Welcome, everybody. I'm Cheryl Milne. I'm the Executive Director of the Asper Center. And welcome everyone to our little symposium, Litigating Equality in Canada. It is our hope and expectation that in addition to the lively discussion we are sure to have today, given the state of equality litigation in Canada, at this moment in time anyway, but I think that's been we've had a rocky history. The paper is being prepared by our really terrific presenters who will form a volume of the Supreme Court Law Review and a separate publication that is a sequel to our popular book, Public Interest Litigation in Canada. So we thank LexisNexis for sponsoring that. I'll begin by acknowledging two things. First, as a symposium focused on equality rights, we have strived imperfectly to represent a diversity of presenters on all of our panels. But for scheduling, work commitments, and last-minute cancellations, we could have done better, but I just want to acknowledge that is something that has been part of our planning. Second, I wish to acknowledge the land upon which we are situate and where the University of Toronto operates. It is the traditional territory of the Huron-Wendat, Seneca, and Mississaugas of the Credit River, and home to many Indigenous peoples from across Turtle Island. I also wish to acknowledge that many of the issues we are talking about today stem from the settler occupation and colonial history of Canada more generally. We owe a debt to people such as Cheyenne Sharma, whose appeal to the Supreme Court of Canada gives us much to debate about substantive equality, and to organizations such as the First Nations Child and Family Caring Society, whose ongoing saga of equality rights litigation shows us how difficult these cases can be, even when they win. In my view, reconciliation requires us to continue to advocate for meaningful substantive equality. I thank my co-chair, Professor Sophia Moreau, for her assistance with our event today. And I want to especially thank Tal Schreier, who has been instrumental in making this work as seamless as possible. Any mistakes are not in terms of the organization, nothing to do with her competence. It's probably something I've done wrong. And I want to turn now to Professor Moreau for her remarks before I give some brief housekeeping comments.
Thank you, Cheryl. I just want to start by saying what an honor and a privilege it is to be in the room together with all of you. Many of you have played such a pivotal role in equality rights advocacy, in intervening in Section 15 cases, and in the adjudication of them. And Cheryl and I are really thrilled that all of you are here today to share your knowledge with us, and we look forward to all of the panels and to our collective discussions. Well, it has been 34 years since the Supreme Court wrote its first judgment concerning Section 15 in the case of Andrews and the Law Society of Upper Canada. And that was a judgment that gave many people hope and seemed to move us away from our previous restrictive interpretations of equality toward a broader one that had the potential, at least, to help the court expose instances of unfair discrimination and marginalization. One might have thought that after all this time, although there would be some ups and downs, we would have achieved some consensus and some clarity on the proper understanding of equality, on, for instance, the difference between claims of discrimination in a charter context and in the context of statutory human rights codes. One might have hoped that courts would have by now converged upon a test for violations of Section 15 that didn't pose unfair barriers to the marginalized social groups that need to use it. But unfortunately, we haven't. Now, I work in a cognate field, so I feel like I'm a bit of an interloper in this conference. I work mostly in discrimination theory, which involves philosophers and legal scholars whose job it is to disagree with each other and to come up with highly nuanced accounts that are always in tension with each other. And it seems to me that although this is the job of philosophers, it seems to be the state of our legal judgments when it really shouldn't be. Obviously, the aim of Section 15 isn't theoretical, it's practical. It ought to be to successfully protect marginalized social groups who face systemic social subordination. And unfortunately, increasingly, it has seemed unable to do that. As you all know, recent Supreme Court of Canada decisions, such as Sharma and the dissenting opinions in cases like Fraser, suggest that we have backtracked and lost some, if not all, of the hard-won gains that were made in earlier years. Cheryl's idea was to bring you all here today to share some thoughts and strategies about our current situation, to talk about things like barriers to litigants, difficulties faced by judges, problems with Section 15, and ways forward, and perhaps ways forward through other means, through other sections of the Charter that might either elucidate Section 15 or be used on their own, like Section 7. And I know one of the questions we'll be discussing will be whether perhaps, sadly, it's time to give up on Section 15 and try to look elsewhere for some legal provisions that can do the work that Section 15 seems sadly not to have been able to do. But that seems like I'm ending my remarks on a pessimistic note, but I am actually full of faith that with all of you and your wonderful suggestions today, we'll come up with some ways forward, both with respect to litigation and with respect to adjudication. So thank you again, and I really look forward to our discussions today.
Now, just for some housekeeping, the full agenda is available on the events page and here. So there's a QR code and link. So if you want to access the agenda for today, we're trying to go as paperless as possible. We are moving around a bit today. We're in this room until lunch, and lunch will be upstairs in the atrium. I think the agenda says the round room, but we moved it because they're painting that room and we don't want to be disturbing that. So it'll be in the atrium, which is just the main area upstairs. Be mindful, there are it's boxed lunches, but be mindful that there are some special meals with names on them. So please don't take those unless it's your name on the box. And our afternoon session will be in P120, which is on the same level as this room, but it's down and you turn left down that hall and it's on the right-hand side, and we'll have people to guide you if you don't know where that is. For our virtual attendees, and this is my first attempt at a fully hybrid event, and so I want to welcome the people who are here virtually through Zoom. You see some of their names up at the top there. I think that will off this. There we go. We are, because we are moving venues just for our virtual attendees, you will have to at lunchtime log out and then log back in at the end of the lunch break, because we are going to log out the webinar and then log in again at that time. So you can go off and have your own lunch and then come back and log in. So I think that's all I need to say in terms of housekeeping, and Cal's not signaling me to say anything else. So I want to turn it over now to Kat Owens from LEAF, who will introduce our first panel to get things started on just a non-controversial issue, which is the role of interveners in all of these cases. So take it away, Kat. Thank you.
Thanks so much, Cheryl. Is everyone able to hear me okay? Brilliant. So yeah, thank you, Cheryl, and thank you to everyone involved in hosting this conference. We're really excited to be here this morning for a panel on the role of interveners in equality rights litigation. I'm very privileged to be joined by 4 excellent human beings, litigants, equality advocates, 3 here in person, and Raji joining us virtually. I won't read you their full bios. You can find them in the agenda, but I'll give you just a quick overview. So for folks who don't know everyone here, you can have a flavor of who will be speaking. So Pam Rick is the Executive Director and General Counsel of the Women's Legal Education and Action Fund, or LEAF, and also my boss. LEAF is a national charitable organization that works towards ensuring the law guarantees substantive equality for women, girls, trans, and non-binary people. Raji Nangat, who's joining us on the screen, is the Executive Director of West Coast LEAF. West Coast Leaf envisions an equal and just society for all women and people who experience gender-based discrimination. In collaboration with the community, they use litigation, law reform, and public legal education to make change. Adriel Weaver is a public law litigator at Goldblatt Partners LLP. Her clients include criminal accused, prisoners, immigration detainees, constitutional and human rights claimants, and community and public interest organizations. And last but certainly not least, Jessica Orkin is a partner at Goldblatt Partners LLP. She has a broad litigation practice, including criminal, civil, and administrative law matters, with an emphasis on constitutional and human rights, as well as Aboriginal rights and access to information law matters. So as Cheryl mentioned, our panel this morning is going to focus on the role of interveners in equality rights litigation. We're going to cover 4 main topics in the more scheduled portion of our remarks, which include the landscape for getting leave to intervene, what intervention strategies look like in a crowded field, the approach to evidence in interventions, and the impact of equality rights interventions. And then we'll try to leave about 15 minutes at the end for a Q&A. So please make sure to note down either on paper or in your brain any questions you have for our panelists. So I'll kick things off then, talking about the current landscape for equality rights interveners. So by way of context, as I'm sure most people in this room will have seen, the Supreme Court of Canada's recent decision in McGregor featured some pretty strong language in relation to interveners, with the majority accusing some of, quote, going beyond their proper role and asking the court to decide an issue not before them. Justice Rowe, in fact, went out of his way to write an entire concurrence focused on the place of interveners at the Supreme Court of Canada and the consequences of improper interventions. So my question for the panel to get us started today is, in your experience, what is the current climate like for equality interveners seeking leave to intervene before different courts in Canada? And maybe Raji, do you wanna kick us off?
Sure. Thanks, Kat. Can you hear me okay?
Yes.
Okay, great. I didn't realize that I would be like a giant face on a screen. It's a little disconcerting. But yeah, this is something that we've been wrestling with a lot here in BC, where our track record before the BC Court of Appeal hasn't been the greatest as of late. You know, we've had a couple of different cases where I guess Section 15 wasn't directly invoked, but our perspective was to bring a substantive equality lens to the issues before the court. And we were unsuccessful in getting leave to intervene. And one of the cases is the Galloway defamation claim. As I'm sure many of you know, Galloway, writer, professor at UBC, and he brought a defamation claim against somebody named AB, and then a whole bunch of other people who were supporters of her around allegations she'd made of sexual assault. And so we'd hoped to intervene in that case because there was going to be an application of the Protection of Public Participation Act, which is kind of the anti-SLAPP provision that allows for cases that are limiting public participation to be taken out at an early stage before they go through the full trial. And so our submissions were deemed at that point not to be sufficiently distinct from those of the parties. And it seemed to matter that there were a lot of parties. So definitely that feeling, I know we're going to talk about it later, but the crowded field seems to not just be crowded with interveners, it seems to be crowded. And that was something that was definitely did not bode well for us. And, you know, it was sort of like, we don't need you. We've got a whole bunch of people here. This is just going to make everything longer. And you're not going to say much that's different from what we think the other people here are going to say. And that we had that experience like at a couple of, like at the BC Supreme Court and at the BC Court of Appeal with that case in particular. And then in another case, we had a challenge we couldn't have possibly anticipated, which is that somehow the fact that BC now has an office of a human rights commissioner would mean that we wouldn't need more than one intervener in cases where the BC Human Rights Code is being interpreted. And that was a case called Harvey and Gibraltar. And, you know, we had sought to intervene jointly with a disability rights organization. And again, the court, the BC Court of Appeal there said, you know, one intervener is plenty. Oh, sorry, that was, I think that was actually at both levels, at the judicial review of the Human Rights Tribunal decision and at the Court of Appeal. It was kind of like we've got the commissioner here. We don't necessarily need you, West Coast Leave, and that this is kind of, you know, not really something that like you're going to basically be saying the same thing. So we prefer the commissioner who's this sort of officer of the legislature. So it's definitely been a rough ride. At the Federal Court of Appeal, where we tried to intervene at the hearing of the both at the federal court and at the Federal Court of Appeal, we tried to intervene in the Safe Third Country Agreement litigation, and there too we were, all three interveners at the federal court were told that, you know, there's already three public interest standing litigants here. You know, our interveners really going to be doing much? You know, are you going to be providing anything different, like helpful? And then there was also this kind of element of fairness to the respondent, and like kind of a sense that the public interest standing test and the test for interveners to meet has some similarity, and some of the factors are, you know, overlapping. And so there was a case where there were, along with individuals, three public interest organizations. And then we tried to intervene in that case with the Asper Center and LEAF at the Federal Court of Appeal. And we also had a really rough ride there, as did every other intervener. But again, there were, you know, 6 sets of motions to intervene. And there was this real sense of an equality of arms and fairness being tested by the fact that these 6 interveners were seen to be supporting the respondent. And the respondent, again, was these powerful and experienced public interest litigants. So certainly I would say for the last few years, like kind of 2021 on, like we've had a pretty rough ride in BC. And I'm really interested in just hearing about how things have been going in other courts of appeal, because it feels quite random sometimes. And certainly there's things we couldn't possibly have anticipated would ironically mean we don't need to be there, like the fact of having an office of a human rights commissioner. I'll leave it there.
Thanks, Raji. And I would encourage folks on the panel, I'm happy to call on people, but we can also make it more conversational. So feel free to jump in. And now I'll say that. So I'll call on one of you.
I think we all can identify the principles. They're not complicated principles to state in the abstract. You have to raise a new perspective. You can't raise a new issue. So, you know, where that line is begins to be the difficulty. So we can talk about, you know, that there are principles of the guardrails of what interveners are supposed to do or permitted to do. And I think it's also pretty clear that there are some courts that are open to interventions, more interested in hearing interveners, more willing to have an unruly courtroom as interveners are viewed by other courts. So we put the federal court in the category of really don't want interveners almost ever. And I think we had viewed the Supreme Court as a court that generally wanted interveners. And that's now, I think, something of a shift that we've seen. And I think what's interesting in McGregor and also in Sharma, in relation to the intervener question, is the fact that the bench is so clearly split on the very same set of facts in front of them. So Justice Rowe and McGregor is outraged at the behavior of the interveners in front of him, and two justices at the other wing of the bench think it's entirely appropriate, and reading between the lines, quite would have liked to have ruled on the point if their colleagues had not been so seriously opposed to doing so. And so the same behavior by an intervener can provoke that wide range of responses. And so I think as interveners, we need to have thick skins. I don't know that it's possible to know whether what you're doing is going to be viewed as appropriate or so beyond the pale that maybe you should never show up again. And a lot depends on which jurist you draw. And even on your leave motion. And even if you draw the jurist who lets you in, it isn't a guarantee that the panel that hears you won't then say what you did was completely inappropriate, even though that's what you said you were going to do when you were granted leave to intervene. Sorry, my iPad is not cooperating. This is the moments where having decided to go paperless is a bad choice. So we had, Adriel and I are arguing a case called Dorsey on Monday. We don't yet know who our panel will be at the Court of Appeal. And this isn't an equality case per se. It's a case that has significant equality implications. It has to do with the question of the availability of habeas corpus for refusals of downward transfer decisions in the prison context. So habeas corpus is available when you are involuntarily transferred upwards, from medium to maximum, from minimum to medium. Prevailing case law says that it is not a deprivation of liberty when you are refused to transfer downwards from medium to minimum. And we never look at the nature of the decision. It's just not a deprivation of liberty because you've never experienced a state of greater liberty. Therefore, it's a case that the Asper Center, obviously constitutional litigator invested last fall, and the Asper Center. So we are arguing it on Monday, and there were 4 intervention applications at the Court of Appeal. And Justice Sawson was our case management judge, and all 4 interveners were granted status. 2 of them are making arguments that are, I forgot to look at my times. Please wait. 2 of them were making arguments that are very much equality based, not raising Section 15 on its own, because that would be a no-no, but raising a perspective about equality implications for this is the Black Legal Action Center and the Elizabeth Fry Society. So raising the equality implications for the communities that they represent. And quite predictably, the Crown opposed those interventions on the basis that it was raising the issue, that there was not evidence in the record, that this was going beyond a new perspective to raising a matter that they had not been given notice of, and they would respond to it, all of the usual tropes. And Justice Sawson said in granting the leave interventions, the reference to constitutional values in the interpretation and application of statutory criteria does not transform this appeal into a charter case. And raising charter values as part of the backdrop against which habeas corpus rules must be applied is not the same as challenging the application of those rules under the charter. So he let those parties in. A different judge would have said that what they were doing was so beyond the pale that they should never attempt to do it. And I think we kind of need to wait for this to ride out, but also continue to push to intervene regardless. Because when the outcome, it seems to me, is so divided that the 9 jurists who are our apex court, whenever they've talked about this, are completely opposed in perspective as to what is appropriate or what is not. I don't see guiding principles that allow me to say this is okay or this is not. It is obviously not okay to put forward an affidavit that you are relying on as an intervener on it. We can all agree with that number. But as we will talk about in a bit, what happens when you refer to really incontrovertible Statistics Canada evidence about the fact that Indigenous people are overrepresented. That's the nature of the evidence that really split, and that Justice Rowe and Justice Brown and Sharma were saying leave in our breaking of the evidence rules for Section 15 interventions. That's the nature of the evidence that we would put in on the house. And so I'm not going to say we shouldn't keep doing this, because I think depending on whether, and it's not a great place to land, but depending on whether you draw Justice Sawson, Justice Martin, someone else in your leave intervention, it may be a completely different outcome. And I think we still have to keep trying.
Beyond it feeling like a crapshoot sometimes, depending on who you draw as a judge at the Supreme Court deciding your leave intervention, I think this entire conversation in the current context should be situated in a larger trend over the last, say, 10 years or so. Folks may remember before 2017, interveners got 10 minutes at the Supreme Court oral argument, 20 pages of written submissions, and as a general rule. And then 2017 rolls along, and the Supreme Court says in a notice to the profession, you all get 5 minutes in oral argument as a general rule, which can be deviated from the course, but we all get 5 minutes to make our maybe 1 point on our intervention these days, and we get 10 pages of written submissions as well. Following that, we see the 2021 November notice to the profession, which says sets out the guidelines that interveners are supposed to pay attention to in the scope of their interventions, trying to remind people of what the appropriate role of the intervener is in their view. Over the course of the pandemic as well, we saw, and I don't know how much of this was sort of broader knowledge, but we were limited as interveners to one counsel appearing for the intervener in the early days of the pandemic, and a number of organizations collectively wrote to the court to say this is an issue. Junior counsel are not getting recognized on decisions. We would like you to revisit this, and eventually they did. The next year, which is last year, another letter goes to say, you're requiring all of us to appear virtually, regardless of whether anybody wants to attend in person, while you're allowing parties to continue to attend in person at this point. So it feels like in that context, I said all that out because it feels like the role and the ability to adequately intervene for us is being challenged over a period of time, where our ability to do that is really being limited and focused. And then on top of that, you add to the crapshoot element of maybe you'll get in, maybe you won't get in. And it feels like a little bit of an inhospitable environment at the Supreme Court these days, except when it's not, and you get 15 to 20 interveners in on a specific case. And I know we're going to talk about that soon as well. But I just wanted to highlight 2 cases quickly that were slightly perplexing to me. One was the Supreme Court's hearing of the appeal in the STCA constitutional challenge, where I think we had 12 organizations or joint interventions that were granted at the Supreme Court. 9 of them were permitted oral argument, 3 were not, and then an additional 3 interveners, namely the Canadian Bar Association, HIV/AIDS Legal Clinic, and joint intervention from the Canadian Lawyers for International Human Rights and the Canadian Centre for the Victims of Torture. They were denied leave to intervene entirely. Those 3 were allowed to present oral argument. Those 3 were allowed to present oral argument. 3 that weren't allowed to intervene at all were the CBA, SALCO, and a coalition of the Roy Mercury Legal Clinic. Basically, so we had some equality seeking organizations that were denied leave to intervene entirely, and some that were limited in their right to intervene even beyond the hypothetical 5 minutes that they were supposed to get. So there's obviously no reasons that are given. The only thing that we have is a statement that's sort of tacked onto a lot of these interventions that say that you have to focus on your submissions on those that are different from the parties and each other. You don't get to raise new issues, and that's the guidance that you get when you are granted leave to intervene. And then the second case, just to highlight from last year as well, is a case called F&N, which had to do with the interpretation of Section 23 of the Children's Law Reform Act here in Ontario, basically a jurisdictional issue, whether the Ontario court could or should claim jurisdiction in a custody and access dispute where the mother had brought the children to Ontario from a foreign jurisdiction and wanted the custody and access order in the Ontario courts. And the court declined to exercise jurisdiction ultimately. But there were 3 non-government interveners that sought leave: the Schleifer Clinic, the Canadian Council of Muslim Women, and Defense for Children International. The Schleifer Clinic, which everyone I think here knows, is a frequent flyer at the Supreme Court and provides many very useful and helpful interventions, was denied leave to intervene. And again, no reasons for that. And we're left to sort of speculate based on the intervention of the CCMW, which did raise some Section 15 and Section 28 considerations in interpreting Section 23 of the legislation at issue and raise the importance of substantive gender equality. I'm left thinking or inferring perhaps the court thought that maybe there was too much of an overlap between those 2 potential interventions. But again, we're not left with any explanation from the court, of course, which feels frustrating. So the note I'll end on is that within this sort of environment, it really leaves me in my role as EDGC of LEAF, trying to be very careful and tailored about our interventions, coordinating with other organizations to make sure that we're not overlapping and to make sure that we are, to the greatest extent possible, quite frankly, following those 2021 November guidelines from the court to sort of make the best case that we can, and the rest is up to the judge that decides the leave interventions.
Yes, I mean, you've said crapshoot. I think there's a catch-22 in many of these instances. Raji, you've touched on some of these. Jess, you have 2. On the one hand, you have to make useful and different submissions. On the other, you can't introduce new issues. So that's a needle to be threaded. Raji spoke about the court saying, well, this is a piece of public interest litigation. We have a public interest litigant as a party here. What really are interveners going to add? On the flip side, I have seen the response that this is really just a private dispute between parties. And by seeking leave to intervene, you are translating that or transmogrifying that into a much broader public interest thing that is not what is in the parties' contemplation in this litigation. So I think there are real tensions there. And then I think there's another set of really practical challenges that go to the mechanics of how you go about seeking leave. And one of the really interesting things that has developed significantly over the past number of years is increasing interventions at lower levels of court, right? And I'm looking to Pam and Kat because this is something that that LEAF has been doing along with other quality-seeking organizations and frequent flyers, as Pam put it. And there aren't the same clear guidelines about how to go about, when to go about submitting an application for leave to intervene. And so one of the other tensions that I have seen, or one of the other catch-22s that would-be interveners are placed in, did play out in the Safe Third Country agreement applications for leave to intervene at the Federal Court and Federal Court of Appeal, where there was no clarity about when those were to be submitted. They were put in prior to the parties finalizing their submissions. And one of the responses from the court was, well, now those can just be incorporated. Why would you need to be there? The parties can pick up these points if they need to. Subsequently, I have seen, well, you submitted these materials too late from the same judge of the same court. So there are all of these tensions. There are all of these very narrow paths that interveners are being required to walk. And then there's the question not just of getting leave, not just whether leave is granted, but on what terms. And I know that it can seem that courts are receptive to interventions when they are granting 20 interveners leave. But on a 10 pages, 5 minutes basis, I'm actually not sure how receptive that is to the substance of those interventions, whether that is really a performative engagement with those. And following on from the TWU controversy, where I think most of you will recall, Justice Wagner got himself, as he then was, got himself into some hot water in granting leave to a number of organizations and interveners there none of whom represented LGBTQ2SI plus interests or organizations. Right? There was a weekend following which there was a different set of leaves being granted. Everyone got in. I think in light of that, there has perhaps been some retreat from, or some lack of interest, lack of desire to weigh different interventions, though I appreciate that is being done in some cases. You just grant it very broadly. It's almost automatic, but on such a limited and circumscribed basis that it is very difficult to actually make use of that. So one of the things that I begin to wonder about is whether we need to be thinking not just about getting through the door, but how we're present there, and about whether we want to be seeking relief on different terms. I frankly would, in many instances, prefer to have 15 pages and no oral argument. I would make that trade. Often you have your 5 minutes, you give this little canned speech, nothing happens. And it's very difficult to feel that that gained any traction or moved the ball down the field in any sort of way. Whereas an extra 5 pages really gives you some scope to properly develop an argument. I do think that there is some interesting work being done because there are no rules at those lower levels of court, and mostly this occurs through case management processes to begin to have these more nuanced conversations about not just whether interventions should happen, but how they might look. And conversations there potentially, I think there's scope for this, about trading off, in effect, pages for oral argument, or having separate sets of oral argument, but a combined factum, right? There are ways to answer questions or concerns about judicial economy, about focus, about non-duplication of effort, but also really give effect to, I think, the animating principles of interventions, which aren't just about the legal issues that are before the court, but that I think really do go to the question of representation in a really broad sense.
Thanks so much. I want to just quickly touch on the point about sort of allocations of pages versus oral arguments. It's interesting. Leaf is going to be intervening in the Bill 124 case before the Ontario Court of Appeal, and we were sort of arbitrarily given 10 pages, 15 minutes, which I think we would have swapped that and taken 15 pages in 10 minutes quite happily. So there is a little bit of, it seems sometimes a random allocation of what's given. But building on the points that have been raised so far in relation to the crowded field, I wanted to give folks the opportunity to talk about what it looks like to engage in advocacy effectively in a crowded field, like in Sharma, which saw 20 interveners, or in JJ and AS that had 16 interveners, or the Bill C-92 reference case with 37 interveners. How do interveners work together? And what's the value of getting involved in cases with such a large number of interveners? Adriel, you started to touch on that as well. And I'm happy for anyone to kick us off. Pam, you want to go first?
Sure. As I get started, you've got this lovely "please stop" sign. And I'm convinced you're going to take back to the office. But I will talk with you. So we do work together. We try to, with our limited resources, those organizations that typically intervene in cases like those that you mentioned in the subject areas that are of common interest to us. That includes organizations like, for us, we collaborate with the Schleifer Clinic, with West Coast Lead. We're in touch with Null. We're in touch with Luke's Place from time to time, and we try to coordinate before going in where we can. And we also try to coordinate in light of our scarce individual resources. So to give a specific example, when Hansman out of the BC Court of Appeal decision was released last week, got leave to go up to the Supreme Court, I emailed Raji immediately to say, are you on the radar? Are you guys going in? You got this? So that we could, at least know between the two of us whether there was going to be that important feminist perspective brought to the litigation in light of our, scarce resources. So we try to collaborate as best we can among organizations to do that. Where multiple organizations want to go in, to give the example of Kirkpatrick, organizations as well as the Schleifer Clinic all intervened, and we got together before the leave applications were submitted to say, all right, who's going to touch on what, so that we can try to make the most of our respective time. We're all granted leave to intervene, make the best case for each of us to be granted leave to intervene and maximize our impact. Because obviously if we're all putting the time and resources into making that application for leave to intervene, we want to be successful. In addition to, okay, yeah, I feel this is good use of the cards. I started with one. No, it's good. So that's the kind of way that we collaborate when we are talking about whether to go into an intervention. And we don't get it perfect every time. I think on occasion we do sort of realize as the intervention applications are coming in, oh, we are both seeking leave to intervene here. And I'll maybe leave it to others on the panel to talk about the kind of collaboration coordination that goes into things once leave decisions have been granted. Adriel, did you want to?
Yeah, I mean, so obviously there's a ton of coordination that happens and extensive conversations. In terms of the question, Kat, that you posed, what's the value of being part of a crowded field, especially a field crowded with various equality seeking intervener organizations? I think one of the things that has really shifted since the Andrews decision, those many years ago, was that there is a much more nuanced and intersectional understanding of equality rights today than previously. And that is not a concept that necessarily lands with the court. In fact, I think in that SDCA hearing, I observed, I have not gone back and watched the recording, but on the webcast, I believe I observed a literal judicial eye roll when the term intersectionality was used. It can be a difficult thing to litigate. It can be a difficult thing to explain. And I think many of the interveners there were trying to do that work of saying a substantive equality rights analysis has to be much more nuanced, much more flexible, and informed by a much broader range of perspectives. One of the things that I think is very helpful about having a crowded field is that there is that broader range of perspectives. So we're not simply talking about the feminist perspective on this or how this will impact women, for example. There is an opportunity to demonstrate, right, to represent that diversity and intersectionality of voices and impacts in a different way than would be possible if there were just one equality organization there. So I think that that is one of the ways in which the work that interveners do together and the jurisprudential understanding and advancement of Section 15 analysis really can go hand in hand quite effectively, so long as there is that coordination. And I think that understanding, that shared understanding of what it is that's sought to be advanced through those conventions. I believe it there. Look at that.
Give me a minute back.
Thank
You, because I have seriously lost some of it. I've gotten too interested in what you can say. Jessica or Raji, do either one of you want to chime in on this point?
I can jump in quickly and just speak about, I mean, everything that's been shared absolutely is the way that we like to do work. We also look for opportunities to intervene jointly with organizations as well. And we've done that many times now with LEAF and with the Asper Center in the Safe Third Country challenge at the SCC. And we tried at the Federal Court of Appeal. And I think that's another way in which sometimes we can provide some of that, like bring together perspectives that will hopefully help for the court to see this sort of intersectional dimensions. Like in that case I mentioned earlier, Harvey and Gibraltar, that we didn't get leave in at the BC Court of Appeal, we tried to intervene with a disability rights organization there to provide kind of like, it was about family status discrimination under the BC Human Rights Code, and just really kind of like trying to kind of tease out some of the nuances that exist where there may be caregiving responsibilities for someone who is disabled, and like trying to kind of identify that intersectional approach. And I just wanted to add that into the mix. Trying to go in with other organizations as we've been successful, but we've also been not successful. And it sort of has felt a little bit of a crapshoot.
I think one of the things to think about crowded fields is whether organizations with limited resources might look perhaps to intervene at lower levels on particular cases. So rather than devoting resources to joining a very crowded field when it reaches the Supreme Court, perhaps being the sole intervener on a case at a lower level. It's a lot more to intervene at the lower levels. But you also can actually get the right to add evidence to the record. And then when it reaches the Supreme Court, it does. There won't be the argument that the statistics that are needed to make an equality argument on the record. For that argument to be made. But it is a very different exercise for organizations with limited resources. Their counsel generally want to participate at. But it does have that possibility of transforming a case in a way that has fewer participants. Asper Center intervened in the Division's Child Welfare Litigation references, where there were 37 interviews, which I think I haven't gone to check, but I think that is a record. It's not that everybody got in. There were some who were refused, but generally that was for intervention applications, which went well outside the guardrail of the intent to supplement the record, or were quite late. But still 37 was the number that got in. And that meant that there had been 5 interveners on top of that who had participated, and who had the right to supplement the record. So that meant that the second day was a parade of 5 minutes. Very few of us got questions. I got a question, and Justice Brown took stuck out my elbows and got 8 minutes in the end, but I don't know that kind of exercise of being in a parade of 21 people, 21 5-minute increments, lends much opportunity to make a difference. I have never, in presenting 5 minutes at the Supreme Court, used any of the points that I have written. And sometimes I manage, when I get asked a question, to go back to something I had scribbled down, because that's the top of the head. But generally, I have something written down, and then I jettison it and try to answer a question, try to respond to something. I wouldn't say that I would give up the 5 minutes entirely. Maybe a trade-off for another 5 days. I do think the court should consider making determinations about oral argument after they receive the fact, and perhaps deciding this is the amount of time we have for our interveners, and we're going to look at who has made an argument that is different, who we might wish to hear from in amongst these, and dividing up the time that way, rather than the decision that's made at the review stage, where everyone gets 5 minutes, or sometimes it seems that some set 5 minutes. On the, if there is only this amount of time for interveners, maybe it's better to divide it up in a way that the court wants to. Oh, that would be fun.
Okay.
So I wanted to move on to our third topic, which has come up again a few times in our conversations, and that's about the approach to evidence in Section 50 cases. And so Jessica and Adriel, this is really drawing on the paper that you're going to be putting together. So what are your key takeaways from the majority decision in Sharma with respect to how evidence is going to be treated in these types of cases moving forward?
We're really sorry done. So Sharma, just tell the story of what we see in Sharma. Leaf and the Asper Center jointly intervened in Sharma at the Court of Appeal. And there was evidence about Indigenous overrepresentation in the criminal justice system in the record. It wasn't that we were adding to a record that didn't have any evidence on the key issue. But we put in some additional evidence about particular impacts on women, overrepresentation of women Indigenous inmates in the criminal justice system and amongst accused, and references to such controversial things as the Royal Commission and on Aboriginal peoples and the missing and murdered women's final report. And some Statistics Canada updates of statistics that were actually already in the record, but taken a few years, and so we updated them to show that the dismal trend was more dismal, or rather this way, percentages of Indigenous people in the justice system. And the majority decision in the Court of Appeal relied expressly on some of that additional evidence. And so go up to the Supreme Court. Actually, before I get to that, there were then at least one decision of the Court of Appeal on other interventions, a case called Hudson, which relied expressly on what happened at Sharma. And Hudson was a case about the interpretation of drug import provision. And one of the interveners is the Criminal Lawyers Association was seeking to talk about how a particular interpretation, the interpretation advanced by the Crown, would have a disproportionate impact on racialized communities. And they put in some statistics to substantiate the position that racialized communities are overrepresented in drug offense charges. And so that this interpretation, which would have a disproportionate impact. Justice Fairburn, who heard the challenge for the objection and decision on those lead intervention motion, referred to Sharma and said this is uncontroversial evidence. Even though it is supplementing the record, it is uncontroversial. And this is an appropriate goal for intervener. Which looks like a small crack opportunity for interventions in this way. And then at the Supreme Court, the majority said, we note here in passing our serious concern with interveners supplementing the record at the appellate level. As stated in Morgentaler, the purpose of an intervention is to present the court with submissions that are useful and different from the perspective of the non-party who has a special interest or particular expertise in the subject matter of the appeal. Interveners must, however, accept the record as defined by the parties in the first instance. Interveners creating a new evidentiary record at the appellate level undermines the trial process. That is not how our system of justice, including constitutional adjudication, is designed to work. Now, the dissent said that the majority's approach was diminishing the role of interveners, critiquing their use of social science and other legislative fact evidence that the court has regularly relied on. I don't feel that what the evidence that we put in was going over the guardrails as I understand, in terms of the kinds of uncontroversial information that courts regularly rely on, in fact, have relied on when they find it themselves without even having a party put forward before them. And so that's judicial notice. But it has provoked a strong response. And these paragraphs obviously are trotted out by government lawyers on every intervention by any intervener, that anything that they are seeking to rely on goes too far. And yeah, it's, when we got the judgment of the Supreme Court, April and I went back to look at the evidence that we had filed, thinking like, what did we do? How did we provoke this response in the evidence? Because it really is a response that looks like what we had put in, which they don't refer to, was something, a new affidavit that then got relied on by the appeal accident.
Yeah, not just to defend ourselves very, but, I mean, when.
No, it's the perplexity of it, as well as the feeling of guilt. But
I mean, when Jessica says we put in new evidence, I want to be very clear, we included things in the Book of Authorities as secondary sources that courts routinely rely on and simply list as among the sources. And part of what we are seeing happen practically are all of these absurd distinctions arising. So once another court has relied on a royal commission on Aboriginal people's statement, you can then rely on that piece of jurisprudence as accepting the point, right? I mean, it is a very strange circumstance in which people now find themselves, where you can say, well, you know, the Ontario Court of Appeal in Morris makes all of these observations about anti-Black racism in the criminal justice system, relying on various things. I can't rely on those things directly, but I can go to that decision. I don't think that that is a principled distinction to be drawing or to be relying on. The other point that I would make about the nature of this evidence specifically is that these are things of which the Supreme Court has repeatedly said judges can and indeed must be taking judicial notice. And we're talking about sentencing and the application of voir dire. You are not meant to have to prove colonialism over and over again, right? The Supreme Court has expressly said these are matters of which judicial notice can and should be taken. They talk about the history of colonialism. I don't think it's a huge stretch to understand that as the ongoing history of colonialism. This is the world in which we continue to live. And that is all that this evidence described, right? It was the ongoing history of colonialism and its manifestations in particular ways in the criminal and carceral systems. Things that, you know, as Jessica says, are entirely uncontroversial in the sense that they exist, obviously deeply controversial in terms of why they exist and what ought to be done about them, but not matters that have ever been in dispute in terms of the court looking at these and saying, is this or is this not happening? So from a practical perspective, I think understanding what those guardrails look like, where they are, has become much more challenging, because these were things that historically, I think many people would have said, this is like a law review article. This just goes in your book. It's a government report. It's not something that you need to prove. In terms of those meaningless distinctions, I suppose now litigants who think that they're maybe interveners down the road, or who understand that this is a Section 15 case or one with substantive equality implications, might be well advised to have a legal assistant, put in an affidavit, attaching as exhibits all of these government reports, right? They're not controversial in terms of what they are or the evidence relied on, their credibility, anything like that. But do they simply need to be in the record? Do you want now always to be putting together a record that includes every conceivable correctional investigator report, Statistics Canada? I mean, these are the directions in which I feel not only interveners, but litigants are increasingly driven by these decisions. So I think it's important to push back on the characterization of this as additional evidence specifically. I mean, obviously, these are facts that are being relied on, but it's not evidence in the understanding that we have of that as something that has to be proven in certain ways, has to be introduced in certain ways. So I do think that there is work that needs to be done there in terms of the understanding of the categories, and ideally some reconstitution of those categories.
I'll just quickly add two things. One, you also get in this sort of same 3-month period, Kirkpatrick, which relies on all of the things that you just described in terms of stuff that would have been put into books of authorities. And then second, I just want to be very clear, we're very pleased with our representation.
Adriel, you and Jessica shouldn't feel bad. We just had the same thing happen to us at the BC Court of Appeal in a case involving overrepresentation of Indigenous kids in care, where, you know, some of these things that you think, like you've mentioned, like missing and murdered Indigenous women and girls inquiry, like so many reports that have been done on the systemic problems with overrepresentation of Indigenous kids in care. Like all of these things were perceived to be these sort of like improperly bringing in these systemic factors. And we'd intervened at the JR of this, like we'd intervened at the BC Supreme Court and got intervener status at the BC Court of Appeal, and stayed very tightly to what we'd been granted status on because of this climate. And still the panel that heard the appeal, you know, had to go out of their way to say like, well, you know, West Coast Leaf is making all sorts of factual allegations and trying to supplement the record with references to, you know, commissions and public inquiries. And it's just, I really fail to understand how this province thinks that it's going to implement UNDRIP if you know, saying that there's Indigenous overrepresentation and citing something that, you know, feels fairly authoritative is not, is like beyond the pale. It just, I feel like there's a real tension happening just around some of these systemic realities. Like you said, like, do you have to now like kind of bootstrap like every possible report, inquiry, commission of inquiry, like every report from the representative of children and youth that like highlights this, and have the person who's bringing the case like bring all of that into the record? Is that really what we have to do now? It kind of feels, really disconcerting to me.
Well, so moving from that optimistic topic to our final, maybe optimistic topic, let's talk about impact. So obviously as interveners, we want to see our submissions make an impact, whether that's in the analysis itself or outside of the courtroom if we're thinking about the broader impacts of advocacy. So I'd like to give each of you an opportunity to talk a little bit about how you would assess the impact of recent cases or a recent case that you've been involved in, either as an organization or as counsel, representing an individual or an organization. I'm going to try to say 3 to 4 minutes per person to make sure we have enough time for questions. And I might use the dreaded please stop card, but I'll try not to. So maybe, Jessica, did you want to start us off?
Sure. I don't, you know, it's not predictable in any way when you will possibly have an impact. And defining impact, I think, is open to interpretation. Obviously, we would all love for the court, actually, I was about to say for the court to name that they have relied on you, but you want that only to happen at the apex court. You know? It is nice to see that your submissions have been taken into account and are directly reflected in the judgment, but that is not the only measure of impact. And I think some of the arguments that many of us are making are not going to be reflected in the judgment. They are arguments that hopefully will not attract an eye roll, but even if they do attract a judicial eye roll, they are worth making. Continue to be worth making, because I think it's part of how the discourse that is well understood in this kind of space about the challenges of equality litigation, but about such issues as intersectionality that are not well understood. Just making sure that you have some consciousness raising of the judiciary. And that is not an easy thing to attempt to do from the other side of the bar. And we can't force them to take into account what we present. But I think we can present what they are not hearing over and over again. And it, you know, comes out sometimes in a threat of dissent or in a comment that is not the majority, but hopefully over the long arc of how this works, we will be swinging back. You didn't have to put up a stop sign.
I did it. Thank you for that.
That was a tribute this morning. Rodney, did you want to go next?
Yeah, I talked a little bit already about this TL case that we intervened in at the BC Supreme Court and at the Court of Appeal, the one that I was just talking about, where we got in trouble for kind of using outside the record materials. But what I did, so I won't go back into that. I get a little ranty. But I wanted to talk about something that was flagged earlier, and that's the potential to intervene at lower court in lower court cases. And that's definitely been our experience. Like we haven't done it a ton, but we've intervened a few times where at a BC Human Rights Tribunal and at the BC Supreme Court in the trial of the solitary confinement regime that was brought by the BC Civil Liberties Association and the John Howard Society. And I would say that those did feel like more impactful opportunities, though they were vastly more resource intensive. But in terms of kind of getting a feeling of being there and helping kind of shape some of the context that the decision is going to be made in, and not sort of being accused later of, you know, doing something improper. Those were definitely, I think, points where the impact really felt like we felt it. But I would just, you know, on what Jessica was sharing, like, I think that looking at impact beyond kind of like, did you get name checked? Did your argument make it there, even if you didn't? Even if they don't attribute it, like that sort of becomes like a bit of a textual analysis that like you probably need a PhD in some sort of semantics and whatever to do, which I do not have. But I think that like understanding kind of the community building and the consciousness raising and the representation pieces of what it means to be intervening as an organization, and then how does the work you do in court influence the work you do outside of court. So like, you know, how do the decisions, the refinement of positions within a particular piece of litigation then support you in the law reform efforts that'll inevitably come at you know, if something is struck down and a regime has to be changed.
And I feel like that might be a good segue into your point.
Well, thank you, Pat. To pick up on what Raji was saying, I mean, we can see the impact sometimes going through the decision, and we do get that, you know, we get the name check on some sort of thing that we have said to the court that they've taken interest in a positive way, hopefully. And then sometimes you go through a decision like Colucci and realize you side by side with your fact and with your oral submissions and realize they've done it. They did it. They didn't say, as my son is fond of saying these days, did it. And we can see the impact of the intervention in that way. But moving even beyond the courtroom, I'll give a couple of examples of our interventions leading to advocacy or supporting advocacy outside the courtroom and other arenas and with other collaborators, and then an example of our advocacy and position development on certain issues feeding into our interventions in that way. So the first one is to talk about Sharma, our intervention in Sharma, not just at the Court of Appeal, but then often the Supreme Court as well. Some people will remember there was a period of time where that appeal was effectively held in abeyance at the Supreme Court while they were sort of figuring out what was going on with some legislation that was moving through Parliament. And during that period of time, we took the opportunity, and I'll really say Kat took the lead on taking the opportunity to work with the Black Legal Action Centre and the Canadian Association of Elizabeth Fry Societies to further strengthen our relationship there and develop a law reform submission to committee on Bill C5 that eventually moved its way through Parliament and was given royal assent after the Sharma decision, rendering it effectively moot. But having that opportunity, the skill set that we were building, the expertise that we were building by participating in that intervention, being able to use that to influence decision making in another arena that would effectively achieve the same objective that we were really getting at by participating in Sharma, that I think is an indicator of success in our intervention ultimately as well. So really, we try to approach the work that we do not just from that narrow lens of did the intervention have effect in that particular case, but how has our work more broadly been able to achieve the ends that we're trying to achieve in that particular intervention itself. On the flip side of things, recently an advocacy project that was led by Roselle Kim, who is one of our colleagues here in the audience today, was to develop an advocacy position on the criminalization of sex work. And over the period of about a part of a year, that work was led internally at LEAP. We developed our first position on the criminalization of sex work, which was in opposition to the criminalization of sex work. And at the same time, the Canadian Alliance of Sex Work Law Reform constitutional challenge to those laws in the criminal code was moving into the Superior Court. And the timing was such that we were able to build on the advocacy position that Roselle led the development of and the relationships that we had established in that process to seek leave to intervene and receive leave to intervene in that constitutional challenge in the Superior Court. So as a package deal, I think that the advocacy that we did and the way in which we were able to parlay that into an intervention had a real impact for us outside of the courtroom in those relationships that we built, in the advocacy that we were able to do, the public education that we were able to tag onto that as well. And we did a webinar as part of that. I see it. And I think sort of looking at our work in that broader lens allows me at least to see the value in the work that we're doing and to assess it in that broader kind of landscape as well.
You had talked about this as the optimistic close to the panel, and I confess when I got the questions, I was thinking of this as the existential angst portion of today's proceedings.
We all have different definitions of optimism.
Yeah. How do you matter? Do you matter? What work that you do? But this is making me feel optimistic because it is a reminder, of course, that litigating equality, the litigation piece of that is one tool. And I think used thoughtfully and with an awareness of those other sets of tools and the other options that are available is going to be that much more effective. So it's always helpful to be reminded of that. I think there are definitely places where I have seen in a judgment that arguments that we have made, submissions we have made have been taken up, have had some impact. Jessica and I intervened in a case called Tunaha or the BCCLA, and there is a concurring judgment, concurring in the result, dissenting with respect to the Section 2 analysis by Justice Moldaver. And we too, these are the self-soothing things that I do at 4:00 in the morning when I'm thinking, what is the point of it? You can lay the two side by side, and I think there are definite resonances there. It does feel like that. Whole sentences. It does feel like that, as I say, had some purchase there, had some impact there. The broader conversation, the broader discourse, how does that get affected by the interventions? It's a much more difficult thing to assess. Kat's done a multi-year project on feminist strategic litigation, and that question is at the heart of that, and I think in some ways sort of unanswerable in the moment where you're located. I think it's something that we can answer much more clearly retrospectively than we are thinking about how does this play out in the day-to-day. So that's another perspective, right? There's the piece that is, how does this fit with other options for law reform, for changing the discourse more generally, and then how might this look with the benefit of hindsight? So I think it's really useful to think about litigating equality in these kinds of fora, both in terms of how do we use litigation in conjunction with those other strategies, and also to take that opportunity to have that sort of retrospective look and analysis. Think, okay, with a broader view, can we see how this has been effective? and then potentially use that to inform how we go about. I don't have an answer to that. I'm just saying it becomes more possible. I mean, it helps.
I would definitely agree that assessing the impact is multiple PhD theses. So I would encourage anyone who's interested in pursuing a PhD to look at that type of question. I think we are at time. I want to thank the panelists so much for that really interesting conversation. I know I've frantically been scribbling notes and have a lot to reflect on, but so thank you. I'm very excited for the rest of the day.
Get started. Welcome, everyone. I'm Kim Stanton. I'll be moderating the next panel. I want to acknowledge that we're meeting on the territory of the Haudenosaunee, Huron-Wendat, and Anishinaabe peoples that have been shared together for so many years, and we're very grateful to be able to have the privilege to meet together on the territory today. And I want to also thank Cheryl Milne for organizing along with Sophie Moreau. But Cheryl's been very patient with Mary and I and our recalcitrant paper writing skills at the moment. And Tal, thanks so much for all of your work organizing. I want to extend an acknowledgement to the folks joining us in DC, who for whom this is an extremely early morning, and anyone else from the West. So Raji being on a panel presumably from DC at 6 a.m. her time, and other folks joining us from DC, much appreciated. This panel is entitled Breaking Through the Barriers. All of these panelists in one way or another have done that themselves, but the focus being the litigation strategies and practical reasons to overcome hurdles faced by equality-seeking claimants, including doctrine, evidentiary burdens, and judicial reluctance issues that Caitlin and Cheryl will speak to in particular. Just first, a brief introduction of our panelists. Caitlin Salvino is a law student at UT. She's going into her third year. She came to UT with DPhil from Oxford. She received the 2022 Governor General's Award for the Person's Case Medal, and the 2023 Clarkson Laureateship for Public Service. She's a junior fellow at Madison College. Cheryl, of course, is the executive director of the Asper Center and a longtime legal advocate for children and youth, including having been at the Justice for Children and Youth Clinic before coming to the Asper Center. And of course, she leads the center's charter litigation interventions. And I was happy to partner with her on some thinking earlier about the question about the treatment of Indigenous interveners. Cheryl and I had a scorching experience in intervening in the cacophonous case where Section 15 was certainly not welcome, and where the only Indigenous counsel who appeared that day was treated with terrible disrespect, in our view, by the court. So it was bracing, and I recall taking the leave students out for lunch during the hearing and saying, "It's not all like this. Really, don't worry, stick with it." Cheryl is a member of NAL's steering committee and the CBA Child and Youth section executive, and she's the recipient of the 2018 Law Society of Ontario Medal for her contribution to the profession. Faye Faraday is an associate prof at Osgoode Hall Law School. She's a labor, human rights, and constitutional lawyer of some renown in equality-seeking circles. Runs Faraday Law. She's litigated many leading human rights and constitutional cases, appearing at the Supreme Court many times, and has published extensively on substantive equality, and of course has been supporting community organizing for many years on for migrant worker rights, equality rights, and racial justice. Mary Eberts needs no introduction for most people. She's, of course, an officer of the Order of Canada and a senior fellow at Massey College. Her legal education from Western and Harvard. She's a co-founder of LEAF. And if we want to think about the impact of interveners before the court, Mary and Gwen Brodsky argued for LEAF in the Andrews case, and were they not there and had LEAF not had the foresight to intervene in that case, we wouldn't have had McIntyre's reasons, and we wouldn't have had the solid basis of Section 15 analysis of substantive equality that we have. Sadly, not as adhered to by the court in any years since then, but it was a high watermark to start with, and we wouldn't have had it without Mary and Gwen's arguments. She's of course appeared in charter cases and other cases before all levels of courts in the country. She's taught here. She's held chairs in human rights at University of Ottawa and University of Saskatchewan, and she was instrumental in achieving the wording of Section 15 itself. So we're delighted to have all of these amazing panelists here today. I'm going to invite Cheryl and Caitlin to start us off, and please go ahead. Thank you so much, Kim. And we're also delighted to be moderated by Kim Stanton in your own right, and I won't embarrass her by going through her bio, but I think you have it as part of the agenda. Her work is also really impressive in this area. So our paper, analyzing the treatment of competing charter claims, judicial restraint in the curious case of Section 15, was motivated by our intervention. And in the case we've already discussed, the Safe Third Country Agreement appeal. And so for those of you who are not aware of what happened with respect to the Section 15 argument, at the application stage at the federal court, the court found that the Safe Third Country Agreement infringed Section 7 of the Charter and struck it down, or struck down the provisions that enforced or put into effect the Safe Third Country Agreement. And when, but Section 15 was also argued, and it was argued from the perspective primarily of women facing domestic violence who were coming across the border, and what was happening to them and their differential treatment in the US as compared to how they would likely have been treated in Canada. And so that was a key part of the argument, and was in fact one of the circumstances of one of the individuals, at least one of the individuals who were part of that case. And so what the federal court did was say, well, we've struck this down on the basis of Section 7. The applicants make these arguments on Section 15. We don't need to rule on that, and cite the decision in part without further reasons. So just, in my view, abdicated the role of the trial court, did not make any evidentiary rulings, and then we ended up with the even harsher ruling at the Federal Court of Appeal. So, and we were denied, along with LEAF and West Coast LEAF, intervention at the Federal Court of Appeal, because it was determined that on the basis of the law related to judicial restraint, that it was settled law, that the judge had the discretion to do what she did, and there's nothing to see here, and essentially quoted the government's arguments as the reasoning. So we did intervene. We did get intervener status at the Supreme Court of Canada, but we also, in doing this, thought that we better take a look and see how often this really happens. Is this an anomaly, or is this something that is a pattern? Because there is this perception that Section 15 is ignored and put aside. So I'm going to turn over to Caitlin to talk about the methodology and found in terms of the review of the cases, and then I'm going to sum it up by what some of our arguments were in the Safe Third Country Agreement.
Great, thank you, Cheryl. So as Cheryl had said, as the Asper Center was going to leave the West Coast LEAF, intervention was really this concern over how lower courts were approaching lower court charter claims, particularly in Section 15. When that intervention was being drafted, there really wasn't anything in the literature analyzing how lower courts treated these multiple charter claims. There were some articles about how the Supreme Court of Canada was treating these claims. And what we tried to do is we tried to look at the actual treatment of multiple charter claims when Section 15 is involved. And so we did two different systematic reviews. One was we started with the Supreme Court of Canada, and we looked at how Section 15 was treated in these cases between 1985, when Section 15 came into force, 33 years later after the charter was entrenched, up until 2022. And then the second systematic review focused on courts of first instance. Specifically, we looked at all the provincial courts, the territorial courts, and the federal court. And we looked at a smaller time period, so we only looked for years in 2012 and 2015. And so beginning with the Supreme Court of Canada treatment of Section 15, we had this set of bilingual search terms that resulted in 310 cases being identified. We then applied these inclusion and exclusion criteria that are on the screen, that I'm not going to go through right now, but it resulted in us having 44 cases that met the inclusion criteria over that period of almost 40 years. And so of these 44 cases that met the inclusion and exclusion criteria, in 29 of them, or 65%, the Supreme Court of Canada ruled on all of them. In 4 of them, the Supreme Court of Canada resolved the case on non-charter grounds. In 4 other of them, the Supreme Court of Canada looked at all of the charter infringements and then chose or found one unjustified infringement. And then in the remaining 7, or about 16%, the Supreme Court of Canada only ruled on one of the charter infringements. And so among these remaining 7, this is where we examined how Section 15 is treated. And of these 7, in 6 of the 7 cases, the Supreme Court of Canada declined to rule on Section 15, choosing to rule on another charter ground. And the only case where the Supreme Court of Canada chose to rule on Section 15 was Ontario NG, which related to mental disability. And so, at least at the Supreme Court of Canada level, when the Supreme Court of Canada ruled on multiple or makes finding on only one charter claim and declines to rule on others, there is this seeming aversion to doing so. So then we turn to courts of first instance, where based on the search terms that we've used previously, it resulted in almost 2,600 cases being identified. We applied inclusion and exclusion criteria again, and it resulted in 99 cases that met all of the criteria that we would then review. So then of these 99 cases, in a surprising number of them, the courts of first instance rule on all. So I think in 81 of them, the courts of first instance consider all of the charter claims and then make findings. In another 9, the decisions were resolved on other non-charter grounds. And then in the final 9, we saw courts of first instance ruling on one of the charter grounds and then refusing to rule on the others and make finding facts. And again, when we looked at those remaining 9 cases, we did see again this aversion to Section 15, where out of the 9, 6 of the cases chose to decline to rule on Section 15 and instead rule on another charter ground. And so I think based on the results, we were surprised just by the number of courts of first instance cases where they were ruling on all the charter grounds, because initially there was this perception that this wasn't happening. But then what there still is, from the Supreme Court of Canada down, when courts choose to only rule on one charter claim, there seems to be this disproportionate decline in ruling on Section 15. So I'll turn it back over to Cheryl.
So I just want to just summarize the arguments that we made in the Sacred Pennsylvania case, contrary to what I think Justice Stratus in his ruling declining to dismissing our application in intervening, where he said that, well, this is all subject law. The trial judge gets to do this. There were some key issues, obviously, when the court fails to rule on legitimate charter claims for which there is an evidentiary basis. So we can understand if there isn't sufficient evidence on one of those claims that they might not rule on it. But if there is an argument, certainly the party's argument with the safety case, there was a sufficient evidentiary base to rule one way or the other, and then put in a very robust record. But the importance is that whether we like it or not, Sharma has reinforced that evidentiary burden on the claimant at the breach stage. So at that very first instance. So if the court fails to make those rulings, then it really does hinder reviewing courts going forward. And it also disregards all of this effort that plaintiffs going to put forward that record. So, while principles of judicial restraint might apply, and we cite Hogg in our arguments for the fact that where there are competing arguments based upon non-charter grounds, for example, if there's a statutory interpretation argument that would give the claimant what they're asking for, the court will decline to rule on the charter grounds, and that makes sense in terms of the boundaries on which the court places themselves in terms of stepping into the legislative role. But if they fail to do so, where they're just charter grounds and there isn't this other non-charter argument, then they are impeding this appellate review, as I mentioned. And first instance courts must fulfill their fact-finding role. So the appellate court's deference to these findings are premised on the trial courts doing their job. And so that was reinforced in both Bedford and Carter, where the court made it really clear that even in applications where the evidence is put forward in document form, in affidavit form, that there is a deference to the findings of fact at the first instance, and that you need to demonstrate a palpable and overriding error to overturn those findings. And so it's really key that those findings be made. But more so doctrinally, the proposed approach to the charter, in our view, really requires, where there are particularly equality rights claims, that there be rulings on those issues, because for a number of reasons. One, that the harm that is occasioned, that where there's a Section 7 and a Section 15 argument, the harms of the breach of Section 15 are different from the harms in the breach of Section 7. And that any kind of remedy needs to address the harms that are occasioned under both sections. Furthermore, if there's a justification for the breach, that justification is going to be different if it's a Section 15 breach versus a Section 7 breach. And so that when you read all of the provisions together, it is important that we know exactly what is happening when there's a claim that it rests on another charter arguments. So that it is, in our argument that it is what is necessary for consistent interpretation. The other thing, and I just want to end on that because I think that I have 1 minute more. Yeah, is just that the court says over and over and over again there is no hierarchy of rights; that all rights are equal. Yet we constantly do feel that's what's happening. And yes, while our analysis shows that it's a minority of cases in which that happens, they are still fairly significant. Alison Latimer wrote an article around analyzing what the court did in Carter, as one example, and that we end up with continuing issues with medical assistance and dying legislation because the court never ruled on the equality rights issues. And that I would argue that some of the continuing problems about the legislation and continuing litigation in that area has to do with the court's reluctance to deal with what is a very controversial issue, because there were minority groups and marginalized groups on either side of that issue, but we never got a ruling. So if you believe in any kind of either legislative dialogue or conversation between the legislature and the courts, where the court doesn't rule on something as significant, especially at the Supreme Court level, as a Section 15 claim, we are losing that piece of the analysis that needs to go forward in responding to, in particular, piece of legislation is been struck down.
Thanks very much. Dave, we'll turn it over to you next.
Morning, everyone, or yeah, I guess it's still morning.
take a slightly different tack on this. I've been litigating charter quality cases for 30 years. And so I think the perspective, and I've been writing about it for that long as well. So I think the perspective that I bring is as someone who's really tired of saying the same thing over and over and over again. So my intervention today is called "This is not a test." I gave it a more muted subtitle than I would have wanted to give it. So I think that this paper will be "This is not a test," rescuing section 15 from irrelevance with the subtitle, "Oh, I love how the elephant ties the room together." So it's not about the legal test. It never has been about the legal test. Can we just start there? This has always been about a fight about power and a vision of privilege and keeping privilege invisible. There is no intellectual coherence to section 15 jurisprudence, and trying to find intellectual coherence in it is a losing game. It's not possible to tie it together without talking about power and without talking about the unspoken ideology that underpins the divides in court. I had been for decades keeping track of how many new tests were introduced and then rapidly rejected. And we've got a new test for section 15, we've got a new test for section 15. Totally overturned that, right? But no case has ever been overturned, right? Just ideas have been brought in to serve their and then rejected very rapidly thereafter. There is no other area of law that operates this way. So let's just start with that one basic truth. It's not about the test. It never has been. There's no coherence in the law. And so what is needed in a very practical sense, and I will write it, I've provided it in numerous cases that I've litigated, is a map to judges to understand there is no coherence. So watch out for all the cases that are being cited that are no law. You cannot cherry pick through the law, but judges need to know when they're being duped by cherry picking sentences out of cases where those elements have been rejected. So that's one start. The second point is that where the real fight is the fact that we live, those of us who are the global majority and those who hold privilege, live in completely different worlds. Our experience of reality is different, and the barrier is an inability to communicate across that, because people with privilege have no experiential capacity to understand what oppression and discrimination are. So every time you go into court, you face well, it's not real, but that's not a real thing. The number of times I've had to actually say, yeah, discrimination, wage discrimination on the basis of sex is, there's like decades of, anyway. But what it means for us as litigators is that every single time that we go into court, what we are doing is we need to actively excavate silenced histories of oppression. We have to actively excavate and overthrow received public truths that erase the reality of the majority of people in our society. And that is a challenging thing, but it is critical to informing how we build our evidence and how we tell our story, and the requirement of incredible patience to walk judges through a shift in their perception of reality so that they can actually believe the evidence. If you The way that our litigation and our discussion of equality operates and our political discourse around equality operates is on the basis of an assumption that the experience of equality is the shared baseline that people have an experience in their real lives of equality, and that what we're bringing to court are aberrations to that norm. That is in fact the opposite of reality. The reality is that the majority in our society have no lived experience of equality, whether it is discrimination based on race, on gender, on migrant status, on disability, you name it. And those experiences of disempowerment are not the operation of isolated laws, but of systems that are knit together. And so every case requires making visible the systems that oppress. Without doing that, Section 15 is a dead letter that will only ever shave off the rough edges of formal inequality. A third reality is that you cannot get to equality using the intellectual lineage of privileged white men from centuries past. And that is what our court cites. There is a phenomenally rich, deep, rigorous intellectual history of equality by Indigenous, Black, and racialized authors that long predates the Charter. That was leading intellectual work at the time the Charter was introduced. That is never cited. And so that theory needs to be brought forward and relied on to make our equality rates relevant for the future. And that is a thing that I look at. I spent the last weekend in BC working with a range of Asian groups on anti-Asian racism, and particularly working with youth whose analysis is miles ahead of our generation, is miles ahead of the analysis of the courts. And the conversations that we are having are remarkably modest compared to the depth of their understanding. So how do we ensure that what we are doing is putting down a foundation that will be relevant to generations that are coming, and by which I mean, people in their 30s who are, or their 20s who are charging into the workforce with a very different understanding of the world and of systemic and structural oppression. We are, and the courts are easily being leapfrogged by that analysis unless they catch up. This is going to, Section 15 will have no utility. So we need to be attentive to that dynamic at the same time as we recognize that we're litigating equality in the midst of a culture war where it's not only about courts being reluctant to hear from interveners, but that there are right-wing intervener groups being astroturfed with significant money from the states who have no constituency other than the ideologues around the table, but who are gaining credibility with the courts. And so we need to, what I urge is that we need to actually speak out loud what is happening instead of politely walking around the rules as if they're actually being applied in a way that is credible and legitimate. I'm deeply heartened that Justice Sheila Martin continues to cite my piece about the intellectual dishonesty of the ping-ponging back and forth and the resurrection of the zombie ideas that have been rejected repeatedly. Call it out for the game that it is. And it's important to then not just call it out, but then put down the anchors that root our analysis going forward in a structural systemic analysis of how the state weaponizes our difference in order to oppress. That is what equality is about. So the final point I would make is that, yes, litigate. I do sound like I'm a charter cynic. I'm actually not. I'm being a pragmatic strategist, which is that you need to know why you're going into court and build the strongest, best case you can, knowing that this is what you're up against, not a test, right? It's all this other stuff. And alongside that, the strongest places for advocacy are outside the court in building a public discourse that recognizes the reality of structural inequality. And I think that I draw enormous optimism from our younger generation, Gen Z, who is growing up in the shadow of existential annihilation, right? You can't think about the climate crisis without understanding that we are all, our futures are inextricably intertwined, and that the things that put us at risk are structural. With that base understanding, we have an incredible future ahead of us, and we have to nurture that. But if our generation doesn't do the work, Section 15 will die as the withered branch that it is.
On that cheering note. So if anyone online is having any difficulty hearing, we've endeavored to move the mic closer and so on, but there's also closed captioning available for those of you online, so just a note on that. And I'll turn it over to Maria.
Thanks very much. Let me begin by apologizing for what are sure to be little bursts of coughing. I'm not contagious. I just have a nasty sinus, and leave it at that. I want to start at the beginning of Section 15, and that is the 3-year delay in its coming into effect. And the assumption behind that the legislature should and indeed would fix all the problems of equality. Well, that didn't happen. And so when Section 15 came into effect, what we have is a whole lot of people who are suffering from various kinds of inequality, trying to use Section 15 in the courts. And that is working against a paradigm that was built right into the charter in the first place, which gave preference to the legislative solution for inequality. And these cases are coming before courts. In many cases, especially who was talking about the federal court, they used to be government bureaucrats, and so they really agree that the courts shouldn't be messing with this. But even if they're not former bureaucrats, here's the way it goes. And I draw most of my examples here from the very long struggle of over 50 years to bring about some elimination of sex discrimination from the Indian Act. And so let me just start with the issue of judicial reluctance. The government of Canada knows very well that there is this essential paradox or ambiguity at the heart of Section 15. And they direct their arguments to that ambiguity in the hope that there will be some judge on, say, an appellate court who will agree with them. And the arguments that they direct to that judge are often ones that are out and out policy arguments. And as we know from studying the history of Canadian or Canada's advocacy in Indian Act cases, there are policy arguments that do not have any truth behind them. One of the best examples of this is the argument by Canada in the McIver case in the BC Court of Appeal, which was accepted by Justice Groverman, himself a pretty conservative guy, but Canada captured him by saying that there's a really serious problem here because individual women's rights are running up against the collective rights in Indigenous peoples. And we can't have a court addressing that. That is something that a legislature should address. And so Groverman, having and considering the wonderful judgment of Justice Ross that looked at the statute and said, oh yeah, well, you know, it's pretty clear that the people who inherit their status through the male line predominate, and those that try to get status through the female line are out. And that was pretty simple. But no, Groverman couldn't go with that because there was this big policy argument that Canada dropped on his plate, and it made him shrink way back, way back. So the judicial reluctance, they may be conservative to begin with, but Canada plays on that big time. And that's one of the things that runs through this whole area of argument. So let me now look at the question of doctrine, which is one of the items on our list. And I agree with Faye that we don't really get anywhere looking at doctrinal differences or confusions or messes in the Section 15 jurisprudence itself. There will be no salvation there. There is no answer there. We have to start looking at doctrine outside of the area of Section 15. And here's an example. Right now, there is a great deal of international human rights sort of thinking and a great number of international human rights instruments. And the doctrine respecting them is that they are not legally binding on Canada. They are persuasive only. And so we have all these wonderful rulings from international human rights bodies using international human rights instruments and they all say that the human rights of Indigenous peoples in Canada have been violated 6 ways to Sunday, constantly, all the time, and it impinges on their right to participate in their culture, speaking of the phony dichotomy that Canada likes to raise. And so a really important thing for us to be doing as lawyers and as scholars and as advocates, activists, is to try to get that doctrine changed so that we can push into the court and into the wasteland of Section 15 equality jurisprudence, this incredibly strong international human rights jurisprudence. Don't worry about Section 15 doctrine. Worry about the doctrine that keeps these other things out of our courts. And now I'm also going to talk about impossible burdens, because yes, it is true that we have things like onus of proof and all that sort of Latinate terminology for burdens. But in the area of Indigenous rights, and especially the attempt by women and their descendants to get status under the Indian Act, what we have are the burdens imposed in a practical way by colonialism that prevents them from making a case. Dr. Lynn Gale had to work for 20 years to put together her family tree because there were no documents relating to when her people were born, when they were married, whether they even existed. And she had to go to church basements. She went all over for 20 years to get her family tree in order. And so the burdens that colonialism and the disregard for Indigenous peoples and families have placed in the path of these people are substantial. And we must address those rather than fiddling around with the onus of proof in a formal court case. So I go on. So what do we do then? What do we do? First of all, I totally agree with Faye. We have to deal with this problem outside of the courtroom. And we deal with it by the kinds of allegiances and partnerships that were being discussed at the previous panel. Advocacy groups and community-based organizations, scholars and critics of what's happening in the courts and what's happening in the legislation and what's happening in other areas of law, all working together. And so within that sort of overall envelope, we can do a couple of things that involve litigation. First of all, we can keep litigating. There have been 50 years of cases dealing with sex discrimination in the Indian Act. And every time there is a court victory, Canada purports to change the law. And it either makes an incomplete change, which leaves an ocean of other things that must be done, or it makes a change that actually creates new problems that are at least as bad and maybe worse than the ones before. And so you just have to keep litigating to beat this stuff back, because Canada is still trying to fulfill its original colonial ambition of making these people disappear. And they do it every day in the courtrooms of the land. And so we also have to keep working with political organizers and working at the international human rights level, because there must be pressure put on Canada to stop doing this before it even gets to the court. So the other thing I want to mention is, just as a sort of the last thing we can do as litigators, and that is, not only do we keep litigating, but we keep escalating. And we can, through our knowledge of what works and what doesn't work in law, keep finding new things to try. And in the area of sex discrimination in the Indian Act, the new thing to try is the class action, because we have seen so many instances where violations of rights and visitations of inequality have started to be repaired by the class actions and the enormous settlements and in those actions, which have led to some reparations. Canada now has a rule in place by legislation that says there can never be any financial reparations for what has happened to women and their descendants by way of discrimination under the Indian Act. So keep escalating. That's certainly something to challenge. And that doesn't, and there are many ways of challenging that don't involve Section 15. Might be there, but there are lots of other ways of doing that. And so, as I say, keep escalating, because this is not going to be dealt with in the tiny little forum of Section 15. A massive problem of inequality, which is not only systemic, but which is the system in which people live, must be dealt with by opposing to it many other systems and what they have to do. Thank you.
Very much. I wonder first if the panelists have any questions or comments they want to pose to one another, having heard what one another has to say, before I open it up further.
My question to Faye is, when are we going to get that paper of yours circulating?
It's coming. But I just have a tag on to what Mary said about escalating. Absolutely. I agree. And I just want to share a thought that one of the youth I was speaking with this week said, which is we were talking about how we're afraid to take up space. And for many of us who are Asian, we have been enculturated not to take up space, right? To be that model minority. And this young person said, look, racism is always going to be with us. Racism is loud and unapologetic. Anti-racism needs to be loud and unapologetic. And so I think, yes, escalate and take up space.
And with that, I'll open it up to members of the audience to take up some space as well and ask some questions or follow up on any of the points that have been made so far.
There's some virtual space that. We have a question from someone in our virtual audience from Anne Clara at McGill Law School. And she's wondering specifically, this question is directed at Faye. If you had any thoughts on how the principles of critical race theory could be integrated into legal strategies and advocacy efforts to influence or shape the interpretation of future Section 15 jurisprudence.
Okay, maybe you can.
The question was, how can critical race theory be integrated into Section 15 litigation? And yeah, absolutely, 100%. It can be. I think that my approach to litigation is one that comes from a critical race anti-oppression perspective. And what is required there is not just drawing on the intellectual lineage of racialized movements, but also to actively deconstruct those received truths that we have about the way the system works. It is really about being able to make that real reality, right? The reality that's been hidden, making it visible before you can actually make the case in court. So that's you have a double burden of actually explaining what your starting line is before you then explain why the particular situation is discriminatory. But I think that our advocacy is not limited to the court. Our advocacy on that must be everywhere around making those systems visible through art, through education, through organizing in any way that we can.
Yeah, it's an important point as well. I think with the Section 15 cases that have gone so far, that gulf between the lived experience of the people who are equality seeking and the members of the court is visible in every hearing in one way or another. And the need for litigators to be able to express in a way that the court is going to understand that reality is a real hurdle. It's a real burden to start.
Can I just give you a reality check on where we're at in that gap of understanding? And for this, I want to give you an example of the 124 case that was that came out in November. It's about the Ontario legislation that capped public sector pay for many years. It was legislation that capped public sector pay that 78% of the people who were affected were women. The sectors that were affected were massively female-dominated sectors. I think there were only a handful of even job classes that were not disproportionately female-dominated. The ones carved out, police and firefighters. So, we're talking about the community and social services, health, education, and so on, right? Corporate service, heavily female dominated. The government, in enacting the legislation, did no gender analysis of the impact. Also, highly racialized, disproportionately racialized, no racial analysis before enacting the legislation. We had masses of evidence about the structural impacts. And the government's argument was, well, the people who are affected are women, they're men, they're trans, they're non-binary, they're like every race, they have and it's like, yeah, that's humanity. But, and the court bought that argument. It was like there was no structural analysis about disproportionate impact or the fact that the sectors of our economy that were affected are structurally feminized and devalued, and devaluing them further deepens that structural inequality, right? That it's always women that have to undergo the government tax cutting strategy, right? The simple argument was, well, there's there's people of all colors in the room, so it can't possibly be racist. That's the reality gap that we're dealing with. And the fact that a really bright judge accepted that is terrifying.
And I think it's as well, over the last 30 years of attempts, the concept of systemic discrimination is still not understood in any broad way. And I know Mary wants to follow up on what you just said, Faye, so hang on to that. Just hang on to it really.
Go ahead. Just say, I see AG counsel in the room, and I'm just wondering, why are you making these arguments?
So Mary wants to follow up, and then I see a question from you.
I just want to introduce here a real life story about how impossible it is to acquaint a judicial decision maker with the lived reality of people's lives within the constraints of the litigation system. In 2004, I was happy to be able to get an order from an Ontario court for some supportive applied behavioral analysis therapy for a group of, they were then children with autism. And that was in effect from 2004 to 2019, when without any warning and without any consultation, Ontario just cut it off and gave the families 6 months to find a replacement in a system that Ontario knew from the outset did not contain any replacements. And so when that happened in 2019, we started a process of litigation. We got the funding returned on an interim basis. And in September, we go to court to make the final argument. And in that 3 years, we have amassed over 2,000 pages of evidence about the lives of these young people, about what it is to have autism at the serious end of the spectrum, what it is to benefit from applied behavioral analysis so that you can live an independent and safe life to the best of your ability, and the terrible effects on the parents and the children of having this cut off. 2,000 pages. We are allowed to file a factum in the divisional court that is no more than 40 pages in length. Thanks a lot.
Question from the floor. Go ahead, Rebecca.
Yes, to follow up on Mary's point about the doctrine that's keeping out international human rights law. I want to contrast two cases, one that's pending before the courts, I think, the Touzin case, which was a Human Rights Committee decision that held Canada responsible for the denial of health care to a non-citizen of Canada. She won at under the International Human Rights Committee, but the government of Canada, no surprise, has refused to implement that decision. So they've gone now to court, and I'm not sure where that decision stands. Contrast a case before in Spain, a decision of the Committee on the Elimination of Discrimination Against Women, a domestic violence case, where for a long time the government refused to implement the case domestically. They went to court and they won. It's a very significant decision in terms of transnational human rights litigation. I'm wondering if there's any work being done academically to look at some of these cases, either within Canada and how we're faring generally. I know Y.Y. Chen, a graduate of this law school and now a professor at Ottawa, Touzin case, but that's all I know. But this is a very interesting issue, or very important issue that's coming up transnationally, and I'm wondering what work has been done in Canada.
Mary, did you?
I've been working for some years with a group called the Feminist Alliance for International Action, which is very keen to not only make representations at international human rights bodies, but also to try to improve the strength of the conventions and those bodies' decisions in Canada. And I think that organization would be very receptive to beginning a study or taking part in a study or supporting a study along the lines that we have talked about, to look at how other countries treat those decisions in a much better way than we do. Because we have to fix this problem. Or we're not going to get any benefit from our international human rights protections here in Canada. It's really critical. So maybe we can talk further.
And it is one of those things as well. And when you only have 10 pages before the Supreme Court, it's hard to do, but it's important to always reference the international law that applies to the government, usually in the Section 15 case, and everybody should be citing it and mentioning it, but whether it ever lands is another thing. Just before we wrap up, I just wanted to turn back to Cheryl and Caitlin, because the empirical findings of your work are really interesting, because the perception for many of us who've been involved in intervening on Section 15 cases for a long time is that the courts prefer to find on any other ground possible, but it turns out it's really the Supreme Court that is the reluctant party here, from what I can tell. So I just wondered if you could comment a bit on that perception and reality.
Yeah, well, I would say yes and no. I do think a 20% error rate, as I would call it, an error, is actually not insignificant. So that if 20% of the cases they're not ruling on a legitimate claim is a problem. It also doesn't take into account which way they rule. We haven't looked at the actual case, but I also think that we're not also capturing the cases like Bedford, for example, where litigants self-select not to make the Section 15 argument for all of the reasons that we've heard both Faye and Mary talking about in terms of the evidentiary burden, having to educate a court about critical race theory that isn't necessarily receptive to those arguments. And what we've seen, in Sharma, we heard about the sort of evidentiary issues of the court getting all bent out of shape about things that they've taken judicial notice of in the past and say you shouldn't have put this forward. Litigants are really reluctant to do this, but it's a huge burden to put these things forward and to have them just kind of shoved aside or disregarded, as in the Bill 124 case. So it's a huge access to justice issue, even in the cases that are looking at them. Looking at all the issues, but it's also for 20% of the cases, that's also it's just being disregarded.
Thank you. We actually have to wrap it up. I'm so sorry. I see there is another question out there, but we're a little behind time, so we're going to have to make that up. And I just want to thank all of our panelists for your contributions, and thank all of you.
Three that I've worked with in various capacities, and so we have done impressive work in this area. I'm going to be very brief in your bios. You have them on the agenda, which you can find through the QR code or the URL from the Center website. I will start with Jennifer Koshan, who is professor at the Faculty of Law at the University of Calgary. I've had the pleasure of working with her on case committees with LEAF. And her contribution to the arguments that we put together has been amazing. But I'll leave it at that. There's much more. She's given much thought to these issues, and her paper is excellent on this. Next, we'll turn to Carrie Frock, who I sit on the NOL steering committee with. She's the chair of NOL, but we specifically reached out to her to talk about Section 28, which is the if we want to talk about orphan clauses in the charter, that's one. It's or neglected or ignored, but we're hoping that that's not the case going forward. And then finally, we don't see her yet, but Margot Young from UBC is here, and as soon as we get through the PowerPoint with Jennifer, you'll see her face page just like Rajesh up on the screen. So I want to turn it over to Jennifer.
Thanks very much, Cheryl.
I want to acknowledge my co-author, Johnette Watson-Hamilton, who is joining us online from Calgary. And we pretty much write all our Section 15 work together. And with such a challenging area conceptually, I just want to give a huge shout out for having an academic buddy to write with, because this work is really hard and it really helps to have someone to speak through these challenging issues with. So the paper that we submitted focuses on the last 6 years of Section 15, or the last 6 Section 15 decisions at the Supreme Court over the last 5 years. I've got them listed there on the slide. We do tend to talk about doctrine in our work. Fundamentally agree with people like Faye Faraday that the test for Section 15 is a cover or a mask for the deep ideological disagreements that exist at the Supreme Court and at lower court levels. But we still think it's important to talk about doctrine because ultimately that's what litigators have to use. And also as someone who tries to teach Section 15 of the Charter to first-year law students, I think it's important to try to wrap our minds around what the doctrine is, how the court is using the doctrine, even to make arguments or findings that are deeply ideological in nature, but there's still something there that needs to be worked with. And so that's why we tend to focus on that in our writing. For the purposes of today's presentation, we're only going to focus on one aspect of our paper, and that is the court's recent decisions on adverse effects discrimination in Fraser and Sharma. We think it's really useful to do kind of a deep dive comparing how the court approaches adverse effects discrimination in those 2 cases, and to try to get at the challenges that the case law poses for this particular type of equality rights claim, and also how to move forward after the very, very disheartening decision in Sharma. So let's just talk about some brief overarching principles with respect to adverse effects discrimination cases. Probably not a surprise to most of the folks in this room, but important to just talk about what's understood and accepted, which really puts into light how big a disappointment Sharma is and how much a departure it is from things that have been well accepted since the Andrews case. So adverse effects discrimination has been recognized as a form of inequality since the Andrews case in 1989 and earlier in the human rights context. So again, it was great to have Leaf and other interveners at the court. Justice McIntyre relied on his decision in O'Malley from the human rights context right from the beginning, adverse effects discrimination and the idea of needing to take account of difference has been recognized by the Supreme Court. That being said, there have only been 3 successful adverse effects discrimination cases from the Supreme Court in the last 34 years, Eldridge, Green, and Fraser. Thanks to Tal for circulating the list of Supreme Court decisions that Johnette and I have put together and keep adding to. We've highlighted the adverse effects discrimination cases on that list. And it's only 3, well, there have been 13 adverse effects discrimination claims. It's kind of difficult to count. There may be more than that. We really focused on what the main claim was. But in cases like Tapotat, for instance, I think you can see that as both a direct discrimination claim and a claim based on adverse effects. So it's only 3 successful adverse effects discrimination claims out of at least 13 such cases before the court, which is a very, very low success rate. We also know, of course, that adverse effects discrimination is deeply connected to systemic discrimination, to the courts and governments' failure to account for difference and inequalities in laws, policies, and structures. And if you haven't read it yet, the paper submitted by Colleen Shepherd for this symposium that she'll be speaking to this afternoon is very useful in thinking about those structural differences. It's also crucially important to recognize adverse effects discrimination claims because they involve inequalities related to systemic racism and colonialism. like Sonia Lawrence and Joshua Seeley Harrington, as well as others, Faye as well, have written about those connections. Very, very rare to see cases involving systemic racism and colonialism that fall into the direct discrimination category. So we need to be able to recognize adverse effects discrimination if we are truly going to grapple with systemic racism and colonialism. Another important general principle, and I think this really gets to the heart of the difference between Fraser and Sharma, so I'll get into this a little bit more detail later. But adverse effects discrimination cases can be either quantitative or qualitative in nature. This was recognized in the Fraser case when Justice Abella distinguished between disproportionate impact type of cases, which tend to rely on more quantitative forms of evidence, and the lack of accommodation type of claim. If you're familiar with the work of Diane Potier, she referred to that other category as a categorical exclusion type of case, but really what we're talking about there is a lack of accommodation that doesn't rely on numbers in order to see this form of discrimination, but it relies more on a qualitative difference between the claimant group and others. So these two types of adverse effects discrimination map onto the two different types of evidence that Justice Abella indicated in Fraser would be useful in proving adverse effects discrimination claims. Evidence about the situation of the claimant group, which is more qualitative type of claim, and evidence about the results of the law, which is the more statistical or quantitative disproportionate impact type of claim. These categories can, of course, overlap in a given case, and so can the evidence that would help to prove these different types of adverse effects claims. But I think it's really critical to recognize both of them, at least as being conceptually somewhat different. And so how to compare the outcomes in Fraser and Sharma based on these two different conceptual categories is what we focus on in this section of our paper. If we think about Fraser, I think it's fair to say that both qualitative and quantitative types of adverse effects discrimination were at play. So women with caregiving responsibilities were a disproportionate number of job sharing RCMP members, and those job sharers were not accommodated in the pension scheme of the RCMP. This, of course, was connected to systemic norms and inequalities around women's caregiving responsibilities, women's employment inequality more broadly, which Faye spoke to on the last panel. And in order to see that type of adverse effects discrimination, the court needed to be able to rely on social science evidence and social science evidence for the qualitative piece, and then statistics for the quantitative piece, the disproportionate number of women RCMP members who were job sharing. It's also, this is just emphasizing the point, job sharers were not accommodated in the RCMP pension scheme, but members on leave without pay were accommodated. This was evident on the face of the law. There really wasn't any evidence that was needed to prove this particular point, but Justices Brown and Rowe, who were in dissent in the Fraser case, kind of got stuck on that particular point, which is really a formal inequality point. They just weren't able to see the more qualitative adverse effects discrimination that was at play on the basis of sex discrimination. So being able to see that discrimination based on sex required using both types of adverse effects discrimination and different comparator groups, which is what the majority in that case did. If we look at Sharma, on the other hand, the majority focused exclusively on the need for proof of quantitative disproportionate impact that the impugned law had on the Indigenous claimant and on Indigenous offenders more broadly, as compared to non-Indigenous offenders. So they were looking for statistical evidence that the Ontario Court of Appeal, in fact, said was not available for Ms. Sharma's type of offense. It wasn't possible to bring forward evidence that showed how many people would have received a conditional sentence for her offense, because there was a mandatory 2-year minimum for that offense before it was struck down by the trial judge. So the evidence just wasn't even available. This also gets into some of the issues around causation and evidence that Ben Perryman will be speaking to this afternoon on his presentation. The majority in Sharma, as I mentioned, in future cases, a qualitative approach might be useful to take. I'll leave it there. Thank you.
Thank you, Jennifer. I didn't even have to use my time cards. So over to Carrie. We can probably put Margot on this.
Hi. So I think I'm the ham or the cheese in the Sharma sandwich here. So I'm going to talk about something kind of different. The title of my paper is, Are You Serious? Litigating Section 28 to Defeat the Notwithstanding Clause. So how many of you, and be honest now, how many of you know what Section 28 says? Oh, good. Okay, so that's about, I don't know, 20 more than what I usually get. So just for those of you that don't, how it reads, and like Jennifer, I can't resist talking about doctrine, so I'm going to talk about it a little bit. Section 28 reads, notwithstanding anything in this charter, the rights and freedoms referred to in it are guaranteed equally to male and female persons. So it's essentially the Canadian version of the Equal Rights Amendment. That's how I describe it in shorthand. And what I wanted to talk about is to encourage litigators to think about Section 28 the next time you're going to be litigating gender or sex equality. Because when I was doing my dissertation research, I talked to a number of people that were involved in different equality interventions. And one word that came up over and over again is that pleading Section 28 is unserious. Unserious due to its origins. It originated with feminist advocates, not with government drafters. Unserious because there's an ambiguity as to whether it's just an interpretive clause, gender equality, we really mean it, I guess, or if it has independent effect. And I can't help but resist. Everyone rolls their eyes when academics try to have pop culture references. But when I was watching Succession, I don't know how many of you are following it, but the evil Logan Roy, after rotting or wreaking havoc with his children, stunting their emotional growth, their intellectual growth, tells them, I love you, but you're not serious people. And that's kind of how I feel about Section 28. The very people that are kind of grounded into the ground are now saying that it's not serious, right? So, and apart from some early cases where men won using Section 28 in part, there really hasn't been any direct application of Section 28. But one thing that comes up in the literature over the past 30 years is, oh, well, we've completely rationalized it, but guess what? When it comes to the notwithstanding clause, that's where it's really at. That's where Section 28 has a bite. So when a government invokes the notwithstanding clause, of course, Section 28 equal rights mean that it can't be used for legislation that discriminates on the basis of sex and otherwise results in unequal rights as between men and women. So no doubt, everyone from people that were involved with provincial delegations, the scholars, everyone's like, yay, Section 28, that's what we can point to as to where it has the power. But now that Section 33 and the interaction with Section 28 has become more of a live issue, guess what? Oh no, we can't possibly think about Section 28 having independent power to block the notwithstanding clause. So that's come under increased scrutiny from contemporary constitutionalists, and the Bill 21 litigation no doubt will come up the hack case will go up to the Supreme Court of Canada. So it's kind of like whack-a-mole that I feel like I'm trying to whack down all of these different convoluted interpretations, constitutionalists tying themselves up with the pretzels to try to prevent Section 28 from having the meaning that it actually says there on the page, notwithstanding anything, including Section 28. And these contemporary critics have read the extensive history of 28 that I've done. And they say, you know, that's really nice, but it's not legal. It's nice as a kind of a curiosity. It's nice to know about our constitutional history, but it really doesn't have much impact on the interpretive exercise. And they keep on now trotting out the same shop-worn narrative that Section 28 is an unserious argument and that litigators rely upon it at their peril. So what I want to do in my paper is I'll do a rundown of my theory about Section 28 and how it operates to block the notwithstanding clause. I'll give you a little appetizer of that. And then I'll talk about some of the criticisms of my approach. And it's interesting because these contemporary criticisms, they're very much cloaked in this cerebral technical language and arguments concerning text and linguistic conventions. But at their core, what they really do is rely on the force of the status quo, misinterpretations of what my interpretive theory is, ambivalent treatments of the text where sometimes they lean heavily into it and sometimes they just totally ignore it, and then something that I call grammar games. So what I hope to convince you of, if not here, then in my paper, is that you really have nothing to fear if you're a litigator and you want to plead Section 28. And it's probably going to become more and more to the fore as we see the rise of populism, preemptive use of the notwithstanding clause. So I'll lead you a little bit. Let's go on a journey. I don't know how far I'm going to get here, but let's take a journey, shall we? Okay, so Section 28 came into being in the draft charter before there was even a breath of a word about a notwithstanding clause. So the notwithstanding anything in Section 28 wasn't a response to Section 33. It was meant to ensure that any other provision of the charter didn't become a new source of women's inequality. It was to require that women receive their entitlement to equal rights, notwithstanding anything. So there was to be nothing limiting or constraining that guarantee. And they wanted, the feminist framers wanted to send a clear message to judges that all discrimination against women in constitutional law should be treated as serious as other constitutional violations. They really gave a side eye to Section 15. They didn't think that it would accomplish all of that. So it wanted a very strong clause, and that's why we saw notwithstanding anything. So when the Kitchen Accord came into being in November 1981, politicians said, yeah, sections 2 to 7 to 15, and they forgot entirely about Section 28. It's pretty clear that, oops, we just forgot those women's. So what they tried to do after the civil servants became involved, and there was a big push by provincial delegates and their civil servants to get Section 28 in. So there was amendments to 33 and 28 to say for 28, notwithstanding anything except 33, and in 33 to say notwithstanding Section 28 of the Charter in its application to discrimination based on sex and 15. There's a much storied feminist campaign to restore 28 to its original text, which was successful, but this really shows that there was anticipated to be an interaction between the notwithstanding clause in Section 28 that was supposed to be a upheld by restoring the original text of those terms. So to give you the Coles Notes version of what 28 does in relation to 33. So notwithstanding clause invoked, and usually it's invoked in an omnibus form. So it will say right in the law that notwithstanding sections 2 and 7 to 15. So anything that as a result of that invocation results in women enjoying unequal rights as compared to men, if the law discriminates on the basis of sex, that's kind of a no-brainer. But also when it comes to unequal enjoyment of other rights, I don't know, let's say freedom of religion. You have a law that targets Muslim women, and not only does it target them in intent, it has adverse effects. See what I did there? Against them. Predominantly, the trial judge in Hatt found that almost all or all of the people affected by that law were hijabi wearing or hijabi women. So unequal enjoyment of freedom of religion. So where you have that, you have a violation of section 28. 28 isn't covered by the notwithstanding clause, and a court can strike down the law based on 28 as it can do based on any other rights violation. And it's true, section 28 also has interpretive force, but like 15, which is the broadest of all guarantees and is used as has an interpretive function, 28 has two functions. So, and what I would also say about section 28, it was very intentional that it was different from section 15. So it doesn't focus on distinction based on the ground, which is sex, etc. It was meant to be something very different by talking about men and women as whole people. So what we're talking about is unequal enjoyment of rights by women. For instance, we're not talking about abstract discrimination based on the ground. That's not what section 28 does. It's talking about women as whole people. So I see I'm out of time, so I'll just give you a flavor of the kind of criticisms that I'm going to look at in my paper and tear apart. The idea that section 28 is only interpretive, well, why isn't there wording to that effect in 28 when there is in 25 and 27? That rights argument, the idea that, well, you look at the rights that exist after the invocation of the notwithstanding clause, so there's nothing to equalize after the notwithstanding clause. Those rights don't exist. Weird kind of textual arguments like the reference to guarantee in section 28 just means an acknowledgement of possession. Rather than I guarantee, I actually mean you to have that guarantee of equal rights. And another recent one, which it took me a whole afternoon to try to unwind, is the idea that the notwithstanding clause in section 33 uses the subjunctive mood. So it creates a legal fiction that rights don't exist. And that's why section 28 has nothing to do, because the legal fiction is none of those rights exist. So that's why I call them grammar games, is that they use these kind of very convoluted, seemingly cerebral arguments to try to retrofit or take away what's in the ordinary meaning of notwithstanding anything. So I'll leave it there. Thank you.
Thank you, Judge Terry. We now have Margot up on the screen. I'm hoping that you're able to join us. I think you're muted, so over to you, Margot. You're still muted. So we can't hear you, Margaret.
So now
There
we
we
can. I was
Yeah.
just explaining what is probably obvious, but I'm dealing with some tricky equipment issues. So let me know if I go off air. But I want to thank the organizers of this symposium. It's really a treat to be part of it. I'm zooming in from the traditional territories of the Gana-Yigahaga, which is, as you know, many of you will know, a traditional meeting ground for exchange among First Nations, so an appropriate place to be for this discourse. My paper today takes up the majority judgment in the recent Supreme Court decision of Sharma, and it's a judgment that is both surprising and not surprising. It's a surprising majority decision because if equality rights would matter in any case, you think it would be this case. The colonialism and sexism is so strongly contouring the life circumstances of the claimant Shan Sharma, and more particularly the context of the actions that land her in court. So it seems that a finding of inequality would in fact be overdetermined. But the result, the rejection by the majority of the equality claim, is also, alas, not surprising. The case focuses on government removal of a community-based sentencing option for certain crimes. And so the government action at issue is, I think, a more complex. It's repeal of a remedial benefit, not simply institution of a burden. And the courts have for some time struggled with the false dichotomy between action and inaction in the arena of rights. More features, however, also condemn the majority judgment. And as Jennifer has detailed well from at least one perspective, this judgment marks the return of concepts and concerns that are historically known to stamp, that are the hallmarks of bad equality analysis. And maybe after Fraser, we had hoped that we were done with the reductionism of formal equality and its henchmen, causation and arbitrariness, for example, but apparently we are not. So I do think it's also important to note that the majority decision in Sharma lurked in the dissenting judgment in Fraser and other cases, but what had seemed like a corner turned is now distressingly apparently simply a short-term detour. So this observation brings me to the theme, or really the conceit of this presentation, and that is concepts that refuse to die. These are the zombies of equality law, ideas and attitudes about equality that haunt and roil the jurisprudence. And I offer this metaphor in aid of convincing you that articulation of seemingly adequate tests for equality simply don't matter. The majority judgment in Sharma shows again how concepts in equality law that we thought were put to rest significant time ago influentially resurface with regularity, ensuring that the Charter's equality rights default continually on the transformative promise of substantive equality. I want to talk about zombies for a moment. So the zombie has been described as a culturally promiscuous undead colonial construct. They are undead chameleons cannibalizing opposition. They are figures of fear and anxiety. So the zombie is a prevalent and a resurgent monster. In the article, A Zombie Manifesto, we learn that zombies are almost everywhere. They're in cognitive science and neuroscience and computer science, and even in the natural sciences with the phenomenon of zombie ants. So why not in law? Zombies are, again, from the manifesto, an ever-evolving metaphorical vehicle, figures that stand in for a myriad of cultural anxieties. Zombies are hauntic objects. They have materiality, their corpse, albeit a rotting one, and they also have a symbolic presence, the ideas or conflicts that animate them, that haunt thought. Equality zombie concepts engage this tension. Their impact in equality law results in very real and embodied consequences for equality claimants, like Shan Sharma. But they also encode conceptualizations of the danger and scope of equality rights that stalks even analysis in those cases where the equality right under examination triumphs. So I want to play off some of the complexities of this post-humanist figure of the zombie to illustrate the role of equality zombie concepts and the insights their constant resurgence enable. The zombie notions in equality law shuffle into view to threaten the effectiveness and reach of our equality aspirations. These equality artifacts are half destroyed through such effective criticism, like the people who are on the panel right now have proffered, but they lumber on. They're a menacing outsider that comes from within. That is, the zombie concepts are intelligible within the history of equality law itself. So at the same time they threaten to erode, they do so on equality's own terms, targeting the sort of core aspirational meaning of equality rights. And this takes me back to zombie ants. Zombie ants, might be an unfortunate reference, but I'm going to run with it. Zombie ants are infected with a fungal virus that ultimately leaves their brain intact, but takes over their muscles and movements to force these ants to lock onto leaves in such a manner that they ensure constant reinfection and spread of the fungus they contain. And I want to argue that the Sharma majority indeed cites valid precedent for all of the concepts that the judges in that majority dig up. Their citations offer fair support. So part of my project is to trace, in fact, all the way back to Andrews, the constant sowing of these zombie concepts, like the fungus and the ants, throughout even the best of equality cases. And I'll mention as example that line from Andrews, where the judge talks about distinctions based on personal characteristics, I'm quoting, attributed to an individual solely on the basis of association within a group will rarely escape the charge of discrimination, while those based on individual merit and capacities will rarely be so classified. And I think many of us have taken time to unpack why this is such an unsatisfactory understanding of equality, but I'll put it forward as an illustration of one of the first infections of the zombie contagion of non-arbitrariness and causation that we see still cycling through decisions like the majority in Sharma. And just to provide more illustration, there are at least 3 zombie concepts in the majority judgment in Sharma: the notion of causation, the fear of positive obligation, and the insistence on somehow engaging with the idea of non-arbitrariness. And each of these contributes significantly to the rejection of Ms. Sharma's claim. I'm not going to engage with these in critical detail. I think that's been done already very well by academic literature, indeed on the court itself in certain judgments. But I do want to point out that each of these notions, causation, positive obligation, and non-arbitrariness, express an anxiety about the judicial relation to the other branches of government. And you know, there's more that can be said about it, but I want to just to name that they all animate a particular anxiety around the power and the role that judges have. There are some other odd revealing bits in the decision. For example, the majority claims that finding that the repeal of the community sentencing was an infringement of Section 15 would be tantamount to elevating the legislative provisions to constitutional status. This is a very puzzling statement in a democracy that's subject to constitutional review. And we have the dissent as well, taking on these zombie concepts and saying that they really dislodge fundamental premises of the existing jurisprudence. But I want to return to this claim that's really informed by this question. Do these convincing criticisms matter? Because you can't, after all, reason with zombies. So what occupies for me for this paper is why these concepts won't die, despite very clear condemnation of them. And why do these notions move those judges who were in the Fraser majority to join the Sharma majority? And to return to zombie terminology, what is the hauntic power of this set of notions? So I heard in Faye's presentation some really important pieces that fit well into my argument, that the ideological and cultural anxieties that the judges have are part of the explanation. All of these concepts speak to enhanced deference to Parliament, to palpable concern about displacing a rather rigid and traditional notion of the separation of powers that arguably really mischaracterizes the balance and interaction in Canadian democracy between the judiciary, executive, and legislative branches. You know, we teach our students about how the separation of powers in Canada is weak, that it's more complex at the level of both agents and institutions. And yet we have a judiciary that balks at the prospect of taking up an affirmative institutional role that's consistent with what structure of powers in Canada seems to call for. So, you know, I've written elsewhere about the need for judges to take up a duty that the separation of powers assigns them, that is to engage with equality claims. But here I'm pointing more strongly to the judicial fear, the one that animates these zombie concepts about how they exercise their power. And one commentator has written that if powers truly were separated so that each branch of government could exercise only a discrete set of powers to the exclusion of other powers or other branches, the nation would be ungovernable. That is, that an intermixture of functions is both necessary and desirable. So I want to wrap up, having given you just a little taste of the sort of various directions in which this paper is going. But I want to reinforce and repeat the idea that causation, rationality, positive rights really are the zombie concepts of equality law. They are the walking dead of equality law, and they encode deep judicial anxieties about the judicial role, about our world, and about the power or potential of equality rights to push at, maybe even to push beyond, the liberal legalism, the life world of our legal system. So to the extent that there's intellectual coherence in these judgments or across these judgments, perhaps this is it. But it really begs the question then, is equality law too infected to be anything more than it already has been? I think yes is a quick answer to this question. The transformative role so many of us wish for Section 15 may simply not be reachable within the ideological frame or the life world of liberal legalism. D.B. Herman has written about this, noting that our own enslavement, when we take up rights to liberal legalism, in this we are already married to the grave. And I would add, therefore vulnerable to the zombies that there lurk. But I'm going to twist this around and say I think it's important not to give up on equality. It captures something other rights like Section 7 can't. Equality rights engage with the difference that difference makes. We know from sociologists that gaps matter to the quality of life, both to those on top and those below. So maybe we need to target the brains of these zombies. And if you read, there's a book called how to defeat the zombie hordes, and that's how you defeat zombies. You target their brain, not the doctrinal form, but the ideology and the anxieties that animate the zombies. But in any case, at the end of this very quick presentation, I'm left with contradiction, with significant tensions, and with palpable incoherence, but I have to say also a commitment to equality and to surviving the zombie onslaught. Thank you very much.
Thank you so much, Margot. That's great. You've also left with me the image of the next time anyone appears before the Supreme Court of Canada and is nervous, they can just picture all the judges as zombie ants. I want to open it now for questions. Does anybody on the floor have any questions? Please raise your hand.
Question for Carrie. It was noticeable that you didn't mention one person among the constitutionalists, and I was eager to hear who you were. But I wanted to suggest to you one thing, and that is that contemporaneous with the coming into force of Section 15 were, and the Charter generally, were government bump with annotations. And so I was teaching students about Hawk at the Quebec Court of Appeal and this confusion about what the effect of Section 28 was. And the bump that the government of Canada issued at the time, the annotation to Section 28 says precisely that it is meant to override Section 33. I'm paraphrasing, but that's what it says. Yeah. So how can there be confusion? If I mean, not that folks are bound to what framers intended. But nevertheless, it's pretty clear that's what the motivation for section 21. So I'm wondering why this confusion and also who these constitutionalists are.
Okay, great. I don't mind naming them. Asher Honickman is the one that has this textualist argument about guaranteed meaning an assurance of possession rather than actually meaning you have to do a thing. So essentially rendering section 28 meaningless. Maxime Saint-Hilaire, I think, has picked up the cudgel in saying that section 28 is merely interpretive because look where it's stuck. Picking up on guys like Elmer Dreger that said section 28 is a queer provision. It says and it means nothing, it does nothing. So there's that guy, and then Jeffrey Siglet is the one that is taking a frolic about subjunctive mood in section 33 sub 2, which means that you have to look at the rights as it's directing judges to consider rights and 7 to 15 as legal fictions. And basically treating them like they don't exist versus what I would say is telling judges to allow laws to continue to operate. And that's where the focus was rather than creating this sort of fiction. When the Bible says, you know, you shall love your neighbor as you love yourself, it's not creating the legal fiction that your neighbor is yourself. It's saying that what you should do, which is to treat them in a certain way. So those are the kinds of things and why this is kind of being resurrected. I mean, I have my conspiracy theories. I think that it was a convenient argument for people to concede section 28's power in relation to 33 in some ways, because that meant that it could erode its meaning in a whole bunch of other directions and still not bump up against your denying meaning to the explicit text of the charter and betraying the rule that the legislature doesn't speak in vain. But yeah, it means what it says. And I mean, it's unfortunate, but I interviewed a number of people, a number of government drafters that are now deceased. And they said, yeah, we thought it was going to block 33 and 1 and do all this stuff. And we warned the politicians, but the women's lobby was just so strong that we couldn't withstand them. So, I mean, from the horse's mouth now, these constitutionalists are leaning hard into one of them, Barry Strayer, who was another government drafter, wrote an article about section 15, where he says what they thought they were doing with 28, but my historical research proves it wrong. And, you know, in terms of what I'm doing, you know, I kind of tongue in cheek call myself a feminist originalist, but really what I'm doing is trying to urge a more principled use of purposive interpretation and look at text and history. So sorry, I wouldn't.
Okay. I know we have one question online, so Emma or.
Yeah, so we have one question from Natalie Shalifor, who notes that youth climate litigants are bringing section 15 arguments forward in several cases. And so she would like to welcome your thoughts on the Ontario decision or the use of equality arguments by youth in the climate change context more generally.
Anyone want to jump into that?
I have to confess, still haven't had a chance to read that decision. But I know it's being argued on the basis of age. And I think, you know, going back to Faye's point this morning about the sort of the role of youth in carrying these conversations forward, I think that litigation is incredibly important. I also just wanted to make the observation though, and this isn't so much tied to the question, but I'm not sure anyone has used the word substantive equality yet today. Like, has anybody actually said substantive equality? It's almost lunch.
I think I did.
Okay.
Only to say.
Is that
only
a zombie concept as well?
Yeah, no, only to say the zombie concepts, we're doing it in. So it's a
Yeah.
fleeting message.
It's the only one with the brain that they're trying to do.
But I guess, I mean, what that makes me wonder is what work is substantive equality still doing if we haven't really been talking about it yet this morning. So maybe that's something we can think about this afternoon as well. But sorry, Natalie, I don't have anything more useful to say than that.
I could jump.
Oh, go ahead, Margaret. Did you want to say something?
Yeah, I could jump in a bit. I think that the equality claims in terms of the two cases, one come out from Ontario and the other from BC, the LaRose decision, are really sophisticated and convincing claims based not just on age, but also on gender and indigeneity, because there are disproportionate qualitative impacts in terms of Indigenous youth and female youth. So I fear, however, that notions of causation, for example, will be really hard to surmount in this argument, that the consequences of accepting an equality claim in relation to climate change are significant, and the anxieties judges have about too boldly straying into executive and legislative arenas and about occasioning significant redistribution of resources will be real stumbling blocks, not for logical reasons, but for the kind of animating anxieties and concerns that mean that these concepts that we've really, I think, quite convincingly debunked in scholarship and in a number of cases will once again come back and play a role. So I wish I was more hopeful about those cases, but I'm not sure that we're at a place with the judges who are on the court and with the sort of recycling of these kinds of zombie combat concepts that happens to have the kind of result we wish we would get.
Thanks, Margot. I would just add to that in addition to those anxieties that you're talking about, the age discrimination claim has always been a really difficult one to make. And I know there's a group of lawyers from Justice for Children and Youth here who are nodding and smiling, because it is one of those categories, even though it's an enumerated ground, it's just been defined away in so many types of cases that it's always a huge hurdle to get over that one. I think Sophia had one question. I'll be very quick. And it will be our last question before we break for lunch. So go ahead.
Great. Thank you all so much. This was really interesting. Jennifer, this question is for you, and it sort of ties together some of your thoughts with some of what we were hearing from the first panels this morning. And I really like the distinction that you made between qualitative and quantitative analyses and the roles, the different ways in which they play certain roles in Section 15 judgments. And I guess my question was this: would you agree that each of them can pose quite distinctive difficulties or hurdles for claimants in the following way that, as you mentioned, in certain cases, it will either be impossible for claimants to adduce the relevant quantitative evidence, or doing so will require great expense and a lot of trouble, and we're dealing with marginalized groups with insufficient resources. So there are those sorts of hurdles. Claimants don't face those sorts of hurdles when they're dealing with qualitative analyses, but there the problem is the kind of problem we heard about this morning, where your claimants have to then try and convince a very privileged judiciary of a perspective that is totally alien to them. So it looks like, as it were, you're damned if you use the one for certain reasons and you're damned if you use the other for other reasons. And maybe together that explains why it's just so difficult to succeed when you bring a claim of adverse effect discrimination.
Yeah, Sophia, thanks. I think that's exactly right. And I think from a strategic perspective, in cases where both are at play, it's always really important to argue both. And there's a great piece by Melina Buckley and Fiona Sampson. I think it was on the health services case, where they they talked about the important link between the quantitative and qualitative claims in the sense that numbers really only mean anything if you look behind the numbers and say what is going on qualitatively behind the numbers. So to bring it back to Sharma, okay, great. So the majority wanted statistical evidence on the level of disproportionate impact that this law was having. But that's really kind of besides the point. I mean, why is it that Indigenous offenders are more frequently before the courts, are over-criminalized, are over-incarcerated? It gets back to factors related to colonialism and systemic racism, which inheres in the way that group has been treated. And so I think even in cases that could be characterized as quantitative in nature, you're always going to want to come back to that qualitative piece because it helps explain the numbers. But again, the evidentiary burden is very challenging in both categories. I agree with you on that.
I think we're going to begin. Welcome everyone to the afternoon sessions of our symposium on litigating equality in Canada. This next symposium is going to focus on a number of quite different things that are united, I think, by the fact that each of our panelists is going to talk about certain things that either Section 15 or our statutory human rights frameworks as currently interpreted risk making invisible or erasing. That's why we've called it in a somewhat fancy way, risks of erasure. So we will hear from Professor Colleen Shepherd about structural dimensions of inequality. We'll hear from Amit Singh about intentional discrete interaction discrimination. And we'll hear from Benjamin Perryman about the role of the judiciary in sustaining evidentiary barriers. I'm Professor Sophia Moreau. I'm a professor of law and philosophy here at the U of T. I'm just briefly going to introduce all our panelists and then we'll get started. So firstly, we have Professor Colleen Shepherd. Colleen is a professor of law at the Faculty of Law at McGill University. She recently completed a term as director of the McGill Center for Human Rights and Legal Pluralism. She served as a commissioner on the Quebec Human Rights and Youth Rights Commission from 1991 to 96. Has been on the board of directors of Equitas, an international center for human rights education from 2006 to 2012, and was elected a fellow of the Royal Society of Canada's Academy of Social Sciences in September 2016. And she will be speaking to us first on litigating structural inequality. Next, we'll hear from Amit Singh. Amit is an associate attorney at the New York City firm of Hallwell, Schuster and Goldberg, LLP. Also an adjunct professor at the Lincoln Alexander School of Law at TMU, and a research associate at the University of British Columbia Center for Constitutional Law and Legal Studies. We're also very proud to have him as an alumnus of U of T, Faculty of Law, and I gather he's about to start his LLM at Yale. He is going to speak to us about intentional discrimination after Etobicoke and O'Malley. And lastly, but never leastly, we have Professor Benjamin Perryman, an assistant professor at the University of New Brunswick Faculty of Law. Benjamin is a doctoral candidate at Yale Law School, where he has been a Fulbright Scholar and a Trudeau Scholar. He has practiced in the area of human rights law and is a human rights adjudicator and is called to the bars of Ontario and Nova Scotia. And he will be speaking to us about proving discrimination, evidentiary barriers, and Section 15(1 of the Charter. Okay. Thank you, Colleen.
Bonjour, bon après-midi, good afternoon. Can you all hear me with the microphone? And you can all see me. I always feel like podiums are a key example of structural inequalities throughout my teaching life, at least. It's really a pleasure to be here today. And I want to thank the organizers for bringing this community together. And it feels to me one of my first post-pandemic conferences, and I was excited to be here in person and to hear from people who are working in the front lines in the courts and academics and scholars. It's I think we all play different parts in trying to work together towards advancing equality. Today I want to present some ideas or some reflections about the importance of trying to litigate some of the broader structural and systemic inequalities or injustices. And while litigation clearly is not a panacea for redressing or addressing systemic or structural inequalities, and I think the panelists this morning emphasized the importance of working with community-based organizations and in a multitude of domains, that litigation is really part of a larger component of different types of engagement. I still think litigation has tremendous richness and possibility of illuminating inequalities at the individual, institutional, and broader societal levels, what I've called the micro, meso, and micro. So I'm just going to present this template for understanding structural equality or systemic. I tend to use those interchangeably, although systemic is often associated directly with discrimination concepts, and structural evokes a broader concept. I'm going to present this template, which I have found useful in thinking about inequalities, and then briefly highlight some of the challenges and the potential of trying to litigate structural inequality. And I'm also going to draw, since it seemed that many were drawing on recent charter cases, I'm going to look at the cases of Fraser and Sharma, which we've heard a lot about so far. In a lot of my own work, actually, I draw more on human rights tribunal cases, the First Nation, and there's numerous cases that I think could illustrate some of these similar phenomena. One I've looked at quite extensively is the First Nations Caring Society case. Okay, so this, in terms of this template, I think to begin, I began thinking about this really after the Jeffrey Moore case involving disability in education, and where Justice Abella refused to give a systemic remedy and instead limited her remedies to really individual remedies. And that made me think that we tend to associate the broader macro or systemic inequalities. These tend to associate structural or systemic inequalities with the macro level. And in this template, I want to illustrate that, in fact, the structural or the systemic is interwoven at the micro, meso, and macro level. And just to quickly run through it, I think at the micro level, we often think about individual interactional injustices, exclusions, discrimination, harassment, bullying, mistreatment. Now, many would say, well, those are isolated individual interactional cases of wrongdoing. But in virtually every interactional individual injustice, those individuals are located within a structural context of, or those interactions are shaped by institutional and societal power hierarchies. If a police officer is mistreating an individual citizen, obviously the power of the police officer impacts that interaction, giving it a structural dimension beyond simply the individual interaction. If in fact individual injustices are pervasive throughout an institution or throughout a society, such as racial profiling, for example, those multitude of individual interactional injustices can create a systemic or more structural problem. Now, at the meso level, the institutional level, I think we think of this sort of panoply of rules and norms, institutional culture, even specific laws governing specific institutions or actors, as potentially having more of a systemic dimension. Indeed, our concepts of systemic discrimination emerged at that institutional level, in the workplace in particular, where we saw seemingly neutral laws or rules or policies were understood to have disparate impacts and therefore give rise to systemic inequalities potentially. Those meso-level inequalities, the institutional level, are often, or even those adverse impact cases are often understood through the impact of macro level, societal level inequalities on institutional, and the impact of institutional policies on individual lives. For example, in the Fraser case, which we've talked about, we can see that the inequalities in the job sharing pension benefits was impacted by the gender dimensions of caring relationships in the family that sort of speaks to these larger societal inequalities. And at the macro level, certainly inequalities linked to these broader historical intergenerational patterns of exclusion, often embedded in broader public policies, in legal frameworks at the national, regional, and international level. those I think we understand as having important systemic dimensions, but they filter down into the meso and the micro level. Okay, so I'm just going to use the Fraser and the Sharma case, which I don't think I need to dwell on since we've heard about them already. Now, in terms of the key risks of erasure, and I'm going to focus in on a few doctrinal approaches in the Fraser and Sharma, which disregard those macro level societal inequalities. And in order to, I think, advance a more structural approach to litigation, it's important to infuse the monitor's working now. I don't have to. I want to infuse litigation with an understanding, especially litigation that arises at the individual or the institutional level, with understandings of macro level inequalities. So the first example is a narrow comparator group analysis, and such that is grounds-based distinctions which are made in isolation from an understanding of broader inequalities. Indeed, Justice Avello repudiated that, what some call the mirror comparator group analysis, in the Whiffler case. But nevertheless, in both Sharma in the dissent, in Fraser in the dissent and Sharma in the majority, some justices appear to be reverting to such an approach. And I should just say as a footnote, I think the majority is going to shift given the changing composition of the court. So I'm not treating this majority opinion in Sharma as having the long staying power. And I'm seeing Justice Karakatsanis as a new voice emerging in the wake of Justice Avello's retirement, a new important voice for substantive equality. Okay, so one is narrow comparator groups. Secondly, the causation and choice, and Margot Young talked about that really fascinating concept of the zombie concepts, the refusal to recognize how pre-existing those macro level and even institutional level inequalities impact individual choices. And thirdly, these positive versus negative rights concerns and the ways in which a more narrow approach to litigation reduces state responsibility by framing, well, in various ways. And I think actually the international law developments may provide some important insights on that. So just in terms of the ways in which structural inequality is made more visible in the case law, I think one of the most important ways is through a robust and enhanced and expansive interpretation of substantive equality, an approach that takes into account power inequities and that contextualizes individual and institutional inequalities by looking at the sort of multi-layered frameworks of inequality. The individual level is always important in terms of hearing the experience, learning from the experiential knowledge and the stories of individuals. So that substantive equality approach, an expansive approach to discrimination, that is the recognition of adverse impact and also systemic discrimination. And also, so those two allow us to identify the structural and the multi-level dynamics of systemic and structural inequalities. The third point is the importance of transformative remedies that go to not only correcting the symptoms of discrimination, but also addressing some of the underlying sources of inequality. So just because our time is short, I've pulled out a number of little quotes from Sharma and Fraser, and I'm just going to highlight a few of those in the time that remains. Just to give you an example of the narrow comparator group approach, Justice Cote's dissenting opinion in Fraser, she finds the relevant comparator would be persons with caregiving responsibilities versus persons without caregiving responsibilities. And the effect of the impugned provisions is to create a distinction not on the basis of being a woman, but being a woman with children. In other words, a distinction exists not because one is a woman, but because one has caregiving responsibilities. There you can see the sort of isolation of the distinction without taking into account the larger context, eliminating a gendered understanding of the history and the cultures around caregiving and caregiving responsibilities, and effectively eroding any conception of adverse impact discrimination.
In contrast, you can see in Justice Abella, recognizing gender-based adverse impact discrimination, looking at how what appears to be neutral has a plain disproportionate impact on women in terms of the data. RCMP members who worked reduced hours were predominantly women. 100% of those working reduced hours through job sharing were women. And the number of women RCMP officers is still a tiny fraction of the RCMP force. And then she bolsters those statistics with the compelling evidence about the disadvantages women face as a group in balancing professional and domestic work. In the Sharma case, Justices Brown and Rowe, for the majority here, held the distinction is between Indigenous and other offenders who were similarly denied conditional sentences, isolating that distinction, and that there was inadequate statistical evidence, as we heard in the earlier decisions. And they do not link this distinction in one section of the criminal code to the remedial provisions on Indigenous sentencing, the Gladue principles, or to the larger reality of over-incarceration of Indigenous people. And I think as Faye told us this morning, it's just shocking. In contrast, the Ontario Court of Appeal applies a much more contextual approach. Aboriginal offenders start from a place of substantive inequality in the criminal justice system, looking at that broader impact. And by removing that remedial sentencing option is to create a distinction. And in some ways, the line between adverse impact and direct is very blurred. And I would argue that in many ways, it's really a form of direct discrimination in the Sharma case. In causation and choice, you can see how Abella recognizes that choices are shaped by systemic inequality and draws, and in Abella's judgment, her last big equality judgments, it's interesting, she cited all these feminist academics who've been working away, unrecognized in their little offices, and all of a sudden, woo, cited numerous times. So it was interesting that she reinforced the voices of scholars, and I think affirming the ways in which people play multiple roles in this struggle for equality. I'm just going to jump over the state responsibility because of time, but I want to end with a few quotes on substantive equality as understood by Abella and Karakasanis that shows how they take this more global approach, which takes into account this larger context. Abella writes, substantive equality requires the attention to the full context of the claimant group's situation and to the actual impact of the law. And it takes into account persistent systemic disadvantages. She also draws on this ILO report throughout their life cycles. Women accumulate disadvantages that pile up at older ages. Women are especially vulnerable because of interruptions in their work. Their pensions are often significantly lower than those of men. So you can see Abella reaching out into that larger macro database to understand the ways in which those macro inequalities impact these meso-level institutional policies embedded in legislation in that case. In Sharma, we see Justice Karakasanis, against mere formalism, substantive equality looks behind the facade of similarities to the actual impact, taking into account social, political, economic, and historical factors. Again, a broader reading. Ms. Sharma's own history intersects with intergenerational effects of colonialism, corresponding rising rates of Indigenous incarceration, linking that individual experience of inequality to those larger inequities. And finally, tracing the lineage of intergenerational trauma makes clear, again, she's broadly speaking, that's why I find her judgment so hopeful, that our criminal justice system is a significant ongoing source of discrimination. To blame overrepresentation solely on pre-existing disadvantages is to ignore a plain reality that incarcerating people is an exercise of state power. And since the state is deeply implicated in the incarceration of Indigenous women, it has an obligation to ensure that its laws do not operate to reinforce, perpetuate, or exacerbate conditions of equality. So in conclusion, I think litigation is, and litigating on issues that raise structural inequities, and almost every discrimination case raises these broader structural issues,
is part of it, but it's obviously part of a larger political struggle. And it's also not an either or. I mean, I think of the First Nations Caring case where they lobbied governments, they tried to get political change and ultimately went to court, filed a human rights complaint with the Canadian Human Rights Commission. Then while so I think it's all connected. While litigation is only one small response, it provides a rich contextual knowledge about structural inequalities, and it often provides an individual face to the larger macro problems of inequity. And however, within the litigation process, I think strategic framing choices impact its potential to contribute to making visible and overcoming structural inequalities. So I think that's the end. Thank you. Merci.
Comment. If you prefer, you can sit.
Yeah, I did.
Totally up to you.
I couldn't see a thing.
Colleen just wanted to do that initially.
Sounds good. I'll sit in that case. Okay, well, thank you very much, Professor Moreau. I'm really delighted to be here, and thank you to Paul and Cheryl for organizing this and agreeing to allow me to inflict these ideas on you. As I said, it's a pleasure to be here, and it's great to be back in this building after a few years away. So my paper is about the human rights codes, and in particular, it's about a form of discrimination that I think somewhat strangely, the courts have begun to lose their ability to impugn. And I say that this is strange because I think for a long time, before the new received wisdom about equality law arrived, we thought that the primary subject of discrimination law was impugning direct discrimination. You know, somebody has a discriminatory intention or prejudice or animus, and they make that naked, and that's the kind of discrimination we wanted to go after. I think then there was a deep and profound and important rethinking and expanding of what we took to be discrimination. We began to realize that in many ways, discrimination is not fundamentally bound up in intentions. It can be the product of neutral policies, for example, that interact with particular characteristics that a claimant may have. And so there are a series of cases from the Supreme Court of Canada and the Courts of Appeal and Human Rights Tribunals in the 80s and the 90s, and even as late as the early 2000s, about how a seemingly neutral policy interacts with the claimant's protected characteristics. So, for example, in Binder and CN Railway, a Sikh man who wears a turban is unable to work on a production line and wear a hard hat precisely because he must wear a turban and it's against his religion to remove it. And the arguments that the respondent make in this case are, well, you know, nobody intended to discriminate against Mr. Binder. You know, he as it were is bringing a characteristic to the job that makes him impossible to meet its requirements, and so there's nothing to see here really. And the courts, I think, rightly recognized that that wasn't true, that there was indeed a form of discrimination here, and at least that employers or respondents generally had to make, you know, provisions in order to accommodate all manner of people who might be entering their workplaces and other contexts as well. So that, I think, is the context, and why I say that the thesis of my paper is surprising is that I think that we've actually begun to lose the sense in which we want to impugn direct discrimination through the doctrine that we now have under the human rights codes. Okay, so here's what I mean by this. So under the human rights codes, there's a two-step test for assessing discrimination. The first is that the claimant has to make it a prima facie case of discrimination. And this test comes from Moore and other cases from the Supreme Court of Canada. And here the claimant has to point to differential treatment on the basis of a protected characteristic, resulting in an adverse effect. And the second stage of this test leaves room for the respondent, after the first stage is made out, a legal burden shifts, and the respondent has to offer what's called a bona fide requirement defense, a defense that suggests that the rule or formal policy that's being impugned is indeed a kind of regrettable but necessary feature of the workplace or whatever context this might arise in. My point, however, I think, is that in the case of direct discrimination cases and what I call discrete interaction fact patterns, that test is essentially toothless to to both ask the question that we want asked and then answer it. And here's what I mean by that. So I should say a little bit of what I mean by discrete interaction discrimination. So what I have in mind is the kind of fact pattern that comes up in a now neglected case that once was very prominent called Shakes versus Rex Pack. And this case is from the 80s. And Miss Shakes was a Black woman, and she showed up for a job interview at a manufacturing plant. And after she left the interview, she got the sense that her race was at issue in the fact that she was not selected for this job. And so she went to the Human Rights Tribunal and said, other candidates who were who I was no less qualified than were picked for this job over me, and that is because they were white and I was Black. And at the time, the tribunal applies a very thin test in order to determine if the prima facie case was made out. The tribunal looks at those facts and says, is it true that Ms. Shakes was experienced an adverse outcome, in this case not being hired, on the basis of a protected characteristic, i.e. her race? And is there at least some evidence that the other people who were picked over her were no more qualified than she was? And the tribunal held that the prima facie case at least was made out in that case. My submission is that now that, the sense in which the prima facie case was made out in Shakes would not apply nowadays, because we have a much more robust threshold for making out the prima facie case now, because the prima facie case as we have it under the modern human rights codes picks out a kind of complete legal wrong, and a legal burden shifts to the respondent to offer a bona fide requirement defense should the respondent want to, but they need not. The respondent could simply lead evidence, say, to deny that the prima facie case was made out. That is not possible under the test that was operative under Shakes. And that, I think, is because Shakes was functioning as a kind of res ipsa loquitur test, if I can make an analogy to negligence law. So what the tribunal recognized in Shakes that we have lost our sense of is that Ms. Shakes is making a fundamentally kind of circumstantial claim that is incomplete at the prima facie stage. She has offered evidence that raises the suspicion of some discrimination, but that requires the eliciting of further evidence, likely from the mind of the respondent and evidence that's within the control of the respondent in order to resolve. So what Shakes does is it shifts an evidentiary burden onto the respondent in order to have to lead more evidence to nix the inference of possible discrimination. And I say that the test as we have it now is toothless to conduct that kind of analysis that Shakes was actually doing quite well, because there is no real sense in which, in Ms. Shakes' situation, the respondent could offer a bona fide requirement defense, right? So recall, a bona fide requirement defense doesn't start by saying, I agree that I discriminated against, it starts by saying, I agree that I discriminated against you perhaps, but I was justified in doing so. Where one is alleging that the respondent has directly discriminated against the claimant, i.e. has a discriminatory intention or discriminatory prejudice, there can be no justification offered, right? That it's a kind of meaningless concept to say, yes, I didn't hire you because you were Black, but that kind of second step is entirely conceptually meaningless in a discrete interaction case. So if I can put the point slightly more simply, I think it's that in discrete interaction discrimination, there is no such thing as a justification that's possible. You can only offer an explanation that nixes the inference of discrimination. So here's a kind of more ordinary example. So if my mom complains that I didn't show up at her birthday party, it's one thing for me to say, oh no, I was just at the back, you didn't see me. That's an explanation that nixes the inference that I didn't show up in the first place. It's quite another thing to say, oh yes, well, I was on the way, but somebody on the bus collapsed and I had to bring them to the hospital. That accepts the inference that I was not at the birthday party, but seeks to justify it. And my point is that in discrete interaction cases, the sole question we are asking is whether there has been a discriminatory intention or prejudice that has infected the interaction between the claimant and the respondent. And the test as we have it now, because of its overriding focus on informal rules interacting with the protected characteristic of a complainant is blind to that, because it swings us into the ambit of justification when justification is not really the question that we should be asking at all. And I'm not sure how much time I have left. 5 minutes. Okay, great. So in the paper itself, I talk about how the courts, as far as I can tell, have struggled to understand the relationship of shakes to the test as we have it now. And I think in the paper, I describe that as a symptom of failing to recognize that discrete interaction cases are sui generis or of their own kind and should be treated with their own doctrinal framework. So, for example, the Federal Court of Appeal was asked by a appellant in a case called Bay Ferries in Lincoln to apply the Shakes test. And the court declined to do so because it reasoned that there has to be a single test for discrimination under the human rights codes. And the appellant's proposed a novel test would essentially create confusion. And after a little bit of hand waving, the Federal Court of Appeal concluded that Shakes was just an application rather than an exception of this conventional two-step analysis that we have now. And I think that's just a mistake, precisely because the logic of the two tests, the kind of way that they function, both as an evidentiary matter and just as a conceptual matter about what they are trying to impugn, Shakes cannot be a mere application of the conventional test. That has to be an exception to it. And there are other instances in which this has come up. The Ontario Court of Appeal came close to talking about the Shakes test in a case called Peters in 2015 as a separate doctrinal test, but also hesitated and said that it was a mere application of it. And this has led in those cases and others to some kind of surprising results. So there was a case where an academic launched a human rights complaint against Queen's University and sought to use the Shakes test as the basis for the discrete interaction discrimination that she alleged had occurred. And the court said that the Human Rights Tribunal, and then on judicial review, the court said, look, we agree that this calls for this separate test, but it doesn't apply in the context of highly educated person seeking a job. So the court distinguished Mrs. Ogunyankin, who was applying to be a tenured university professor, from the kind of complainant in Shakes. And that, I think, is a kind of stilted and ad hoc distinction that really shouldn't matter for the kind of discrimination that these complainants are alleging. But the courts, precisely because they don't know how to reconcile these two cases, have in that case and in a series of other cases drawn these highly artificial distinctions that don't actually track the underlying moral reality that we're concerned about. So I can, I have a series of speculations about how we ended up in this place of perhaps missing the discrimination that's right in front of our faces. But because I'm tight on time, I think I will stop here, and I'll look forward to your any comments or thoughts you have. This is all rather embryonic, so any feedback you have would be greatly appreciated. Thank you.
Thank you. And it's nice to be here today with everyone. And thank you to the organizers. Writing this paper was surprisingly cathartic in a way that I knew I needed, but I didn't think I would get out of the paper. And it's a bit of a response to one of the nice things about teaching in the first year program is that you get to experience people reading these cases all together for the first time. So it's not a 10-year, 20-year, 30-year for some people in the room exercise. It's a probably last night or the night before, and the textbook, or the week after, and the textbook starts with this nice narrative of Eldridge to Fraser, and doesn't this look good? And then this year, Sharma drops on them, and they read Eldridge to Fraser to Sharma. And they come to class and they say, what the actual? And then they say, you taught us that there's supposed to be a broad, liberal, and propulsive interpretation. You lied. You taught us that there's supposed to be a living tree. You lied there as well. Now I don't trust you. So part of this paper is a response to that. And my research looks at the intersection between the law of evidence and public law claims. And in this paper, I write about why I think proof is the biggest barrier to successfully litigating discrimination claims in Canada. And I look at three types of barriers that are interrelated: the elevated and elusive test for discrimination, the challenge of causal comparison, and finally, the problem of filling evidentiary vacuums. And I'm going to skate over some of these today because they're covered well by others this morning and on this panel. But my main claim is that these are judicial creations, and we ought to look at them as judicial creations. And when we see these barriers, we should understand that they're judicially created barriers. What that reveals about the judiciary, I'm less certain about, but I am quite solid in my view that these are judicial creations. So in this first question of the elusive and elevated test, the beginning part of my paper talks about, it's much easier to get to the justification stage in a freedom of expression claim or a religious freedom claim than it is in a discrimination claim. And those types of claims, you probably control the evidence. Your claimant has the evidence they need to show the breach of expression. They have the evidence that they need to show breach of religious freedom. Once you get into discrimination claims, you're relying on evidentiary records that are not just about your claimant, but are also about how your claimant sits within a broader society. And that makes them inherently more difficult, notwithstanding the test. And then we get the business about the unstable test. So, there's a quote from our Chief Justice who says, looking at the Section 15 jurisprudence, quote, "What they see is a transparent display of consensus building, collapse, and course corrections," end quote. It's like you're supposed to see this golden jurisprudential thread that is weaved us a nice quilt. And maybe you have to say that to become the Chief Justice of Canada. And then we get others like Professor Faraday this morning, Professor Seeley Harrington, who say, no, this is about power and oppression, and we should look at it that way. I don't try to resolve this, but I do say in the paper that my own perspective here is the unstable test. We should conceptualize the unstable test as a rule of law violation. That the rule of law is supposed to, at least in its thinnest sense, vouchsafe this notion of a stable, predictable, and ordered society. And there's nothing stable, predictable, and ordered about the Section 15 jurisprudence. You do not know what test you're going to get when you commence a Section 15 claim. This is a huge problem from the perspective of evidence. It means that when somebody walks into your office, you probably need to only run egregious claims, that there's no space for that claim that sits below the level of the egregious claim. That is often a case of substantive inequality, where we're going to have to explain to the court why this is egregious. You need the Ontario G type of case where the person is denied the exit ramp, and it's so obvious. You need the white lawyer who was denied membership in the bar, that the court will understand that as a legal wrong. So it leaves out the possibility of, it doesn't leave out the possibility of litigating these other types of claims. But for groups with limited resources, obviously people are thinking once, twice, third, or never about litigating equality claims that are less egregious. The second implication of this unstable test is that your record has to respond to the test today, the test yesterday, and the test tomorrow. And I say in the paper, I call this that your record has to be future-proof, quote unquote. You don't know what the test is going to be. Your record has to respond to what it could be. It has to respond to the zombies, to borrow Professor Young, that may resurrect at some point. And it's possible to do that, but it's hard to make those records. We don't spend enough time talking about how hard it is to make the record, both from a time and money and emotional sense. I would add that creating that record is probably where the case is won and lost, and where the money is spent, at least from an expert evidence sense. Are you going to go to legal aid and say, I'm sorry, but I actually need 10 experts because I don't know what the test is going to be. And so a legal aid is going to say to you, no, We're not funding that. You know, you might get one expert out of them, but you're certainly not going to get 10. And so this need to future-proof your record means that well, we already know that you have to be a have litigant in order to bring these claims. And of course, we can create have litigants through civil society organizations and fundraising and what have you. That also takes heavy lifting. So that's the first barrier. What it means, and this will be a recurring theme, is that the biggest challenges for bringing charter claims get higher and higher as the resources of the claimant go down and down. And so unfortunately, it means that the people with the fewest resources face the highest barriers relative to other types of charter claims. The second barrier that has already been talked a lot about today is the issue of causal comparison. And comparison's always been a part of Section 15 jurisprudence. I think you know, the Sharma majority doesn't get that part wrong, but it elevates that substantially to this notion of more direct causation. One curious aspect of the reasons for me is that they don't engage with the notion of causation from Bedford in the context of Section 7. So there, the Attorney General of Canada tries to run an active and foreseeable standard for causation. They say, you know, it's not us who are harming sex workers, it's Johns who are harming sex workers. Yes, our legal framework is contributing to this, perhaps. I don't think they actually conceded that, but that's not the standard. The standard's notion of active and foreseeable or more direct causal connection, at least in the context of Section 7, the court comes back and says, no, you're wrong. It's one of quote unquote sufficient causal connection is the Section 7 standard. We don't see any engagement with that by the Sharma majority. In fact, so they don't tell us why that's not a workable standard or why that lower threshold, you know, they pass through contribution on their way to direct causation. One challenge I think about this is that it's almost an impossible to meet standard. So even if you have all the resources in the world, even if you know, you have Alison Latimer developing your record with the support of a large civil society organization, your social science evidence is still only going to be able to deliver you correlation and a description of experience. And so even when we can look to these other disciplines for what they reveal about the truth of our society, they don't promise us causation. They definitely don't promise us direct causation. And if you're hiring a social scientist who says they can tell you that they can give you direct causation, then you probably should be picking a different social scientist to be your expert. And so that that elevation of the standard to something that social science is not able to do and not prepared to do is a problem. It's an unresolved problem. It's almost an impossible problem. Others have discussed the extent to which the Sharma majority resurrects this notion of comparator group. And I think this is so important that I have to belabor this. I think they do bring back comparator group analysis. They say that it's off the table, but what they do is rely on it. So they say, Ms. Sharma was not required to adduce a specific type of evidence. She had to demonstrate that the impugned provisions created or contributed to a disproportionate impact. So far, so good. But then they say, for example, She could have presented expert evidence or statistical evidence showing Indigenous imprisonment disproportionately increased for the specific offenses targeted by the NPM provisions relative to non-Indigenous offenders. And that's the only type of evidence that they identify as capable of meeting standard in case. So they both identify the type of evidence and they identify the relevant comparator group. And to the extent that we're all realists now, and litigators are probably the biggest realists of the bunch, we understand that when you are strategizing your case, you don't do what the court says they're doing, you do what they actually are doing. And so they may say that any type of evidence is possible, but when their only examples are specific types of quantitative comparator group evidence, you probably need to bring that in order to meet the expectation. My paper doesn't, this is a hole I need to fill, but the Sharma majority alludes to who controls this evidence, and it's almost always the state. And anyone knows the state of our ATIP or freedom of information laws presently, you know that you're not getting that data out of them for 3 to 5 years or never. And so what it means is that access to the very data, the type of data that you need to prove these types of claims is in the other side's hand, and they're not going to give it to you in a timely fashion. And then the third barrier is this question of filling evidentiary vacuums. And how much time do I have left? About 2 minutes. This is going to have to go fast. I thought I was doing well. You know, in a best world, you bring your expert evidence at trial. Well, the best world often doesn't exist in litigation. There's times where we want to add non-record or extra record evidence to a case, and the Supreme Court of Canada has a long history of relying on non-record or extra record evidence. I mean, this is not something new. They've been doing it for a long time. They're quite comfortable doing it. They say they're less comfortable now, but they've got a long track record. And to the extent that they say, we wonder why people are trying to bring non-record evidence into the picture, it's probably because they've been relying on non-record evidence in various cases for quite some time. But what I want to say is that there's actually a defensible or principled basis to rely on evidence that has not been cross-examined in the right set of circumstances, that we do this in other cases. So the principled approach to hearsay, we acknowledge that cross-examination is not the be-all and end-all, and sometimes we'll bring this evidence into a case, even though it is not being cross-examined at trial. We'll make adjustments in the context of Indigenous rights. Thank you. And there's no reason why we can't make some suitable adjustments to evidence that doesn't necessarily go to the heart of the issue, but that paints a broader picture. And I guess the last blurb I'll say, and this is going to be shorter than I intended, is that other jurisdictions allow interveners to add. And so in my paper, I look at the South African Constitutional Court, where they say, the purpose of what we're trying to do is justice to the parties. And if that means that we have to bring evidence in from an intervener, then we're going to do it. Because the core objective of what we're doing as a court is to try to do justice to the parties, not based on their resources, but based on the law and a principle of justice. The Supreme Court of the US, for its part, also brings in extensive non-record evidence through the form of amicus or Brandeis briefs with benefits and consequences. But when you see other jurisdictions doing this and the sky hasn't fallen in, I think it is revealing to where the hostility is coming from. Is the hostility coming to the claim or the type of evidence? Is it actually undercutting the trial process in the way that some judges think it is? I'm not terribly convinced that it is as dangerous as some judges make it out to be. I'll stop there.
Thank you, Benjamin. We have a little under 10 minutes for questions. Any questions? Yes.
Hi, my name is Marika. I'm from the Court Challenges Program. You might be interested because we give out money to, among other things, equality test cases. And I guess my question is from the perspective of somebody who funds cases like this, not me personally, but somebody who funds cases like this, is perhaps where do we see the issue lying? Is it become kind of an evidentiary arms race where we're kind of ramping up the sort of need for evidence? Or is it where the onus lies? And I just say this from the perspective of, from the perspective of the litigators that we work with, how do they plan? And you've obviously talked about the instability of the test and the problem that poses, but how do we even plan from a cost perspective if we are trying to level the playing field and actually give people the capacity they need in order to bring forward these cases? And in a fair way, particularly because we fund more than just Section 15, how do I make sure that I'm giving out money in a fair way, giving the right amount of money to the right cases that cost more?
I can start. I think when we look at PHS, the Insight case, that record's developed 5 years before the case. And it's developed because they see the writing on the wall, and they have relationships with professors at UBC, and so they can actually start generating adjudicative evidence in relation to the clinic before the Minister of Health makes the decision that is under review. I think what I like about your funding model is that court challenges will give workup funding. And so to the extent that there is workup funding, that could be part of that workup funding application. So we need to do a literature review and explore what type of research exists or doesn't exist. That's probably not going to be able to fund the research, but it is the type of advanced planning that takes time and effort, and that, you know, that the court challenges program fund. In PHS, all the funding comes from universities effectively for those studies. That, you know, they engage with with doctors primarily who are already funded to do this type of research, and that builds the record. So I think it's quite difficult. The second thing I would say is that, you know, as soon as you have a good record and a good case, you're getting an offer to settle. And so, you know, I'm not sure how to respond to that, except to say it is a bit of an arms race.
It's interesting listening to the presentations, because seems to be a real contradiction. On the one hand, the courts are demanding more and more evidence in order to prove discrimination, even a prima facie case. And then on the other hand, they're denying interveners, they're denying the admissibility of evidence. So it seems like there's just that contradiction. But I just wanted to throw out another idea, and that is, it seems to me, and maybe I'm thinking about the class action lawsuit idea, if one can demand as a remedy an evidence gathering process to the extent that we often, I'm thinking of the Truth and Reconciliation Commission as a part of the remedy in the class action lawsuit for the survivors of residential schools, how they brought forward their claims, but part of the remedy was to engage in further fact finding and truth telling and space for voices of survivors to come forward. So I always thought that with respect to, you know, pay equity cases, that one should be able to show a prima facie case or a little of some pay inequity, and the remedy would be across the board analysis of pay inequity. So.
Yeah, I'll just volunteer one thought that I don't think is much of a solution, but is perhaps a way of framing the problem. So I think that in the kinds of cases we've been talking about today, the adversarial system is at the heart of the problem, as it were. So the courts, so for example, in the case of the South African court that is permitting evidence from interveners, you know, that's a kind of betrayal of this idea that the two parties are to muster their own evidence and do combat from which the truth will emerge, right? So I think, and the same tension, I think, is at the heart of the issue with respect to interveners, which is, you know, if they're going to bring in their own evidence and supply their own issues, then that too is a kind of departure from the adversarial system. So I think if we're going to try to chart a way forward, it's to think about how committed we are to the full-throated version of the adversarial system, particularly in cases like these, where, as we know, claimants are the ones with less resources, and, you know, that's the whole name of the game, right? Somebody who's alleging discrimination is very rarely going to be in the position of having infinite resources to litigate these claims. And what they're confronting, I think, is a system that formally speaking, assumes that they are in as robust a position as the respondents to muster this evidence, and perhaps they need help in a way that requires rethinking just how committed we are to this ideal in the first place.
I think we might have time for one more question. Do any of our panelists have a question for other panelists? Oh, sorry. Yes, Faye, sorry.
I have a small question. You said that when you get a good enough record, then the case is settled. And I am curious whether you've had that experience, because in 30 years of litigating charter cases, I've had exactly 2 cases settle, and they settled because we strategically brought them right before elections, in which the government would have been hammered in the press. So it was the press that, right, and the election that got us the settlement, not the evidence.
I think there are cases, I think there are cases where I've seen it proceed to a motion for judgment because they would want to force you to settle.
In a charter case?
Yeah. No, obviously not on the charter ground. We want to force you to settle on some other non-administrative ground, and we don't want to deal with the charter question. But
Because I think one of the things that we haven't talked about that is really important is that governments litigate charter cases like they're the private law. And they litigate them harder, more viciously, with more strategic delay in motions than the private bar does. And as a government when the government has the role to uphold charter, it's a very it's a litigation strategy that's ill suited to that role. And I would just let people know that the UN Committee on Social, Economic, and Cultural Rights has actually found that the government's litigation strategy in charter cases is contrary to their obligations in international law. And that is something that we should be raising again.
Well, please join me in thanking our panel. That was really nice.
Again, I'm Cheryl Mill. You've heard me speak now many times. We call this panel sort of case comments, but and I think that gives it a bit of short shrift. It's more than just a comment on cases, although we're going to start with one that's a very particular case, but I think we have just other sort of substantive comments that come through these cases. We'll start, our panelists are Marian Sandilands and Abdallah Barkawi will start, and they're from the law firm Conway Litigation in Ottawa, but their paper was also written with Thomas Conway and Joseph Ritchie and Sarah Nixon as well. So we have a whole team, and I think they're all on Zoom joining. And it will be followed by, we don't have another head up on the screen behind me, and there he is, Anthony Sangiuliano, who is currently serving as a law clerk at the Supreme Court of Canada and is an incoming postdoctoral fellow at the University of Toronto Faculty of Law. And then finally, Jonathan Thompson, who is an Ottawa-based lawyer experienced in criminal and regulatory law, and is a graduate of Osgoode Hall Law School and has a Master's of Law. He's a Master's of Law candidate at the University of Ottawa Faculty of Law. And so we'll turn it over to Marian and sorry, Abdallah. Sorry. Go ahead.
Good afternoon, everyone. I am joined actually by one of our other co-authors, Joseph Ritchie, who's in the room. We all came over from Ottawa this morning. We're excited to be here. The reason there's so many of us is because we were all co-counsel on a case that's still happening called Metro Taxi versus City of Ottawa, and that's what our paper is about. And I guess it's kind of an unlikely sight maybe for a section 15 claim. But hopefully by the end of our presentation, you'll be sold on it and excited to find out what happens. So this was a class action that was filed back in 2016, just to give you a sense of how long these things take. So I'm sharing my time today with my colleague Abdullah Barkawi. I'll introduce the case, give a bit of background, and I'll hand it over to Abdullah to talk about the evidence that we brought at trial. And hopefully, and I'll depend on the Q&A session for you to give us insights on how this fits in with what's going on generally in the Section 15 world. So just to introduce the case itself, what it's about is about the lost revenue and really life savings of people who own taxi plates in the city of Ottawa following the illegal entrance and then the legalization of Uber and other types of transportation companies, which happened also in Toronto as well as Ottawa. So the plaintiffs, it's a class action. The plaintiffs are taxi plate owners, which I'll explain what that means, and also taxi brokers. And it's a claim for damages against the city of Ottawa for the city of Ottawa's regulatory response to Uber. So allowing it to operate illegally and then legalizing it essentially. And the premise being that that regulatory response led to the devastation of the taxi industry, in particular, the loss of the life savings of taxi plate owners who invested in these taxi plates at great cost. So there were several bases for the claim. It wasn't just an equality claim. It actually started out on different bases, including things like negligence. The city were alleging this was negligent in enforcing a bylaw against Uber. There was a claim that the bylaw, when the city changed the bylaw to legalize Uber, that was unlawful. And there's a claim about the fees that are charged to taxi industry participants being unlawful tax. So there's a bunch of different claims going on. And there's also a Section 15 claim. And the claim is that the city's regulatory response discriminated on the basis of ethnic origin and race. So to give you a sense of the time frame here, it was filed in 2016, which is the year that the city legalized Uber. It was certified, class action certified in 2018. And the trial happened early this year, 2023, January and February. And if you think about the years there, both Fraser and Sharma happened after the certification and before the trial. So when Professor Perryman was talking about meet the test from yesterday, today, and tomorrow, that's the boat we were in. So to give you a bit of background on taxi industry and what this claim is about. So just like in the city of Toronto, the city of Ottawa regulates the taxi industry, and in particular, you need what's called a taxi plate license in order to operate a taxi. In New York City, they're called medallions. There's a similar kind of systems in different cities, and that's a way for the city to control the supply of taxis. And because there's a limited supply and they're transferable from person to person, by the laws of economics, that creates a market. And so these are traded privately and they have market value. So that's sort of thing one to understand. Thing two is that the industry in Ottawa, as in any major North American city, is overwhelmingly populated by people from various disadvantaged groups. In Ottawa, we see racialized and immigrant participants, and we actually had to prove that fact, but I'll get to that in a minute. And thing number three, Uber entered the market illegally back in 2014, earlier in Toronto. And the city changed its bylaw in 2016 to essentially legalize Uber. And all of this together was devastating for the taxi industry in Ottawa as it was anywhere else. There was a marked loss in taxi ridership, obviously. So the income of taxi drivers and also taxi plate owners dropped. And so that's sort of the third kind of major element that goes into our case. So there in 2016, as I said, they brought this class action. And there have been other similar types of litigation in other cities, including Toronto. But as far as I know, ours was the only one that includes a Section 15 claim. So it's unique. And as far as I know, it's the only one that's still survived hasn't been dismissed. And so right now, at this point, the trial is done. We don't have the judgment yet. So this is a comment on what happened at trial, but we don't know what the ultimate judgment is going to be. And I'll quickly just cover the logic of the Section 15 claim, and then I'll hand it over to Abdullah to go into the evidence. So I think this is definitely an adverse effects discrimination claim. So there's three main elements to it in terms of the logic. The first is that the class is overwhelmingly or disproportionately, depending, racialized. So it's overwhelmingly made up of racialized individuals and immigrants. About 90% of the taxi plate owners and class members were born outside Canada, for example. It's very marked racialization and immigration. And element number two is that these same racialized groups, so the ones in Ottawa that we found were South Asian, Arab, Black, and West Asian primarily, very clustered. And these same racial groups are measurably subject to systemic inequality in Canada. We brought evidence about that as well. And then the third element that we're alleging, the city's lack of enforcement and the bylaw change had an adverse impact on the class, and it worsened their disadvantage. So those are the kind of the three elements of the logic that we're bringing. I'll just touch on the city's defense because it will tee up the evidence that we brought at trial. So they're bringing a number of defenses. One that's interesting that they pleaded was that the city of Ottawa had no knowledge of the racial makeup of the taxi industry, right? So we had to prove that. The second, another defense that they're bringing is that the enforcement of the bylaw and the change in the bylaw is not connected to race. It's quote race neutral, thus not discriminatory. And a third element that has emerged in the city's defense is that other groups in the taxi industry, such as taxi drivers or Uber drivers, are also probably racialized, and they may have benefited from this change. Therefore, there's no discrimination against taxi plate owners. So that tees us up for trial, and I'll hand it over to Abdullah.
Thank you, Marian, and good afternoon, everybody. I think I have a few minutes, so I'm going to try to be as quick as possible because I have quite a few things to say. I want to start by talking about the mode of a class action, because the way a proceeding is structured actually has a lot of impact on how the evidence goes in and how the case moves forward, and how the case is put together. And this was mentioned earlier today that, you know, a class action might be a good idea in the future for Section 15 claims. I actually think even if it's not a class action, if it's just an action, it's better than a regular application, which typically on charter claims. That's how they proceed. And so I'll explain a few rationales for why that is and where appropriate, how that applied in our case. There are a number of benefits. One of them, for example, is funding. You can get funding for a class action. You can't get funding for a regular proceeding. That's a tort, at least in Ontario. Another benefit is you get discoveries in a regular action where you don't get that on an application. It's just by affidavit evidence. And because you get discovery when you're in a situation like we were in, where the city says, well, we don't know who you people are. We got to get documents from them and to examine them on discovery and see what kind of evidence that they have and to help us mount our case. And that actually ended up being quite helpful for us because we had to retain an expert to prove quite literally the identity of our class members. And the city of Ottawa just so happened to have a list of people that includes all of their names. And we retained Mike Ornstein. He's a professor at York University, and he analyzed the data and categorized the class members into what kind of race or ethnicity they belong to. So without But without that process, the ability to go and examine and get the documents from the city of Ottawa, we could not have gotten that information. So that's one benefit. The other benefit is when the city actually went to trial, one of their key witnesses ended up admitting that the makeup of the industry and that it is racialized is not debatable, because it was so overwhelming and so in your face that it would have been really embarrassing for the city to say, we didn't know that the people who bought places are racialized, or the people who work on in the taxi industry are racialized. So that was a very significant benefit. The other benefit, and it goes to a point that Faye raised earlier, is and that's the tendency of the government to, litigate like any other private actor does. And in our case, that was true. It was a hard fight from the very beginning until the end, till the last day of the trial. That's how it ran. That's how every other private file that I've ever run has been. They're hard fought. Just because it's a government on the other side doesn't make a difference. Or I mean, at least in the case that we had. But what the class action mechanism did for us is that it comes with case management. And so there's always a case management judge who's appointed and guiding the case from beginning to end. So that the delay tactics that could happen in other cases are less likely to happen in a class action proceeding, because the judge is involved from the beginning. So those are some of the benefits from having an action or a class action. Let me just talk a little bit about the another benefit that it comes through the evidence, and that's as opposed to an application. When you're doing an action and the case isn't settled, and ours did not, you go to trial. And the beauty of that process is that it's very human. And you have a trial judge sitting there listening and being exposed to the evidence, learning on the go, and becoming familiar with the case in a way that there is no way, it's impossible to do that on an application. No judge reading an affidavit and cross-examination transcripts will be able to get an appreciation of the evidence in the same way as it is when there's a human being in front of the trial judge explaining their evidence. That applies to expert witnesses. If anybody would have seen Mark Ornstein in our trial, he was fantastic. The way he explained the case, he explained the background of the class members in a way that they themselves could not explain, because he was able to aggregate and say, well, 60% of these individuals are from the Middle East, or from India, or from this place, or from that place, and they belong to disadvantaged groups, and this is where they fall in as compared to others. He was able to explain why it is that these groups end up dominating the industry, and how they tend to ask family members and friends, and they come here and they struggle and they can't find jobs in their field, or according to their education, because of their education not recognized, or because English is not their first language. And so he was able to explain that at a macro level that no single individual plate owner or class member that we had was able to explain that. And as far as we were concerned, and obviously we were somewhat biased in this process, he did a fantastic job at doing that. And it would have been incredibly difficult, if not impossible, for the judge to get what he got from the expert just from reading his expert report, or an affidavit, or a cross-examination transcript. And the same applies to other witnesses. So we ended up calling a sample, a very small sample. There's more than 1,000 class members in this case. We brought in four of them who had immigrated to Canada and bought a taxi plate in Ottawa to tell their stories. To tell the trial judge who's going to decide in their case whether they were discriminated against, which quite frankly is a very personal determination, what their story is what happened to them, why they bought a plate, how much money they put into buying the plate, the struggles that they had to go through to get the money to buy a plate, the struggles they had to go through to come to Canada in the beginning. And some of the stories were heart-wrenching because there were immigrants coming from war-torn countries who had to go through a lot to come to Canada and to survive. And in the end, they made the investments, and they were extremely affected by what the city of Ottawa did to them. And without them being there, there is no way that trialers would have properly understood what the evidence is about and what the case is about and the impact of what happened to them is. And that's, in my opinion, in a way, yes, we have tests for Section 15. Is it important? Yes, we had to meet the evidence. It's our burden to meet it. But at the end of the day, the trial is a human being. And whether he in our case, whether he agrees with us or not, there is no way he can convince a judge to be with you unless the facts drive that. And an action is the only way to do that. And a human process is the only way to do that.
Thank you. Thank you, Abdallah. Thank you, Marion. I want to turn it to Anthony now. On the screen.
I took your role by mistake.
You're at the end, so we've got Anthony next.
Oh, okay, thank you. In that case, I'll
We
proceed.
can't hear you, so I think you're mute.
Can you hear me now?
Say he's muted.
Can you hear me now? Okay.
Not yet.
I'm online and I can hear.
Oh, okay. You can hear me, Justice Feldman?
Oh, we can hear you now. Thank you. Thank you, Justice Feldman.
Okay, I think I've disappeared from, there I am.
Yes, you're here and we can hear you. Thank you, Anthony.
Shall I proceed in that
Yeah.
case? Okay, so, and thank you for letting me join virtually despite these occasional tech hiccups. So I've written a case comment on Justice Miller's dissenting opinion in Sharma for the Court of Appeal. And this choice of focus, I'm sure, is bound to raise some eyebrows. But stay with me because I think it's worth focusing on this dissent. That's not because I would commend it as reaching the right outcome when it comes to the Section 15 aspect of Sharma. And it's not because I think it helps us even better understand the opinion of the Supreme Court majority, which reached the same outcome on Section 15. I commend it as offering a novel, intellectually rigorous, and instructive attempt to map out the purpose of Section 15. Of course, the model that the dissent provides in this respect is congenial to government advocates in Section 15 adjudication, but that's besides my point too. My point is that it provides a principled foundation for accepting what in the comment I call a demanding view of the Section 15 test, one that imposes heightened burdens on the charter claimant. But I think it's at this level of principle that the current discourse on Section 15 needs to live at to avoid the kind of ideological and outcome-driven factionalism about equality that has already been highlighted in this symposium. If we're going to avoid factionalism, it won't do to simply reject Justice Miller's interpretation because it reaches the wrong results. Rather, for claimant advocates, I think it's best to challenge it on its own turf and engage with the investigation of the deeper roots of Section 15 that it tries to do. And a key point that I try to make in the comment is that it's certainly possible to embark on this investigation and develop a conception of the purpose of Section 15 that supports a generous view of the Section 15 test that removes burdens from the charter claimant. And I think that claimant advocates can get a handle on this by appreciating and reflecting on the moves Justice Miller makes in the Sharma dissent. So then my remarks do try to resist the sort of skepticism we've been hearing about earlier about the possibility or impossibility of conceptual coherence and clarity under Section 15 and of a rigorously formulated Section 15 test. So I see this sort of investigation as a much needed tonic for divisiveness rather than just more fuel for the fire. So to begin, Justice Miller, by way of overview, does three things, I think. First, he critiques the idea that Section 15 of the Charter promotes substantive equality. Second, he argues that Section 15 is meant to prohibit what he calls wrongful discrimination that the state is at fault for perpetrating. Third, he argues that to prove that the state was at fault for wrongful indirect discrimination, a claimant has the burden of showing that any disadvantage the impugned law imposes on a marginalized group is not proportionate to the common good that the law pursues. I won't spend too much time on the first point, but in a nutshell, Justice Miller claims that the concept of substantive equality that is supposed to inform the purpose of Section 15 has never been clearly defined. At most, it has been understood in contrast to what it is not, mere formal equality, but substantive equality has not been given a positive definition. Regardless of what we think of that, the critical next question, if he's right, is how do we spell out a positive count of Section 15's purpose? And here, Justice Miller says that the purpose of the provision is to prohibit wrongful discrimination. Wrongful direct discrimination is committed, he says, when a prohibited ground figures into the deliberative process leading up to a legislative enactment. The fault standard is subjective intent then for direct discrimination. Wrongful indirect discrimination is committed, according to Justice Miller, when legislation is intended to pursue a perfectly laudable common good, but in doing so, the legislature unfairly accepts negative side effects on groups marked out by the prohibited grounds. Here, the fault standard, is not subjective, it's objective, it's negligence. The state fails to consider the negative side effects of its enactments, and in so doing fails to treat those who are disadvantaged by a law as equals. So Justice Miller rejects the idea that the imposition of disadvantage on marginalized groups alone is capable of establishing that the state is at fault for wrongful discrimination. This would be, he says, a non-fault standard of absolute liability. But the point of Section 15 and his account rests on, I think this is the essential takeaway. The point of Section 15 is to condemn the legislature or hold it culpable, as he says, for a certain kind of wrongdoing. In indirect discrimination cases, the wrongdoing of negligence. For Justice Miller, for the claimant to prove that the state is culpable for indirect discrimination, they have to show that the common good fails to justify the law's negative effects on vulnerable groups. So in order to get at this fault of negligence, some consideration needs to be given to the good that the law is intended to pursue. That's the only way to show that the state was blameworthy for failing to treat the claimant's group as equals when acquiescing to negative side effects on it. And I think this comes out pretty clearly in how Justice Miller approaches the impugned legislation or the impugned amendments in Sharma. He says that making incarceration the default sentence for serious crimes like importing cocaine is an important common good, and that Parliament was not wrongfully negligent in accepting the negative impact this would have on Indigenous peoples over incarceration, because this common good was proportionate to that negative impact. And moreover, Parliament, he says, must be able to repeal ameliorative laws, such as the provision of conditional sentencing for Indigenous offenders in some circumstances, if it sees this as best promoting the common good, even if the repeal creates a disadvantage for the ameliorative law's beneficiaries. So we see that Justice Miller's fault-based, culpability-based conception of Section 15 as aiming to prohibit wrongful discrimination leads him to accept a demanding or burdensome view of the Section 15 test. And I think this conception is, to borrow a metaphor, the virus reanimating the zombified corpse of some supposedly dead principles for interpreting Section 15. This sort of idea is what is, I think, the brain of the zombie. Think of it this way, for example, it seems to have been thought by some members of the legal community, how can the state be held at fault or culpable for wrongful discrimination if it has not caused the claimant disadvantage, caused disadvantage for the claimant's group, if it has attempted to ameliorate that disadvantage, or if its laws correspond to the claimant's needs and circumstances. So again, I'm not saying that Justice Miller's fault-based account is correct, but I think what's commendable about it is its form, not its content. It can be seen as seeking to break the outcome-driven stalemate between demanding and generous views of Section 15 by exploring and mapping out the principled foundations of constitutional anti-discrimination. That form is what I think is commendable to Section 15 advocacy and litigation. The specific content of the dissent is useful for government advocates because of how it supports the demanding view of Section 15. But as I said earlier, I think it's also possible for claimant advocates to maintain the same form of the dissent, offering or developing an intellectually rigorous reconstruction of the purpose of Section 15, while rejecting the content of his view of that purpose and replacing it with a different content, one that supports the generous view. And I'll close by suggesting how I think this kind of feat can be accomplished. I suggest that the way forward is to think through an account of the purpose of Section 15 that explicitly rejects the fault-based conception of the provision that Justice Miller sought to affirm. And so on this account, Section 15 is not meant to ascribe responsibility or culpability to the state for perpetrating disadvantage suffered by marginalized groups. It's not to blame or condemn the state for any sort of wrongdoing it committed in the past, even if, as everyone might accept, the state did in fact commit some wrongdoing or contribute to it. Rather, I think the flip side is to explicitly conceptualize the function of Section 15 as a tool for calling on the state to take responsibility and to take the initiative to either justify existing social norms, patterns, or structures that disadvantage vulnerable groups, or else transform or reform those norms. And to get the state to take responsibility, it is unnecessary that the state caused the targeted norms to exist or is otherwise culpable or at fault for their existence. Indeed, it best promotes the instrumental transformative purpose of Section 15 to only require the claimant to prove on an absolute liability standard, the sort of absolute liability standard that Justice Miller was anxious to avoid, that a marginalized group is disadvantaged by a law, and that for that to be sufficient to shift the burden of justification to the state under Section 1. So in summary, if Justice Miller's fault-based conception of Section 15 in Sharma supports government advocacy, explicitly rejecting it in favor of an instrumental or transformative conception should support claimant advocacy and a generous view of the Section 15 test. Thank you.
Okay, there was a method to my madness of putting you in the middle so that there wasn't a pile on of questions at the very end.
Thank you.
I was just looking at the puzzled looks at some people, so I expect you're going to have some questions about your theory. But turning it over now to Jonathan for the last presentation. Thank you.
Thank you. Good afternoon, everyone. My name is Jonathan Thompson, and I am an LLM candidate at the University of Ottawa. I'm expecting my degree in 2 weeks in case anybody wants to hug me later and tell me that that would be great. And I'm also, I have to make this joke, I'm very sorry. I spend a lot of time with my toddler, and I'm so excited to be presenting something that is not the pout fish. Yes. That was like a 2%, or I got it complicated. I am interested broadly in what the interaction is between the equality guarantee in the Charter and the law of prosecutorial discretion. And I come at this by being primarily a criminal lawyer, although my practice has shifted to a regulatory focus now. And before I start, just for the sake of my own curiosity, I wonder if you'd indulge me. Could I ask of the people in the room, and I don't know if people online would like to participate as well by using the hand raising emoticon, but can I just ask how many people in the room would primarily describe, when you introduce yourself at parties, how many people lead off, if you do, how many people lead off with, I'm a criminal lawyer, if criminal law is your primary area of practice?
I don't get invited to parties.
You have the best stories. And I saw one like sort of tentative hand back there, and I get that. And I'm terrified to be here, and the reason for that is I'm a criminal lawyer, and if you ask me what my expertise is with the equality guarantee, I would say it's expertise. I wouldn't use that word. I say I have a familiarity with it. I've read it, but by and large, the equality guarantee actually hasn't really penetrated the criminal law in deep and meaningful ways. And I have some theories, and this has been the subject of some academic commentary, but that's my starting point. And I apologize because what's about to follow from this point is you're going to hear me talk to you a lot about what I don't know. And there's one point where I'm really liable to heckling. You'll see when it happens, but I apologize. This presentation is a very big what if followed by a then what. I have lots of questions, I have ideas, and I have no expertise, as you're about to find out. And I don't have answers. And I'm excited to be in this room with so many very educated, informed, expert people who I hope can assist me in thinking through some of these thoughts. So I'm interested in criminal law and prosecutorial discretion, especially when it's examined along the lines of anti-Black racism in the criminal justice system. I'll pause here to say that I don't spend a lot of time dealing with anti-Indigenous racism in the criminal justice system. And that is because to the extent, I think anti-Black racism is actually a very good lab to look at the equality guarantee, because in the criminal jurisprudence, I think it's pretty well accepted that there's a different methodology for Indigenous criminal justice. Whether that is, correct legally, morally, and effectively, I mean, that is a whole other topic that won't fit in the 12 minutes that I'm speaking to you. But I think it's good to start with anti-Black racism because at least as recently as Morris in the Court of Appeal in 2021, we learn that there's no sort of separate methodology for Black people in the criminal justice system. The system should be enough to solve systemic racism on its own. And that's also problematic, but let's not dwell there. I aspire to be the first person to fit Tupac Shakur into a law review article in Canada. But the quote that keeps rolling around my head is, it ain't a secret, don't conceal the fact, the penitentiary's packed and it's filled with Blacks. That's the present state of Canadian criminal justice. And I'll throw some numbers at you. I would urge you to read the work of scholars who do this. Kwasi Wusubempa, Scott Wortley, Kanika Samuels, Robin Maynard's book, Policing Black Lives, but the numbers are very stark and obvious that there was a huge demographic explosion of Black incarceration in this country between 2005 and 2015, where the Black federal prisoner population increased by 69%. While Black Canadians make up 3% of the population, they account for 9% of the prisoners in federal correctional facilities. Black people make up 3.9% of Ontario's population, constitute, however, 17.7% of admissions to Ontario's correctional facilities. I could go on and on at length, but I think generally we accept that we have issues with systemic anti-Black racism in criminal justice. But the real problem is, as Canadians, we really have this view that the criminal justice system is this machine and we pour evidence in the top and results come out the bottom. And we ask for parity to take place. And maybe it does, maybe it doesn't. And then we have these results that we can't otherwise explain with reference to the system itself. There's something else going on there. There's some mechanism of discrimination that we can't explain. So by way of a very long introduction, I'm really concerned with three questions. And this is where I'm, again, liable to be heckled. The first is the exercise of prosecutorial discretion bounded by the Charter's equality guarantee? Good. Two, if so, what does a charter breach look like in this context? And three, what type of legal and policy responses can be employed to give effect to substantive equality in Canadian criminal law? Excuse me. Okay. First, just briefly, there's been this historical non-penetration of the equality guarantee into Canadian criminal justice. It just really doesn't figure into the criminal law milieu, except in limited and discrete ways. The phrase equality light has been used in that legal scholarship. Rosemary Carentway is, I believe her phrasing is that it's been subordinated to a second order right. So we see often in the criminal context, the equality guarantee is employed to look at, as in Sharma, about the availability of particular types of sentencing regimes, or looking largely at police conduct, or as really a type of guiding principle that affects the application of other constitutional rights and remedies. But the baseline presumption of the criminal justice system, as Joshua Seeley Harrington wrote in a piece for the Defense of Critical Racial Profiling, it was the sort of liberal doctrine of the criminal justice system is that it's presumed to be neutral and just. The difficulty is we know, though, that it nonetheless produces these disparate results. Where American scholarship is very far ahead of Canadian scholarship is first in the in the collection of disaggregated racial data in their justice system. And second, with a very clear recognition that prosecutors drive a lot of the decision-making that produces these types of downstream results. We're not there in Canada. We're really stuck in first gear in terms of presupposing that judges and prosecutors and defense counsel and police are for the most part racially neutral actors. And the real difficulty is that in sustaining any type of equality claim based on the disparate results really would falter from the get-go because we can't really identify what these mechanisms of inequality are that happen in the middle. Is it about distribution of harms versus distribution of benefits to other groups? Is it about implicit bias? We just really don't have this data. And why I think Fraser has changed the seascape in terms of the criminal jurisprudence is Fraser has this language, and I'm certain that this is an unintended consequence, and I'm certain that this was really never meant to match one-to-one to the criminal justice system. And I think this filters into what other people have stated throughout the day about the somewhat ad hoc nature of the equality jurisprudence. But Fraser, I think, fairly read, tells us that the equality guarantee applies both to laws as well as state actions. Fraser tells us that for the last time, it's not formal equality, it's substantive equality. Fraser tells us that, in fact, you don't actually really need to know what the missing middle mechanisms of inequality are. It's sufficient to prove adverse impact discrimination with reference to the inequitable results at the end of the process. So I think there's something here that tells us that an adverse impact discrimination claim can be proved in reference to Canadian criminal justice. And I think prosecutors are particularly liable to claims of adverse impact discrimination because their decision-making drives who is prosecuted and for what. Will a guilty plea be accepted and to what offense? Prosecutors have the power to recommend sentences and joint positions. Prosecutors have the power to send things into pre-charge diversion programs. And these are all sites that are ripe for examination if data can ever actually be found. I'm wary that I've spent a little longer than I intended to, so maybe I will cut to the chase. And the hypothetical that I want to use as a lab, and again, we don't really have the data, but I think it could be cobbled together from various sources. And this is the what if. The what if is in a single jurisdiction, if we take similarly situated accused people before the courts, so similar charges, similar backgrounds, and respective criminal record, for example. What if we found a racial disparity between Black offenders and all other offenders, for example, in who was referred to a pre-charge diversion program? And what if that number was significant and could not, the disparity was significant and couldn't otherwise be explained? And isn't that a case of maybe direct discrimination, but certainly adverse impact discrimination at the end of the day? And does that represent a violation of either an individual's rights or a whole claimant group's rights vis-a-vis the prosecutorial decision to refer things to a diversion program? Historically, prosecutorial discretion is treated as sacrosanct by the courts, and there's a whole body of case law that essentially says that the judiciary won't supervise matters within a core area of prosecutorial discretion. And I think that is tied into this broader question of whether and to what extent can the judiciary supervise the executive in its exercise of the Crown prerogative. And in the context of prosecutorial discretion, the Laws Act is ironclad and very clear that within core matters of prosecutorial discretion, such as who to send to a pre-charge diversion program, prosecutorial discretion is not to be interfered with. However, again, in a different context, we look at, for example, Cotter and Canada in 2010 in the Supreme Court, where it's made very clear that the exercise of the Crown prerogative over foreign relations has to take the charter into consideration. So, and as to what the remedy is, that's a whole question for another day. But I've gone far over the time that I intended to, and I have more to say. But ultimately, I think where this is leading is a policy realignment in respect of Crown charging policy. I do believe that the most effective changes and the areas where there is the most potential to even things out in respect of equality is not necessarily in what apex courts have to tell us, although that is of course crucially important, but in how these constitutional aspirations find their life in the expression of policy. It's very disappointing to have, I think the consensus in the room is the result in Sharma is disappointing at the end of the day, but Sharma is ultimately, one charge out of about 200,000 that are received by Ontario courts in any given year. So I think there is some real potential if the equality guarantee is given new life in the field of prosecutorial discretion. Gone over time. Thank you so much, and I'll invite your questions when it's my time.
Great, thank you, Jonathan. So do we have any questions? Yeah. See, Carrie's got her hand up first of all.
The question is for Jonathan, and I thought that was a really, really interesting presentation. It caused me to think about things that I haven't really thought about. And so my question is kind of twofold. Number one, like, how does this fit into the hands-off of prosecutorial discretion? Is there a constitutional element to that, with the same way as parliamentary privilege and the fact that you can't have judicial review there? Like, maybe you can give like us non-criminal people kind of a primer to see how your theory fits in. And second of all, I've always liked Justice Iacobucci's dissent in Little Sisters, where he talks about if you have customs officials with no guidance on how to assess obscenity, and therefore discrimination results, then potentially that can be attacked. Like, if without guidance where there should be, that's kind of a charter violation of Section 15 potentially. I'm wondering what you thought of maybe using that kind of theory for prosecutorial discretion. There should be guidance, right?
Thank you. These are very good questions, and do you mind? Can I actually take them in reverse? Because I think thematically that's so in terms of policy guidance, there's a case called Anderson, which was decided by the Supreme Court in 2014, which was about the Crown's discretion in choosing to file a notice of increased penalty for a graduated sentencing scheme in respect of impaired driving. And the question was whether the Crown was constitutionally obligated to take into account the accused's Indigenous status before choosing to seek a greater penalty. And ultimately, the Supreme Court said, no, this is part of the core aspect of prosecutorial discretion that doesn't garner interference or a remedy. But at the Newfoundland Court of Appeal, and I believe Justice Rowe took part in that decision, in finding that there was a breach in the Court of Appeal, the lack of policy guidance was, I don't know if it was solely determinative, but it was an important part of the factual milieu. And so if I were called upon to advise the Attorney General of whatever jurisdiction, I think the easiest thing to do to avoid liability is have a policy. And that is actually, there's a gradient of Crown policy across the country about, first acknowledging that does racism exist, and then, is racism that solely exists to prevent Crown attorneys from being discriminatory in their decision making. And then sort of this last category, which is sparse, but getting bigger about, systemic racism exists and here's what you ought to do about it. So I think I agree that it would be very helpful to have that kind of policy guidance. And, how does that fit into the sort of the hands-off constitutional element? I don't really know. And it's this sort of question is in the hypothetical of, let's say we did see a big disparity in terms of who gets diversion and who doesn't. There's kind of this bigger ticket question about, an individual who, the allegation that they committed a particular act, is that person entitled to a constitutional remedy based on group characteristics and discrimination that has happened to other people and not them yet? It doesn't really map over one-to-one, and I just don't know, but I can't shake this feeling that at the first instance, there's an equality problem here. And as to, what contours it takes in terms of being proven and what a potential remedy could be. I think that's the very, very complex part. And I wish more people were thinking of writing about that kind of thing. That's a wonderful questions, and thank you very much.
Kim at the back.
Yeah, it's actually just a brief comment. If it makes you feel better because you were intimidated by the crowd, I wanted to stand up and cheer when I heard that you wanted to talk about prosecutorial discretion. It is an area that is in desperate need of sunlight. And for years and years and years, I have wished that someone would do a PhD on it. Cheryl and I, in the factum that I talked about briefly earlier in Cacophonous, we had an uphill battle to convince our fellow equality seeking people that we should intervene in that case. And we had a hard time finding stuff to, like Rosemary Cairns Wade's work was some of the only stuff around for us to be able to say what we know to be true, which is that criminal law principles should be considered in light of substantive equality principles, like that's how they should be interpreted. And the way that Crown prosecutors can just even, is it summary, is it indictable? That decision is not appealable and requires a huge amount of sunlight on it. And so what you're talking about to me makes a ton of sense. Please keep going with it.
I need to bring that up with my wife.
Yeah, no, it's a really important area. Thanks.
Thank you, Kim. The Asper Center also intervened in the Anderson case, and it's one of those cases that you just kind of shudder and say it was so wrong what happened in that case. And because it was about, I mean, at the center of it was talking about Gladue principles being, having to be considered when there was the seeking of a custodial sentence, and they said, no, that's further down the road and it doesn't go into the election and the election for mandatory minimum in that case. So it was a very frustrating case to be. So it is a huge hurdle for what you're saying. Are there any other questions? Sabaya has a question. So I have a question for Marion and Abdullah. As you were describing the background facts and the background structural inequalities that related to the discrimination faced by taxi drivers, I was thinking again about this fact that I think is always in the room, but we haven't talked a lot about it, which is that very often, although we are all trying to fight inequalities through litigation, often the desperate situation of the groups that we're trying to advocate for has resulted from, as we've talked about, a variety of structural inequalities that can't themselves necessarily be eliminated through litigation. So, I mean, in this case, it seems that part of the problem, or part of what led to this situation, is that taxi drivers face so many barriers to employment in other areas of society. And we do a terrible job, for instance, of recognizing foreign credentials in a whole variety of different areas of employment. So people are driven to drive a taxi. And that's not the whole of the problem, of course, but that's a part of the puzzle that doesn't get dealt with through litigation, but that we need other people to fight for changes to eliminate. So I guess I'm wondering if you could speak to some of those background inequalities and to the need, I guess, to bolster what we're doing today and what all of us do in our ways through litigation with a political advocacy for change of a variety of sorts.
So what you're talking about reminds me of, I mean, there's an existing structural inequality that would exist whether or not whether or not Uber came or not, right? We're starting from a structural inequality. And what was interesting about what emerged in our case was that making that leap from taxi driver to taxi plate owner, investing that capital was for these individuals a way to claw themselves out of the structural inequality that they were facing, and that was their path to prosperity. And we saw actually over generations, because we went 2 or 3 generations, and the older generations of plate owners were people like francophones, were Hungarian Jewish refugees post-World War II who had made the same journey and become plate owners 2 generations ago. But anyway, I digress. But what we, so the theory that emerges here is this, by sort of callously casting aside this entire regime and allowing it to disappear, the city had, there's been sort of a ladder that was there, and it was basically cut.
Very nice.
And so that's the equity that we were trying to bring forward.
Yeah, exactly. I just want to give an example of, I think Mary's answer is perfect and complete, but as your question kind of brings a story to mind. We had one of the plaintiffs was from Afghanistan, an engineer, and when he came here, he could not find a job in engineering, and so he went back to school and did all this kind of stuff. And English was not his first language. He had 4 other languages, but not English. And you know, you can tell his frustration from the beginning of the case in 2016. He was examined for discovery. He's just like, I've been discriminated against every day since I came here. You know, from day one, I tried to find a job. I have it in engineering. They told me I qualify, and I could not get a job. And then, so they said, go get a degree. So I went and I got a degree, and then I went to do it, and they told me I don't have Canadian experience. And then so how do I start? I can't get Canadian experience because I don't have Canadian experience. And so you can tell all of that, and it's part of the. I think it's actually part of the Section 15 claim against the city of Ottawa in our case, because it was. Why shouldn't that be a part of the government's obligation to understand the people that they're regulating in this case and how their conduct is affecting that population?
So time for one last question. I noticed that Jennifer's hand was up.
Thanks, Cheryl. This is a question for Anthony, so you are going to get that question after all. I'm interested in just hearing a little bit more about how you conceptualize what you refer to as a form and content piece of Justice Miller's decision at the Ontario Court of Appeal in Sharma. I think I'm pretty clear on what you're saying the content is, but I'm not, especially to the extent that you're saying the form is what matters and the form can be used in different ways with different content. I just want to make sure I really understand what you're saying about the form of his reasons.
Thanks, Jennifer. And unfortunately, it's too bad that this wasn't an opportunity for us to meet in person, I guess, for the first time. I actually didn't use the language of form and content in the written version of the comment, but just kind of thought it was a useful way of speaking about it for the presentation. So, but the way that I'm thinking about it is just form is focusing less so on insisting on a particular outcome in a given case, but more developing an account of the principled foundations of the purpose of Section 15 in a way that helps produce those outcomes. And I think in particular what I have in mind is, can we, as I was trying to get at in the talk, can we develop an account of those principled foundations that get us to a test that has as few burdens as possible on a claimant, without having to rely on the idea that a test with fewer burdens on the claimant is just going to produce the right results that we want. Because my worry is that that sort of outcome-oriented reasoning has the potential to provoke backlash and produce equally outcome-oriented reasoning in the opposite direction that doesn't necessarily help us clarify the purpose of the test, but ends up kind of perpetuating this sort of ideological factionalism I mentioned. So when I think of form, I just mean trying to develop a link between an account of the purpose of Section 15 and a test that has more or less burdens on the claimant. I think that Justice Miller's, the form of his account was to develop a negligence-based view of indirect discrimination that was linked to a more demanding, burdensome Section 15 test. And the opposite that I envision is an account that just draws a link between the purpose of Section 15 and a more generous Section 15 test. I hope that answers your question.
So that draws us to the end of our panel. I want to thank our panel members for All very interesting things, we've been talking about today, so thank you so much. We now
Well, I'm very honored to introduce our guests who will be participating in our final session today, in which Justice Catherine Feldman will moderate the conversation with the Honorable Lynn Smith and the Asper Center Executive Director Cheryl Milne on the status and the future of equality rights litigation in Canada. I'm just going to briefly introduce each of our three guests, and then I will turn it over to Justice Feldman to moderate the conversation. So Justice Feldman is, of course, well known to us for her rich and insightful Ontario Court of Appeal judgment in the case of Sharma. She was appointed a justice of the Ontario Court of Justice in 1990 and appointed to the Ontario Court of Appeal in 1998. Since her appointment to the bench, Justice Feldman has participated in and chaired numerous continuing legal education programs for law students, lawyers, and judges in a number of areas, including bankruptcy, arbitration, employment law, and appellate advocacy. In January 2001, she became the first recipient of the Canadian Superior Court Judges Association President's Award. In 2015, she was one of 50 women featured in the book Leading the Way, Canadian Women in the Law. And in 2016, she was named by University College as an alumna of influence. She is currently still a judge on the Ontario Court of Appeal, which will somewhat limit what she is able to say today. And she is the director of the Canadian chapter of the International Women Judges Association. I should also mention, of course, that she's an alumna of our Faculty of Law here, where a while ago, she was co-editor of the Faculty of Law Review and received the Dean's Key. And then ever since then, she has been extraordinarily generous in giving back to the Faculty of Law and the university at large with her time and expertise, and is a recipient of a University of Toronto Arbor Award. Justice Lynn Smith is currently an honorary professor at the Allard School of Law at UBC, where she teaches a seminar on charter litigation. She was appointed to the Supreme Court of British Columbia in 1998 after teaching for many years at UBC in the areas of evidence law, the charter, and human rights, and serving as dean of the law faculty from 1991 to 97. She served as a justice of the Superior Court of British Columbia until her retirement in September 2012. At various times, she has served on the boards of the BC Civil Liberties Association, LEAF, and the West Coast LEAF, of which she was a founding director and a founding chair, respectively, the Vancouver Community Legal Assistance Society, the Law Foundation of British Columbia for a term as its chair, the Vancouver Foundation, the BC Women's Hospital and Health Center as a chair, I'm getting dizzy, and Science World. In 2005 to 6, Justice Smith was executive director of the National Judicial Institute on secondment from the court. In December 2020, she was appointed an officer of the Order of Canada. She's well known to many of us for having written the deep and probing trial judgment in the case of Carter and Canada, the constitutional challenge to the prohibition against medical assistance in dying. And I should specifically mention that unlike the Supreme Court, who declined to rule on the Section 15 issue in that case, Justice Smith offered a very probing and in my mind, wonderfully illuminating Section 15 analysis, arguing that prohibitions on assisted suicide perpetuate and worsen the disadvantage suffered by those with physical disabilities, and that these prohibitions were not justified under Section 9. And last but never least, Professor Cheryl Milne is executive director of the Asper Center. She has represented the Asper Center in a number of interventions in cases which focused on Section 15, including Coco Panace, AG&G, and most recently, the pending decision in Safe Third Country Agreement appeal. She has also intervened with submissions on elements of constitutional litigation, including the role of interveners in Barton and public interest standing in AGBC and the Council of Canadians with Disabilities. Prior to coming to the Asper Center, Cheryl was a legal advocate for children with the legal clinic Justice for Children and Youth, where she led the clinic's charter litigation. And in 2018, she received the Law Society Medal from the Law Society of Ontario for her many contributions to the profession through her child rights advocacy and legal education. So Justices Smith and Feldman and Professor Milne, we're very honored to have you here today, and we really look forward to this discussion. Justice Feldman, I will hand things over to you.
Thank you so much, Professor Moreau. It's a pleasure to be here, and looking forward to these moderating duties. So I'm going to start off with my first question to Justice Smith. I just want to set the stage with reference to two quotes from the Supreme Court of Canada decision in Sharma. So at paragraph 204, which is the dissenting decision, Justice Karakatsanis says, the framework for the analysis of Section 15 is settled law. While changing in form over time, the current iteration has been affirmed 5 times in the last 4 years. The roots of that framework extend much deeper in the case law. Then, go back to paragraph 34, the majority. Clarification of Section 15 is necessary. This court has described Section 15.1 as the Charter's most conceptually difficult provision. The development of its analytical framework is daunting, and it has gone through multiple formulations since 1989. Academics have criticized the current framework from various perspectives, the common thread being that it is unclear and thus leads to inconsistent application. So right in Sharma, 2 views of where Section 15 jurisprudence stood at that time. Coming out of Sharma, 2 views more entrenched. So it does seem as though it has been difficult to reach stability with Section 15 analysis. After all this time, are you optimistic about getting to stability anymore?
Well, thank you very much for that question, and thank you to the organizers for inviting me to take part in this. I've been sitting in on the symposium all day from 6 a.m. my time, and I must say I've learned a great deal, including at early hours, but some wonderful speakers. If you'll allow me, I'd like to take a very long view back to 1977 in order to answer the question eventually whether I feel optimistic or not about Section 15. So if one looks way back to 1977, pre-charter, that was the year that the Community Legal Assistance Society co-counsel Alan MacDonald and I argued the Bliss case in the Federal Court of Appeal. And we then argued it again in the Supreme Court of Canada in 1978, so unsuccessfully, but partly due, I have to say, to the absence of the only 2 Supreme Court of Canada judges who'd shown interest in Section 1B of the Canadian Bill of Rights. In any event, taking that very long view, we can discern 4 trajectories in Section 15 and equality over 4.5 decades. 1, there's been a huge growth in legislative and constitutional protections. For example, there's the Charter. There's human rights legislation that didn't exist in the form that it did then. It's much stronger now. Secondly, as has been referred to considerably, jurisprudence under Section 15 has evolved and ebbed and flowed. And I have to say that when we on the Leaf Case Committee for Andrews drafted our argument in Andrews that was so ably argued by Mary Eberts in the Supreme Court, we were conscious of the importance of getting off on the right foot. And we were conscious of the need to persuade the court that it should take inspiration from the Canadian human rights jurisprudence and not from the US Equal Protection Clause or from the Canadian Bill of Rights cases. And at the time, it felt as if we had pretty much succeeded. Despite, and I'll just add this, as Mary Everts will remember, the Law Society of British Columbia trying hard to push Canadian Bill of Rights cases as worthy models to follow. So when Andrews came down in 1989, and shortly afterwards Brooks did, overturning Bliss, the shift seemed so definitive and final and transformative. But as we all know, since then, we've seen at least 5 more different attempts at definitive tests and approaches, and now we're where we are now, as Jennifer Koshin has well described. So that was trajectory 2. Trajectory 3, in terms of outcomes and results, I think it's fair to say that from the perspectives of equality-seeking groups, it's been overall mixed to disappointing. But finally, and this is the 4th trajectory, I think there's been a significant impact of Section 15 flowing not from direct application of Section 15, but from the charter value of equality that it trails behind itself. The most recent example was just this month in Neufeld and Hansman, where the value of expression was weighted at the very highest level because the expression was aimed at supporting equality of LGBTQ2S people. Remember also the TWU litigation. There are many, many examples. So that is my version of kind of the overall picture. It has been an arduous journey, and why has it been so difficult? If I may, I'd like to go on and just list off some of the reasons, and then I'll subside. First of all, there are conceptual challenges. Equality is new-ish. It's a 20th century right. It doesn't have the venerable patina that comes with rights like freedom of expression. It's novel. Secondly, various Greek terms are used to convey the idea that it's hard to pin down. So it's been called protean or shape-shifting. It's been called chimerical. In other words, it can seem illusionary or fantastically visionary. And another way of saying that, I think, is that it's so highly contextual that inevitably it's highly contested for all of the reasons that have been suggested today. Those were the conceptual challenges. Consequential challenges. Well, there's so many different kinds of cases that can be brought under Section 15. They can involve huge social benefit programs and potentially a great deal of money. They can involve criminal sentencing practices, driver's license requirements, division of family property laws, and so on. Many equality cases affect enormous swaths of the population, although some don't. Thirdly, jurisprudential challenges, and this is really a shopping list of things I'd like to say. First of all, and several speakers have adverted to this today, so many different kinds of analysis are necessary. Analysis of explicit distinctions, like the ones in law in Canada, of disproportionate impact revealed by statistical evidence, like Sharma, adverse impact by necessary implication and a failure to accommodate, Carter and Eldridge, not to mention the little used Section 1 analysis following a Section 15 prima facie infringement. Next, and this is something I've wanted to say for some time, I think that the enthusiasm for substantive equality led to a mistaken and unnecessary wholesale dismissal of formal equality. I happen to think that we need both. The trick is to figure out when equality consists in treating people the same and when it requires treating people differently. And that's where an understanding of substantive equality becomes necessary. Of course, there's the well-known difficulty in defining substantive equality. I happen to think that it's a term that was coined to capture several related ideas that are all pretty coherent. But the core element is that substantive equality looks beyond the words and below the surface, including at whether there are persistent systemic disadvantages or at whether identical treatment is going to produce serious inequality. Next point, I think that the Supreme Court of Canada's early threshold decision, the one that we argued for in Andrews, to take human rights analysis as a model rather than the Equal Protection Clause or the Canadian Bill of Rights, I think that was the right decision, but it may have led to overlooking salient distinctions between charter equality and human rights cases. And maybe these distinctions need to be further explored. A very important factor, and a number of people have referred to it, but I don't apologize for referring to it one more time, has been the unfortunate custom on the part of the Supreme Court of Canada, I say this with the greatest of respect, obviously, the custom of leaving dead branches on the jurisprudential tree, moribund branches, cases like Otten and Gosselin and others, that just sit there and invite cherry picking and confusion on the part of counsel who have to try to figure out what they need to do to prove an equality case. And this reluctance to clearly overrule previous cases, I think is a very significant factor. And it means that to use language that's sometimes used about difficult women, Section 15 has acquired a reputation for being difficult to work with. And so people stay away from it. And finally, I think that as it happens, Section 7 has proved able to carry more of the load than was initially imagined. For example, in the context of the former absolute criminal code prohibition against assistance in suicide, there was a very close similarity in Rodriguez between the Section 7 analysis by two judges who found the legislation arbitrary and the Section 15 analysis by Chief Justice Lemaire, who found it discriminatory. And I don't need to say that over and over again, we have seen instances of courts choosing to go with a Section 15 and Section 7 analysis over a Section 15 one. There may be even more room for Section 7 to fill its sails, given the recent Ontario Court of Appeal decision in LaRue, and with arguments that are being brought forward that substantive equality should be recognized as a principle of fundamental justice. And I will close by noting that, yes, it's true, as several people have noted today, that systemic equality analysis, essential under Section 15, requires some understanding of the realities of systemic discrimination. And those realities may not have been part of the experience of some judges. They're more difficult than some other sorts of analysis that judges have to do. So that's my list of why some of the reasons why I think it has been so difficult over so much time, and why I have become more of a pessimist than I was, say, 5 years ago. It may be that it's going to take even more time to reach a stable and definitive Section 15 analytical framework.
That could be a whole paper, a whole book. Just, so much to chew on there. You know, Professor Milne, do you mind if I call on you? I'll pick out just one thing, but you can comment if you want on any of those observations. What do you think of the idea of reaching back and seeing whether formal equality is worth pursuing?
I think we've done that, like, to some extent. Like, I think that that's the easy, that's the low-hanging fruit. That was sort of some of those initial cases, and even with the same-sex marriage and Vreemed cases, that's what we saw to some extent. I mean, I guess what I pick out from what Justice Smith has said is that I think that the consequential challenges are what I think drives to some extent this the difficulties, because I think the kinds of cases that will really make an impact and what we really need to wrestle with are the ones that have big consequences. And so that there are financial consequences, and there are huge consequences within our criminal justice system. They are things we must wrestle with and things we must do, but I think it spooks the court to some extent to think that they would wade in and make this kind of change. And I think Faraday was talking about it earlier today about how we need to. I mean, I don't think in her talk she mentioned it. It was sort of an aside comment about blowing the thing. We need to blow it all up. I think that's the sort of language that people around climate justice are saying right now in terms of how we approach that. That issue is that our whole system is somehow sort of indicated as part of the problem. And so when we do have challenges that the kind of challenges that involve pay equity across a broad swath of professions and occupations, that the courts are reluctant because of the big financial consequences. And clearly Sharma just locked into that whole fear of, well, what do we do with a criminal justice system that is fundamentally unfair and unequal? And governments should do that, not us courts, except that courts are very much in the business of throwing people in jail. That is part of what, and so they are implicated in those decisions, but want to take a step back and say, no, that's the legislation. And then the last thing is that I really like your point, Justice Smith, about these moribund cases, because that also fits into what Margot Young was saying earlier today about the sort of zombie concepts, because they're kind of in there and they're embedded in some of these moribund cases that, we have zombie cases and zombie concepts that keep rearing their head, and we can't get rid of them because the court is reluctant to clearly overrule past cases that were wrongly decided.
So I'm going to change gears a bit. I'd like to follow up a bit. I think it was Mr. Barkawi who was talking about the huge benefit of having a real trial as opposed to an application. And so I'm going to go back to you, Justice Smith, about just the role of the trial judge and the record, and whether you want to weigh in at all on his perception that seeing the witnesses in this type of case is very important.
I could not agree with him more. I think that it is highly significant that trial judges hear witnesses live if possible, or at least have an opportunity to hear experts under cross-examination rather than proceeding solely on the basis of a paper record. My own experience as a trial judge was that it made a great deal of difference. I wish to say something about the experience of trial judges in building a record under the charter, if I may. One is that there's been quite a significant heightening of the expectation of trial judges through what the Supreme Court of Canada said in Bedford back in, was it 2013, when it said, a fact is a fact is a fact, and a finding of legislative or social fact is the same as a finding of adjudicative fact, and it can be set aside by a court of appeal only if the court of appeal finds palpable and overriding error. That was quite a significant shift, and it means that trial judges have a very significant obligation to try to get it right the first time. At the same time, there's been a ratcheting up of, as we've heard from people like Benjamin Perriman today, of the requirements for evidence in charter cases. And so social science evidence, all kinds of evidence comes in, and trial judges are required to get it right. What they don't get right can only be overturned if a fairly significant onus is met. At the same time, and this sounds like a plea for, oh, the poor trial judge, but I do want to say that it has been the experience over the past decade or two, at least in larger jurisdictions, that the workload on trial judges is ever increasing. And as we all read in the Globe and Mail this morning, there's a huge shortage of judges on a number of courts. So that although in the ideal world, judges would be able to spend the time that's needed to review records, parse the evidence, do it all so carefully and get it all right, and that they would review every single charter argument as, you know, as, for example, as the trial judge me did in Carter, often it is simply beyond what's possible for judges sitting on the trial court who don't have all the time in the world. It's a real dilemma. So I think that the burden on trial judges has increased, and the workload issues have increased at the same time. Those are two realities that have to be taken into account. And I agree completely that in the ideal world, all of the charter arguments would be carefully reviewed. The facts would be found in order to make a decision about them, and the decisions would be made in every case. I think it's understandable sometimes that trial judges feel they just can't do that.
Did you ever have a charter case in the form of an application?
Yes, I did. I did. Yeah, I had, it was an election rights case. But actually, some of the experts were cross-examined live, which makes a difference. You know, a lot of charter cases are going to be about that, aren't they? Cross-examination of experts rather than adjudicative fact witnesses, because what actually happened is often not quite as significant as what we all make of it afterwards, and that's where we call in the evidence, or the experts, excuse me.
Professor Milne, do you want to make any comment on this, either from the intervener point of view or just generally?
I certainly would love to comment on this from the sort of litigator point of view, because I used to say that part of the problem was we have these huge sort of voluminous records that are, to some extent, unfair to trial judges, that there's a lot of evidence put in that's not necessarily relevant, or it's hard to determine what its relevance is, and that trial judges are not at a disadvantage of trying to sort out between, especially in these written records. In Ontario, the general practice is application, it's not action. However, now we have this decision from Sharma that basically says, well, we don't want those government reports put in. Everything needs to come in at this trial level. We can't even take judicial notice of things we took judicial notice of years ago. And it basically says, well, how can we be that gatekeeper as the council when, and it goes back to, I think what Ben Perryman was saying is that you have to kind of future-proof the record. So now there's just an incentive to throw even more in, which I don't think is very helpful. It's also, an action is extremely expensive and time-consuming. And so part of the reason we do applications is because it is economical and is faster. And it takes up way less judicial time. So you have a week of at most of argument as opposed to months of hearing evidence. Now that doesn't mean you're not spending months going through it, but it's not quite the same thing, because you're both hearing the evidence orally and then you're going through the written stuff as well. So it's just, exponentially much more time and effort to do an action. And I agree. I think sometimes that you're going to get better decisions certainly on some issues if you hear from the witnesses directly. I've had direct experience with cases that the end result was kind of bizarre, because there was no real proper assessment of the real credibility of the experts, because I saw them, I cross-examined them, I know how I would have found them to be in terms of credibility, but the judge didn't have that same perspective, and so just basically said, well, they're all okay. So that's part of the problem of saying, well, we should have more actions. I agree, that's the ideal. I just don't know how claimants can afford to do it. Yes, there's the court challenges program. it does not provide enough money. It helps, but it's certainly for many lawyers that are taking cases on through and being funded through the Court Challenges program, they're still putting in a lot of pro bono time and effort. The witnesses, often the experts, are putting in their time pro bono. So so when you're getting the experts who are academics, who are doing their research, they're often not charging for their time, so that the system actually relies on a lot of people just giving of their time. And sometimes that's seen as negative. Somehow they have an axe to grind, or they're an advocate. Well,
you get what you pay for.
That's right. Otherwise, they'd be paid. So it's a difficult one, but I do think that, and then we go back to that other issue that has come up again and again today about the data collection issues. So if the court is now wanting quantitative data, which it only wants for Section 15, they allow for Section 7 all of this qualitative stuff, including reasoned hypotheticals that aren't even real evidence, they're just stories. But Section 15 doesn't allow us to tell stories the same way that other sections of the charter do. And I'm not really sure ideologically why, other than there is this barrier that the evidence now, the evidence is just one more, or it's a hurdle, it's always been there, but it's just been raised up a little higher. So it's a little higher jump now. And it's not fair to trial judges, and it's not necessarily fair to counsel either.
May I make one comment, Justice Phil?
Sure.
Well, actually, it's two. I'm going to smuggle in two. The first one is in British Columbia, at least, it's not all or nothing. You don't have to have either a full out action or just an application. In a number of cases, there have been hybrid proceedings in which key witnesses will appear and be cross-examined, and others are simply asked to give evidence by way of affidavit. And it's quite an efficient process. Yes.
Can I just ask you, is that done through a case management meeting and agreement, or agreement among counsel, or is that provided for actually in the rules of civil procedure?
It's generally been done through a case management order with agreement of counsel, but I believe it could actually be ordered. And I don't know whether it has been in concrete cases. It is the way that we did the hearing in Carter. And it's also the way that hearings have been done in other fairly large charter cases. So this hybrid model, it's efficient, but the judge still is able to hear the key witnesses and hear the cross-examination. The second thing that I wanted to mention is that the problem in my mind with simply putting a whole lot of material in front of trial judges and letting them go away and sort it all out, and Cheryl, Professor Milne, just adverted to this, is that judges may not have the expertise or the inclination or the time to get it right. It wasn't that long ago that even the Supreme Court of Canada had its Askoff debacle, where the Supreme Court of Canada managed to misconstrue statistical evidence regarding length of time before trial, and had to correct itself 2 or 3 times because of, it's not something that most judges know how to do, is deal with social science and statistical evidence. So there's a risk there. I just mention that because I know that Ben Perryman has thought about it. I heard him at a conference on that, not maybe 5 or 7 years ago. So it's a challenging situation. And I fully understand at least I think I do, the constraints on counsel and putting cases forward. We have to try to find a way around it. And I'm tempted to endorse at least part of what's been said today, which is that maybe we should look really hard at the possibility of backing off from the requirement that all evidence has to go in through experts. It's what the Supreme Court of Canada said in Spence, that judicial notice case, quite a while ago now. It's had a huge ripple effect in many areas of the law, including this one. Maybe we need to back off and look at what's done in other countries with in the South African Constitutional Court and and the Brandeis briefs in the US, recognizing the risks in that you're then letting judges off on their own try to interpret the evidence. So maybe you build in safeguards to help judges, but at the same time, you don't require every single piece of evidence to be proved with the full rigor of an expert witness.
Well, also, the suggestion was made earlier that the way to go is through a class action.
Mm-hmm.
It has, a number of financial advantages that make it a viable way to proceed and overcome some of the issues that have been raised here. So that would be something that's obviously being done and something to be thought of possibly for future cases.
Mm-hmm.
On the class actions issue, I think that there are a couple of things to keep in mind. I mean, I think it was Ben Perryman that mentioned, we're referencing you a lot, Ben, but because we're talking about the evidentiary issues, but he also mentioned how some of these cases settle, and actually class actions are one of those groupings of cases that settle more often than others, because often there are huge financial consequences, so that there's an incentive to settle and sort of keep those, to be able to quantify and keep a limit on what can be ordered, and they can go on for a long period of time. And sometimes with class actions, the legal the challenge, like the challenge to the law, or the challenge to sort of the legal issue itself, as opposed to the damages and the financial consequences, can get lost. So that, especially if there's a settlement. So that's something that that's just a note of caution about, well, class actions aren't always the answer, but they can be. I mean, they have that. That have that possibility, but I think we can't see that as the answer to all these questions, because if it's straight, we want to strike, they're seeking to strike down a law or government policy that may not have necessarily financial consequences, then the class action may not be the route to go.
So can I just follow this up with one more question with respect to interveners and the record? And my recollection, and you can correct me if I'm wrong, at least from Bedford and Sharma, was that interveners did provide part of the record in both those cases. And after McGregor, is there now a hard change there, or am I misremembering that?
So in Sharma, there were the Aboriginal Legal Services actually at the trial level actually entered in a lot of evidence. So some of that statistical evidence that was available, whatever was available, was what they put in. But they were granted that ability to do so at that early stage.
Do you think that's affected now by McGregor? The ability to even do that?
No, I think McGregor wasn't really critical of the evidentiary piece. Sharma, the Supreme Court was critical in Sharma about adding in evidence, but quite frankly, I and Adriel and Jessica did a really a passionate defense of what we did in that case. And I say we because it was the Court of Appeal and it was Asper and Leaf together. We were just referencing royal commissions and the murdered and missing women, Indigenous women and children report. So it wasn't anything controversial. It was just additional sort of gloss of things that I think you had every right to take judicial notice of. It was just helping build the context. But that's kind of separate. McGregor is about whether you're raising new issues. And again, Asper Center was there. We got criticized. So I don't want to be defensive of it, but part of it was they let us in on the we were interveners, especially at the Supreme Court of Canada, make it really clear this is what we intend to argue. There was a fairly good a motion record that went in that was it wasn't as long as a 10-page factum, but it was at least 5 pages of this is what we intend to argue. So there was no surprise there. So for them to then later say, well, you've raised new issues when no one objected to that, was a bit
But
surprising.
you are being defensive respectfully, because is the court not entitled to, on further reflection and having had the whole thing presented, say, you know what, actually, we don't really like this, whether it was your fault or the court's fault for letting you in?
Yeah, I mean, they let us in. So they could say, well, thank you very much, but in retrospect, it wasn't helpful. That's the end of it. But instead, they've at least there's a criticism of what we tried to do. I also actually think that the dissent really did like what we had to say. And that was about the revisiting of HAPE. And the issue was clearly, how does HAPE apply to the case? And part of our argument was that HAPE, there are problems with HAPE. So does it apply? Yes, but there's a problem with how you apply it. So there was more nuance to it than just we raised a new issue. But I think Sharma, the majority in Sharma, are more critical of putting in evidence. But again, it was by way of this is what was in the Royal Commission report. This is what we know. This is updated statistics about incarceration rates and Stats Canada material. I just don't think it was. In any other case, they could have, their clerks could have found it and put it into the judgment, quite frankly. But, you know, I don't want to belabor it, but because it sounds defensive, but it does leave interveners going, what do we do now? And parties too. I think that some of that was, you know, if there's additional information about numbers that wasn't available at the lower court level, well, why can't they bring that to the court's attention? Because it's relevant and not controversial. It's Statistics Canada, it's government information. The government has access to that information. If they don't like it, they could object to it and say, but they have to own it to some extent.
All right, I'm going to turn to something else. So Justice Smith, in BC, there's recent case law that is turning to Section 25 of the Charter. What's your view on looking at other sections beyond Section 15?
Yes, well, I thought that this audience might be interested in just knowing that a case has been argued in the Supreme Court of Canada where a number of fundamental points were at issue. And I know about the case in a little bit of detail because my daughter was part of the team that argued it. So, but it's a case brought by a Yukon Territory First Nation called the Vuntut Gwitchin First Nation. And it has to do with the challenge to a residency requirement that the Vuntut Gwitchin First Nation has put into its own constitution, requiring people who want to serve on council to live in the traditional territory. And in this case, it's Old Crow. Old Crow is a very remote community. It's the fly-in, fly-out community. It's as far from Whitehorse as Whitehorse is from Vancouver, to give you some idea about the remoteness. Anyway, so the First Nation put this residency requirement in. It's been challenged under Section 15. Because an individual who wishes to serve on council does not wish to move to Old Crow. And she has a reason, which is a very credible reason. Her son needs medical help that's not available there. So the Yukon
she's otherwise, Justice Smith, she's otherwise qualified, correct?
Oh, yes, she's a member of the First Nation, yeah, and is otherwise qualified. So the case went to the Yukon Territory Supreme Court. And it was argued initially. First issue was, does the charter even apply? And it's very interesting that for the first time, as far as I know, that issue is going to be squarely before the court. Does the charter apply to a self-government agreement? Because the Vuntut Gwitchin negotiated a self-government agreement under the Yukon Territory umbrella agreement. Secondly, if this residency requirement is subject to the charter, then does it even get to the Section 15 stage, or does Section 25 preclude that? the section 25, which refers to Aboriginal rights. And then the third argument is, well, if it does get to section 15, is this really a case where there's an infringement, given that the analogous ground that's alleged, Aboriginality/residence, is a ground that was developed under the Indian Act, the Aboriginality residence analogous ground recognition came in the context of a case involving a band member who lived off reserve. So the Vantakwichan have never had a reserve and have never been a band. Anyway, it's such an interesting case. That's what I wanted to say. And section 25 will be at the forefront, and both the Yukon Territory Supreme Court and the Yukon Territory Court of Appeal found that section 25 saved the provision from being struck down under section 15. I think that if you want, I could go on to say something more about why in general we might want to think about some early decisions under the charter about analogous grounds and start considering revisiting them, but I'll save that.
Why don't we segue into that right now? Go ahead.
Okay, well, this is an example of an early decision. Corbière, I can't remember what year it was, but it was a long time ago. And it decided in the context of the facts that were thrown up in that case that Aboriginality/residence should be recognized as an analogous ground. As somebody mentioned earlier, I guess it was Jennifer Koshin, indigeneity has never been recognized as an analogous ground per se. And more importantly, in the context of the Vantakwichan case, residence has never been recognized as an analogous ground. So you can't challenge the Yukon Territory's residence requirement for voting in their elections, or the municipality of Etobicoke's requirements for voting in its elections, but because of this rubric of Aboriginality/residence, you can challenge this residence requirement. So what the Vantakwichan argued in the case is that to single out their residence requirement and strike it down is exactly the opposite of what should be happening under reconciliation and recognition of Indigenous self-government. So the Supreme Court is going to have its work cut out for it. In general, I think that this is one example of a recognition of an analogous ground, but there may be others that need to be rethought or revisited. It may be that there are other early decisions under the charter, somehow, but in general principle, I've always been a bit puzzled why recognition as an analogous ground should be irrevocable for all time. Doesn't that mean we're being awfully pessimistic about the possibility of social change? And doesn't it mean that courts are, and I think this is true, courts are very reluctant to recognize new grounds because they'll be irrevocable. So if we didn't have the irrevocability part and a little bit more flexibility about analogous grounds, there might be more room for the charter to have an impact. That I just throw those things out.
I see our time is marching on, so I'm going to ask you one more question that I want to make sure we get in, and that's about the Canby Surgeries case, which I read with interest because you wanted to talk about it in terms of how it might reflect a regional difference in approach.
Well, it was a case in which there was a challenge to privately delivered healthcare. It was a mega trial. It was 400 days or something. It was really a huge, massive undertaking. And the rules of evidence were scrupulously and firmly applied, which meant an enormous record was built up. The trial judge upheld the current legislation, the Medicare Protection Act. The Court of Appeal upheld him, and then the Supreme Court of Canada denied leave to appeal. So which was a very interesting decision. Nobody saw that coming, I have to say. I don't know if it's a regional difference. To me, it is a high watermark of a trial judge doing what the rules seem to say you should do as a trial judge, and that is insist on proper proof of everything. And it shows what the consequences are in that it was an enormous trial and an enormous record and extraordinarily expensive. Supporting the proposition, sorry.
Part of the big challenge was to the factual findings, and the Court of Appeal wrote extensively on why they upheld those factual findings.
Yeah, that's right. That's right. It's a really interesting example of a decision that will probably stand for a long time, because nobody can possibly imagine mustering another case in which this sort of issue is raised since Chauli, which, as we all know, was a very closely decided case. This is the first case to come forward, and that's either a good thing or a bad thing, but it again also illustrates the importance of trial judgments in terms of building a record, and that record being final. The Court of Appeal referred over and over again to the failure to meet the palpable and overriding error test.
The other thing that I thought was unique, or at least unusual about this case, was the Section 1 justification. That doesn't usually come up.
Yes, one of the concurring judgments did quite a significant Section 1 analysis, Justice Femlin, which was, I think, very interesting.
Yes, and I think it arguably feeds into what Mr. Sangulano was talking about in terms of the justification for the breach, or putting it another way, saying it isn't a breach, but using Section 1 to say, well, if it is a breach, this law has other benefits.
Exactly.
Do you want to comment on that, Professor Milne?
I don't want to, I can't really comment on the substance of the case, but I would say that, you know, if all of our cases are moving in that direction to 400-day trials, that's the court, we would collapse under that. We just can't do it. Or the only people who can do it are the very well-funded litigants, which I think was the case in that there were lots of litigants with funding on both sides. I mean, government on one side, but primarily the challengers, you know, did have a lot of financial backing to mount that case. That's not true of most of Section 15 claimants, and so if that's the high, it's a high watermark in terms of amount of evidence and how it was conducted, but it may be, it shouldn't be the standard, because I just don't think we can manage it.
Permit me to say, I'm now doubting my own memory when I said 400 days, so don't quote me.
It was a long time, though. I know that.
A long trial.
It was a very
long.
It was certainly a significant record. That was
Yeah.
clear. That was clear. So, Professor Milne, are there some intractable equality issues that seem to be too much for the courts to handle that we haven't talked about?
Well, we've certainly, I don't know if we've talked about it right now, but we've certainly talked about them today. And I think, you know, part of it, and I'm just going to name three, because I think that the one is, I mean, it is fundamentally the whole concept of substantive equality that to some extent seems to be intractable. But I think that there is, part of it is that there seems to me to be a bit of a conservative pushback regarding substantive equality, and that's manifested in sort of the sort of rejection of some of the evidence about the overrepresentation of Indigenous peoples in you know, state interventions such as criminal law and child welfare. And Raji Mangat was talking about the child welfare case where they got pushback about accepting that Indigenous children are more overrepresented in the child welfare system. It's something we actually know as a fact. So that was surprising. The second thing is and it's related, is this, I think we have this problem with positive obligations. And that somehow we'd say, well, it's just a negative, charter is just negative rights. We can't put positive obligations on government, but that doesn't make logical sense where equality, one aspect of equality is accommodation of difference, which requires positive action, or at least actions that are different than. And so we just keep bumping up against this, I think, simplistic view of positive versus negative rights, and with a dismissal of things because they're being categorized, I think, superficially as positive rights. And maybe they should be positive rights, but they shouldn't be dismissed, because I think that we're not seeing that Section 15 actually requires them to some extent. And then the third one is sort of my, partly from my background, a nod to the Justice for Children and Youth people in the room, which is that the age-based discrimination is just, it's a section in there. It only seems to mean actually the elderly. It doesn't mean younger people. It's sort of been defined away as being meaningful. And if you look at the CP case, for example, and try and read that in conjunction with KJM, it's incoherent, except for essentially in a result, which is kind of a negative. You don't get, as a young people, you don't get rights. So CP basically saying that the right of appeal that an adult gets does not apply to a young person because it's a separate system and they are supposed to be treated differently and more favorably, but a favorable thing such as a right of appeal is not allowed because that's not going to be good for you. And it's this strange paternalism that's not really, and under the guise of it's in accordance with their capacities and interests. So that's how you get age kind of defined away. Whereas KJM is saying, well, the delay rules that came out in Jordan, they sufficiently accommodate young people too. There's no separate rules for them because we don't need to actually do it differently for them. Like it just, if you read them, they're not coherent. And I think that's just an example. I mean, CP, the reasoning is faulty for a number of reasons, or problematic for a number of reasons. Again, there is a dissenting opinion, but we didn't really talk about that case so much today, but it is in that line of cases of where it's hard to really see what the court is doing in terms of equality rights. But it gets sort of pushed to the side because it's about kids. And I think that's one of the areas. So those are the three that I would suggest are intractable. The first two being monumentally huge. The second one being more of it's an issue. It's a concern, but it's a constituency. And I think, there was an earlier question today from Natalie Chalafour about climate change litigation, and we're seeing that age cohort time issue because being replicated in those decisions as well. And Matur applies Sharma, and so if you look at how Matur applied Sharma, then I think we can see what is happening as a result of the Supreme Court majority decision in Sharma, which is not positive.
Well, is there not some optimism from the LaRue case? Justice Smith mentioned it, but recent decision of the Ontario Court of Appeal that refers to Gosselin and seems to give it, some further hope for revival.
There's always hope. I'd like to see an actual decision that doesn't just say it's a possibility.
Well, it's a possibility. I think that's what the court said, was that it's a possibility. I want to end on an upbeat note.
Good. If you'll forgive me, I actually do have to sign off. I have another Zoom call starting in a couple of minutes. It's been great to take part in this.
Thank you very much. I think we've come to the end of our time in any event, so thank you all very much.
Thank you.
Bye.
Thanks. Cheerio.
Well, thank
Bye-bye.
you all for a wonderfully illuminating day. We're very, very grateful to you, to all of the panelists, to all of you who are here attending who ask questions. And we very much look forward to seeing the final versions of the papers that will appear in our 2 anthologies. So thank you all again. And thank you for working on this project collectively. I feel like a great sense of solidarity in the room that we're all very much trying to work on behalf of marginalized communities to figure out how to raise awareness of social subordination in the context of Section 15 litigation, and how to work around existing barriers. So thank you so much for all of the important work that you are doing and that you will continue to do. Cheryl, did you have anything final that you wanted to add?
Sure, just 2 things. One, for all of our panelists, we'll be sending out something probably next week, just giving you some deadlines for review of your papers so that we can meet our publishing deadline. And we really hope to have a nice volume by the end of the summer, but we'll give you some interim deadlines. And finally, I just want to ask, or I want to thank Tal Schreier, who's been running around making sure that everybody's got everything. I hope there's a big round of applause in the room right now. And also Emma Davies and Daniel Kiesman, who are the 2 Asper Center students who've been behind the scenes and monitoring and taking notes, and will be helping us when we edit the volume as well. So, and thank you to everyone who's really contributed to a really lively and interesting discussion. And have a great weekend.
Thanks, everyone.